in urgent cases like Baby Miracle Cross.
Thank you. Thank you, Madam Speaker. I'm sure I speak for everyone here when we offer condolences to the parents of Baby Miracle Cross. Madam Speaker, I will answer this question in the context that the Children's Life Fund is funded primarily by the taxpayer of Trinidad and Tobago via the Consolidated Fund. Therefore, there must be process and transparency. The current process to spend taxpayers' funds via the Children's Life Fund is as follows. First, an application is made. 2, it is then processed by the Children's Life Fund. You have visa requirements, visa panel, quotations that must go out and request to go out to the different hospitals. A board note is prepared, the board meets, the board considers and approves as necessary, the Ministry of Health and the Minister of Health signs off for action. All cases that come to the Children's Life Fund are indeed urgent. But the very urgent cases, as in this concrete example we have before us, we try to short-circuit the system by foregoing a formal board meeting and seek approval and agreement of the board via an email round robin. In the case of Baby Miracle Cross, 6 hospitals were approached by the Children's Life Fund. Of the 6 hospitals approached, and this was a very complex case, 3 hospitals did not respond to the request to perform the surgery. 1 hospital responded, and that hospital was accepted. 1 hospital declined, and another one declined. The point I'm trying to make is that not every request to a hospital to perform the surgery is automatically met with approval. On this case, 6 were approached and only 1 accepted. It is unfortunate that on the day of approval, using the expedited process of a round robin via email on that very day, it is very unfortunate that this baby died, and we condole with the family. In addition, I have asked the Children's Life Fund to look at more administrative procedures that we could use or not use to expedite the very urgent cases. I thank you, Madam Speaker.
The member for Faisalabad.
To the Minister of Health, having regard to the imminent crisis in relation to the medical staff of the San Fernando General Hospital, could the Minister please state what steps his ministry intends to take to treat with the doctor's overtime concerns?
Again, thank you. Thank you, Madam Speaker, for the opportunity. First of all, the question is not correctly phrased. There is no imminent crisis at the San Fernando General Hospital. There is absolutely no imminent crisis. The doctors are being paid their overtime based on their negotiated contract positions, and this is the information I have of the CEO of the Southwest Regional Health Authority. Thank you very much, Madam Speaker.
The member for Cumuto, Manzanilla.
Thank you, Madam Speaker.
May I ask your indulgence for you to ask the question to Social Development and Family Services until the member reaches to answer your other question?
Sure, thank you. To the Minister of Social Development and Family Services, given the increased incidence of violence against women, can the Minister state what immediate steps are being taken by her ministry to provide assistance and support to victims of domestic violence?
Thank you, Madam Speaker. The Gender Affairs Unit is now under the Office of the Prime Minister. The Gender Affairs Division has developed a national strategic action plan for ending gender-based violence, which addresses domestic abuse and other forms of violence against women and children. This initiative is supported by the Entity for Gender Equality and Empowerment, UN Women. The division is also preparing a national communication strategy for the prevention of violence against women and children, with the support of the Pan American Health Organization, which will speak to continuous public education and sensitization. In addition, a domestic violence central registry, which will harmonize and analyze data across key state and non-state agencies involved in data collection, will be launched by the Gender by the Gender Affairs Division in the very near future. The registry aims to develop profiles of victims and perpetrators with a view to effectively allocating resources and developing targeted programs and projects to eradicate domestic violence.
Member for Cumuto, Manzanilla.
Thank you. Will the minister please advise, I know that you've indicated that you are in the stages of formulating a policy, but what happens at this present time to persons, women who are being violently violated? What does the ministry do? Thank you.
Apart from resources available through the state, we work closely with non-governmental organizations and other civil society organizations to provide services to women and children who are affected by abuse. The resources are available, and of course what we are bringing today through this Honorable House would also address the situation.
Further supplemental. Member for Cumuto, Manzanilla.
Thank you. Just to find out, if a woman has been affected by violence, who does she go to for assistance? Does she come to the ministry, or does she go to these NGOs that you work through? Thank you.
Assistance could be sought through the NGOs or the ministry. First line of contact, they could contact 800-SAVE, which is a hotline for domestic violence victims.
I've seen that the Minister of Rural Development and Local Government has just arrived. Can I invite you to take your seat? And therefore, I now call on the member for Cumuto, Manzanilla.
Thank you, Madam Speaker. To the Minister of Rural Development and Local Government, given the unfortunate recent mauling of a baby, can the Minister provide an update on the procedures being pursued to enforce the proclaimed sections of the Dog Control Act 2013?
Thank you very much, Madam Speaker. Madam Speaker, what transpired a couple of days ago with the mauling of a 6-month-old baby is an extremely unfortunate position. I mean, nothing worse could have happened to that young couple, and I empathize with them, and on behalf of the government of Trinidad and Tobago, we want to send our deepest condolences to that family, and we share in their hurt. But Madam Speaker, the Dog Control Act was proclaimed on the 23rd of May 2014. The Act provided for, inter alia, the control of dogs and to regulate particularly the manner in which certain breeds of dogs are kept by their owner or keeper with respect to it, and it also accounted for the repeal of the Dangerous Dog Act of 2000. The regulations were passed on the 1st of May 2015, and it provided for the registration of Class A dogs. Madam Speaker, even though the situation is unfortunate that had occurred, what happened with regards to that child is not a Class A dog situation. Class A dogs under the Act are categorized as follows: American Pit Bull Terrier, American Staffordshire Terrier, American Bully, Dogo Argentino, Japanese Tosa, and Fila Brasiliano. So technically, all other dogs are considered Class B dogs. The dog that mauled the child, my understanding, is a cross between a Rottweiler and a German Shepherd. And in terms of the strictest sense of the law, that is no different to a Porton in terms of how the law is structured. So in a sense, the unfortunate situation really doesn't fall sense strictly under the dog control bill. But having said that, I will take this opportunity to brief the House as to what is being put in place to implement this act.
Expired.
Okay, well, I did in fact answer the substance of the question. Yeah.
Questions on notice? Questions for oral response?
Member for Princess.
Madam, before
Sorry.
you call on the members, I'd just like to indicate that I'm asking for a 2-week deferral for question number 61 and question number 73. And if I may crave your indulgence, Madam, and indicate that with regard to the written questions, thank you, I'm asking for deferral for question number 65. All the other written answers are available.
Deferral for how long?
2 weeks.
For question number 65, 2 weeks. All questions that are being deferred, I'm asking for 2 weeks. Thank you very much.
With respect to written questions, these questions, the other questions, other than 65, will be answered today? Circulated?
We have the answers to be sorry. We have the answers to be circulated. It's just question number 65 that we're asking for 2 weeks.
Just for my clarity.
The member for Princess Town.
Madam Speaker, through you to the Honourable Minister of Education, could the Minister indicate whether, when? Sorry.
Member, please just direct the question.
Thank you, Madam Speaker. Madam Speaker, the Princestown Presbyterian Primary School number 1 is owned by the Presbyterian Board of Management. This denominational school was closed on June the 8th, 2015 due to infrastructural issues. Members should note that the process for the construction of a new denominational school involves the following: a request being made by the relevant Board of Management, in this case, the Presbyterian Board of Management, for the construction of a new school. Demographic surveys to determine the demand for space and the capacity of the new school building. Consultation with a variety of internal and external stakeholders, inclusive of the Education Facilities Management Company Limited, EFCL, and the Division of Curriculum Development of the Ministry of Education to determine the most appropriate design and other facilities for the new school building and availability of funding for the project. Madam Speaker, consistent with this process, the Ministry of Education is in discussion with the Presbyterian Board of Management with respect to the construction or reconstruction of the Princestown Presbyterian Primary School number 1. The board has advised the ministry that the most urgent priority at this time is the refurbishment of an area of the existing school that is structurally sound. This refurbishment will accommodate 20 classes and will alleviate the problem that currently exists. Madam Speaker, all efforts will be made to have the refurbishment completed in time for the commencement of the new school year in September 2016. Thank you very much.
Member for Princess Town.
Madam Speaker, could the Honourable Minister indicate whether or not he is aware that the member for Moruga Tableland met with members of the board, members of the PTA and myself at his constituency office on November 26, 2015, indicating that he had spoken to the CEO and the permanent secretary at the ministry, indicating that a date for demolition for that school had been identified.
Minister of Education.
Madam Speaker, just let me reiterate. The Ministry of Education has been in consultation with the board which owns the school. We have been having discussions with the chairman of the board on behalf of all those who exist at the Princestown Presbyterian School number 1. And therefore, we can do nothing outside the concurrence of the Board of Management. Thank you.
Member for Princess Town.
Madam Speaker, through you to the Honourable Minister, could the Honourable Minister indicate then whether or not the member from Moruga Tableland indeed misled with respect to the information that he provided?
Member, I would not allow that as a supplementary question, please. Member for Couva North.
Thank you, Madam Speaker. Question number 44 to the Minister of Labour and Small Enterprise Development. Thank you, Madam Speaker. Madam Speaker, the government of Trinidad and Tobago notes with grave concern the recent reported cases of job losses in this country, including through retrenchment, some of which have been attributed to the current state of the nation's economy and the global situation of falling oil and gas prices. As articulated in the official policy framework of this government, the government of Trinidad and Tobago, we hold firm to our belief in the principle of social justice, and the operation of the economic system should result in the material resources of the community being so distributed as to serve the common good, that there should be adequate means of livelihood for all, and that labor should not be exploited or forced economic necessity to operate under inhumane conditions, but that there should be opportunity for advancement on the basis of recognition of merit, ability, and integrity. It is our view that one job loss, Madam Speaker, is one too many. Some of the government's current and proposed initiatives to addressing the recent job losses across all the sectors of the economy would include, Madam Speaker, one, understanding the labor market realities. And if I have time, Madam Speaker, I will come back and I would expand under these broad headings. Two, discussions with employers and trade unions. Three, establishment of a national tripartite mechanism. Four, job placement and advisory services. 5, job creation through entrepreneurship and cooperative development. And 6, nationwide awareness of workplace rights and responsibility. But Madam Speaker, as Minister of Labor and Small Enterprise Development, I have sought to hold discussions with employers and trade unions to discuss layoffs, as was evident in the recent situation of ArcelorMittal Steel Company. Those discussions, Madam Speaker, I want to give the undertaking at a broad-based level. I will continue to keep the communication flows active. Madam Speaker, the team at the Ministry of Labor and Small Enterprise Development and myself have been pondering over this situation, and it is increasing because every day, Madam Speaker, letters cross my desk from employers informing of impending retrenchment. As a consequence, therefore, Madam Speaker, the team at the ministry, which I have the honor to lead, we have developed a 10-point plan to assist retrenched workers, one of which, Madam Speaker, has to do with having a conversation with the financial sector of this country. As a matter of fact, Madam Speaker, I should have met with one of those stakeholders at 1:30, but I had to be here. So as soon as I leave here, Madam Speaker, I'll be meeting with the president and team of the, Madam Speaker, with the president and team of the Credit Union League. Next week, I'll also be meeting with the president of the Bankers Association, also meeting with the International Labour Organization, the United Nations Coordinator, UNDP, bringing all the players together, Madam Speaker, because one of the most important factors that would impinge on retrenched workers' livelihood would be servicing the loans. Madam Speaker, I can't hear myself.
Members. Continue, please, Honorable Minister.
Thank you, Madam Speaker. Madam Speaker, as a matter of fact, one of the most important factors that would impinge on the survivability of a retrenched worker would be servicing loans and mortgages. And it is in that context we are of the view that some degree or a moratorium can be considered by financial institutions because, Madam Speaker, bad times do not last forever. And these retrenched workers, many of them, almost all of them, could be
Expired. Member for Couva North.
Thank you, Madam Speaker. Through you, Madam Speaker, can the Minister give any sort of plan to the House to reabsorb these over 8,000 unemployed persons to other employable sectors?
Minister of Labour.
Madam Speaker, what the member asks is an impossibility. I don't think they on that side were able to do that over the period of time they managed this country. But Madam Speaker, I am quite sure with the 10-point plan and the cooperation of the stakeholders involved, we will be able to match skills of retrenched workers with employers who register at the ministry and seek alternative employment.
Member for Chaguanas East.
Thank you, Madam Speaker. Question 59 to the Honourable Minister of Education.
Minister of Public Utilities. Minister of Education.
Thank you, Madam Speaker. Madam Speaker, the National Maintenance, Training and the Security Company, NMTS, has been providing janitorial, maintenance and security services to primary and secondary schools through the Ministry of Education for over 30 years. These two services have been consistently delivered by employees of the NMTS. At present, 75 of our secondary schools, 17 of our primary schools, and 1 early childhood care and education center are in receipt of janitorial and maintenance services from the NMTS. This service is delivered by way of a complement of approximately 689 janitorial personnel. Schools are classified by the NMTS according to the number of students enrolled and the size of grounds that the school occupies. It is this classification that is then used to assign janitorial staff to schools, and these may comprise building supervisors, maintenance technicians, both 1 and 2, handy persons, and the grounds persons. Secondary schools may have up to 8 persons providing janitorial service, while primary schools may be assigned up to 4 persons. In general, the janitorial personnel assigned to the primary and secondary schools by the NMTS are adequate. This notwithstanding, there have been some developments since the original contracts were signed that have increased the requirements for NMTS janitorial services. These are as follows, Madam Speaker. An increase in extracurricular activities at many of the schools, the construction of additional wings at some schools, and the continued use of portions of old school buildings after the new school buildings have been opened. Madam Speaker, the NMTS is one of 7 firms that currently provide school security services to the Ministry of Education. For its part, the company therefore maintains an active 24 hours by 7 days presence at 314 primary schools, 86 secondary schools, and 29 early childhood care and education centers. The assignment of security officers to schools is based on a risk assessment carried out collaboratively with the Ministry of Education, where schools are classified as highest risk, high risk, medium risk, and low risk after consideration of the school's location, incident history, socio-economic environment, neighboring area, and the area's crime rate. Madam Speaker, secondary schools are therefore assigned between 3 and 8 security officers, while primary schools may be each assigned up to 2 officers. Additionally, in 11 of our secondary schools, canine protection is also provided nightly. Overall, the Ministry of Education is of the view that adequate human resources have been provided by the NMTS. The Ministry of Education also recognizes that there is need to further strengthen the monitoring of the service provided, and it is at present strengthening this element to encourage continuous improvement in the delivery of the service and greater satisfaction on the part of its primary end users, the teachers, and students of our schools. Thank you very much.
The member for Caroni Central.
I didn't realize I had a... Madam, yeah. Madam Speaker, questions number 62 to the Minister of Finance.
Minister of Finance.
Thank you, Madam Speaker. The government is not in support of excessive interest rates for borrowing. In this context, it should be noted that Section 44A1 of the Central Bank Act, Chapter 7902, states that the central bank may fix the maximum and minimum interest rates payable on deposits received and may fix the maximum and minimum interest rates, fees and charges to be charged on loans, advances or other credit facilities by a financial institution. Further, Section 44A2 of the Act states that the central bank, after consultation with the minister, may set the maximum spread between interest rates chargeable on loans and interest rates payable on deposits, which a financial institution may earn, carry, or charge. Accordingly, the Minister of Finance has initiated discussions with the central bank on this issue with a view to ensuring equity, transparency, and fairness in the fixing by the commercial banks of interest rates for both loans and deposits.
Member for Caroni Central.
I commend the Minister of Finance on this.
Member for Caroni Central.
Question 64 to the Minister of Social Development and Family Services.
Thank you, Madam Speaker. Madam Speaker, Cabinet in May 2011 approved the allocation of land at Carlson Field to construct the National Enrichment Center for persons with disabilities. In February 2012, the then Ministry of the People and Social Development entered into a memorandum of understanding with the Community Improvement Services Limited to provide project management services for the construction of the facility. Super Industrial Services was engaged to undertake the construction works, which commenced in October 2012. Despite the center being formally launched in July 2015, the center has not been operationalized due to the following. The facility was not constructed in accordance with the design brief. The bathrooms do not conform to required standards, and those are American with Disability Act. The elevator cannot adequately accommodate a wheelchair. The sewer system is inadequate. The therapeutic pool was not properly constructed. The therapy rooms are inadequate. There was improper installation of the air conditioning system. There is an absence of pumps and water tanks for fire emergencies. SIS. Absence of electrical safety and security installations, the exterior recreation area was not properly constructed, and completion certificates have not been issued as critical approvals remain outstanding from the Ministry of Works and Infrastructure and the Regional Authority. Madam Speaker, as a result, the facility is not OSHA compliant, nor does it conform to international accessibility standards. Madam Speaker, in light of the extensive remedial and other works required to bring this facility to the obligatory standard, I wish to advise that the NEC will be fully operational after design and/or construction defects, which are likely to affect the efficient functioning of the center, have been remedied, and all issues relating to staffing, equipping, outfitting, and operation of the facility have been addressed. Madam Speaker, I thank you.
Member for Caroni Central.
Follow-up question. Does the minister have any idea of the time frame within which this would be done? It is not a wicked question. It is a question it's a question to elicit
Minister,
a context, a time frame.
Member, Minister of Social Development and Family Services.
Madam Speaker, given the extensive remedial works that need to be done, the fact that the building was not constructed based on the design, it is difficult at this point in time to indicate when it can be fully operational.
Member for Caroni Central.
Yes. Honorable Minister, I would just like to indicate that I have no reason to doubt the issues that you have raised in relation to the center. But I visited that particular facility because it stands in my constituency.
Member? Member for Caroni Central. Yes. While I don't want to too much circumscribe you, please ask a question.
Yes. And wouldn't it be in the interest of all to try, especially those people who would most use the facility, to try and expedite this matter, because it is really a quite formidable facility?
Minister for Social Development and Family Services.
Madam Speaker, we agree that this is a facility that is desperately needed in Trinidad and Tobago. However, given that we are treating with persons with disabilities, we would not want to take any chances in operationalizing a facility that does not conform to obligatory standards.
Member for Princess Town.
Madam Speaker, through you to the Honourable Minister of Community Development, Culture and the Arts, question number 66.
The total amount expended by the Ministry of Community Development, Culture and the Arts for Regional Carnival in 2016 was $10,808,823.29. In response to Part B of the question, the amounts received by each Carnival Committee, Regional Carnival Committee, will be provided in a list which will be circulated to the honourable members at this sitting.
Member for Princess Town.
Madam Speaker, through you to the Honourable Minister of Community Development, Culture and the Arts, question number 67.
Minister of Community Development, Culture and Arts.
Thank you, Madam Speaker. Historically, the Ministry has been charged with the responsibility for the development of communities, heritage, and the cultural sector of the country. One mechanism used for achieving this is through the provision of financial assistance to both individuals and non-governmental organizations for projects that contribute to growth and development in these areas. It should be noted that state or government agencies, such as regional corporations and other ministries, do not qualify for assistance by the Ministry of Community Development, Culture and the Arts, and as such are rejected. In addition, full funding for projects is not generally granted, only partial funding. Funding from September 2015 to present was provided to individuals and non-governmental organizations to host a variety of events for the national days and festivals, as well as other cultural projects to date. These are summarized as follows. Diwali, in the amount of $3,773,600. Ramlila, $988,200. Hosei, $100,000. Christmas, $3,962,855. Other cultural events, $725,500. And for Carnival, totaling $12,711,500, divided into prizes for Soca and Chutney Monarch, $6,400,000, general requests including tents, $3,361,500, and sponsored steel bands, $2,950,000.
Madam Speaker, through you to the Honourable Minister. Minister, could you indicate, seeing that you have mentioned the Ramlila Festival, whether or not the government is prepared to honour the commitment of the previous government to continue in the support of the National Ramlila Centre?
Honourable Member, I would not allow that as a supplemental question. Member for Princes Down.
Madam Speaker, through you to the Honourable Minister of Trade and Industry, question number 68.
Minister of Trade and Industry.
Thank you, Madam Speaker. Thank you. To part A of the question, the Ministry of Trade and Industry partially sponsored 2 events. To part B, the events that were partially sponsored are 1, Caribbean Prestige Foundation for the Performing Arts in the sum of $400,000 for the development of the pay-per-view program of the International Soca Monarch 2016, and 2, Southex Event Management Company in the amount of $300,000 to incorporate the traditional category at the Chutney Soca Monarch 2016.
Member for Chaguanas East.
Thank you, Madam Speaker. Question number 74 to the Honourable Minister of Education.
Minister of Education.
Madam Speaker, the Pro Vice-Chancellor and the campus principal of the University of the West Indies, Professor Clement Sankat, has provided an update on the UWI South Campus as follows. 1. Project completion. The University of the West Indies is working towards July 2016 as the project delivery date set by the contractors engaged by the University of the West Indies. And 2, student registration for academic year 2016-2017. The South Campus is a satellite campus of UWI St. Augustine. All students who will be located at this campus will be registered at UWI St. Augustine campus. Once the facilities at the South Campus are completed and ready for occupation, programs will be delivered at UWI South Campus in the new academic year. Thank you.
Member for Chaguanas East.
Thank you, Madam Speaker. Supplemental question. Pursuant to your discussions with the PVC and campus principal, would you be in a position to advise the Honourable House as to what these programs will be that will be commencing in... No.
Honourable Member for Chaguanas. Honourable Member for Chaguanas East. I would not allow that as a supplemental question.
Request for leave to move the adjournment of the House on definite matters of urgent public importance. Statements by ministers.
The Prime Minister.
Thank you very much, Madam Speaker. Madam Speaker, I have the authority of the Cabinet to make the following statement. Madam Speaker, the need to restore the Red House was identified several years ago. Thus, from 1995 to 2015, there have been numerous reports, designs, surveys, and reviews of one type or the other on this very important building. During this period, Madam Speaker, more than $150 million have been spent on this building with very little to show for it. Wow. And after all that time and all that money, construction works are yet to commence, while the number and severity of the roof leaks have been exacerbated and the building's structural, historical, and architectural elements have grossly deteriorated. Madam Speaker, the Red House is an OAS-listed monument of the Greater Caribbean. It is on the National Trust of Trinidad and Tobago's Properties of Interest schedule. No other building is as rich with our history as the Red House. Beneath its fragile flooring was found cultural material that depict our history, from our early beginnings as a people to our recent past, when the building was reconstructed following the water riots of 1903. Above that, Madam Speaker, it yearns to vividly celebrate and portray the rich political heritage of the country and to reflect the importance and dignity of our Parliament as a place of and for the people of Trinidad and Tobago. Madam Speaker, I give you and this Honourable House the assurance that under this government, the Red House will be restored and will provide a permanent adequate home for the Parliament of Trinidad and Tobago. Upon assuming office, Madam Speaker, this government established a historical restoration oversight subcommittee of the Cabinet.
Oh, Shabwana sees.
I accept your apology, but might I warn all members to ensure that their devices are on silent mode, please. Continue, Honourable Prime Minister.
Yes, Madam Speaker. As I was saying, upon assuming office, this government established a historical restoration oversight subcommittee of the Cabinet, which I chair as Prime Minister. This committee sought and obtained a report from the project manager, and that was UDICOT, on the status of works on the Red House restoration project. You see, Madam Speaker, despite the fact that the Parliament is the end user of the Red House, it is ultimately the government of Trinidad and Tobago that has the responsibility of providing suitable accommodation for the legislature. What did we discover? Madam Speaker, 1, the Parliament of Trinidad and Tobago is no closer to returning to its permanent home than it was 5 years ago. 2, the entire roof of the Red House is in need of restoration, notwithstanding the fact that roof works reportedly commenced in 2009, and there was a roofing contractor, quote unquote, permanently on the project for the past 8 years. And furthermore, some $23,257,187, VAT exclusive, have to date been expended on the roof repairs. Thirdly, over the years, Madam Speaker, millions of dollars have also been spent on various designs for the restored Red House, designs that never materialize. We have been informed that the sum of $31,899,860 was expended on the current designs, a sum that includes architectural, structural, mechanical, and engineering designs, as well as historical and restoration surveys. Madam Speaker, this government intends to ensure that this expenditure is not wasted and that the project continues, albeit with modifications given our economic circumstances at this time. Fourthly, bids were invited by public tender for a general contractor for the major restoration and construction works, and UDCOT has advised that tenders considerably exceeded the projected estimated sum. Madam Speaker, we have been informed that tenders range from 411 million to 694 million. This tender process has been abandoned and new bids will be invited. Fifthly, Madam Speaker, the user brief for the Red House restoration project included a proposal for the establishment of a parliamentary complex with the construction of a companion building for parliamentary auxiliary services on the site north of the Red House. This government wishes to advise that this user brief will need to be revised by the Parliament. Given the prevailing economic circumstances, Madam Speaker, a purpose-built companion building is no longer feasible. Madam Speaker, through the relevant committee, the Senate, and the House, we have conveyed the concern that the restored Red House must portray a strong and enduring national symbol, one that will resonate with the citizenry and project to the world an image of Trinidad and Tobago as a modern, dynamic, and developed society. Madam Speaker, we plan to do just that. To sustain and focus our efforts and resources at this critical time, the government has to decide on a number of priorities within a governance framework that will ensure that the errors of the past are not repeated. You will no doubt agree, Madam Speaker, that making sound decisions on how to obtain and use resources is an important aspect of good governance, and that is the goal of this government. Madam Speaker, the Historical Restoration Oversight Subcommittee of the Cabinet has requested UDCOT to review the current designs to facilitate the timely restoration of the Red House for parliamentary operations with required auxiliary services being accommodated in the nearby Cabildo chambers. As part of this review, UDCOT has been asked to consider the option of a grade 2 as opposed to a grade 1 restoration that takes into account the heritage character of the Red House, the age and condition of the building, the essential requirements of the end user, and the protection of the environment. Very shortly, Madam Speaker, the government proposes to bring to the Parliament a request for the re-establishment of a Parliamentary Accommodation Committee for the purpose of consulting with Parliament on necessary revisions of the user brief. On the issue of project schedule, Madam Speaker, UDCOT has advised that the project can be completed by mid-2018 by subdivision of works into work packages. The project manager has informed the Cabinet Subcommittee that such packages can be ready for public tender by July of this year. The subcommittee will maintain its oversight role to ensure that these time schedules are kept. Madam Speaker, UDCOT will be requested to retain dedicated professionals to provide construction management, coordinate the several packages of work. We anticipate that this shift in approach to project implementation by UDCOT will result in significant cost savings that can be passed on to the project. This government intends to maintain a governance framework for guiding the overall rehabilitation of the Red House and other historical buildings. Madam Speaker, we plan to work closely with end users, the Parliament in the case of the Red House, to ensure that decisions taken harmonize with the government's priorities, and that resources are available and can be committed to carry out the approved plans. We therefore propose a robust approach to project management to avoid wasteful spending, inefficient disbursement of funds, and an uncoordinated cash flow regime. Madam Speaker, we feel strongly that the failures of the past efforts are linked to weaknesses in the governance framework, which resulted in delayed decisions and increased project costs and risks. Such gaps in the governance framework cannot be attributed to just one government, Madam Speaker. This is a troubling matter that seems to be an inherent public sector problem, and this government will not perpetuate nor encourage this problem. We believe that unless these gaps are confronted, only limited progress can be made on the rehabilitation of this and other important buildings. We therefore intend to address these weaknesses and to rescue, restore, and conserve our architectural monuments. In this way, we shall keep our heritage intact for the benefit of our future generation. I thank you, Madam Speaker.
Member for Orokuch East.
Madam Speaker, thank you, sir. Pursuant to Standing Order 24-4. In light of the statement of the Honourable Prime Minister, particularly his statement that over $100 million was spent and had nothing to show, in light of that statement, is the Prime Minister then condemning the parliamentary committee that had oversight responsibility for the Red House project that included your current Minister of Finance and your current Attorney General?
Prime Minister.
Madam Speaker, insofar as I condemn the approach to carry out a construction project by an oversight system that has failed and failed expensively and miserably. And if a member of this House has any issue with what I've just outlined, then you have it still.
Go on.
Personal explanations, introduction of bills, on the supplemental order paper, the remedies of creditors, Amendment Bill 2016 in the name of the Minister of Finance. On the second supplemental order paper, the Strategic Services Agency, Amendment Bill 2016 in the name of the Attorney General. Motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills second reading.
The Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Make Jurisdiction for All Family Matters and Children Matters Exercisable in a Division of the High Court to be called the Family and Children Division and to make provision for matters connected therewith be now read a second time. Madam Speaker, I rise on this occasion for the first time as the Attorney General and Minister of Legal Affairs to pilot the first bill that we have brought under my ministry into this Parliament. And I start by that statement in saying that the bill before us is one with some considerable history. Dare I say that under the new standing orders, 45 minutes of speaking time to conduct the work in this particular exercise is a very, very narrow time frame. And I say so because not only does this bill have significant history behind it, but this bill as it stands before this particular House has certain deadline obligations, which I will sensitize the honourable members of the House to, and also conducts a very massive scope of enterprise. Specifically, Madam Speaker, the history of this bill was that in 2001, on the 11th of September 2001, the Family Court Bill 2001 was laid in the Senate. That bill lapsed on the 13th of October 2001 on the dissolution of that Parliament. In 2007, on the 10th of September 2007, the Family Court Bill 2007 was introduced, and that bill was intended to deal with the issues of juvenile matters and lapsed on the 20th of September 2007. On the 5th of May 2009, the Family Court Bill 2009 was laid in the Senate of the 9th Parliament, and that bill unfortunately lapsed on the 8th of January 2010. I put that forward because in the period 2009 to 2015, there was a considerable amount of delay on the occasion of collating the package of children's laws, getting the legislation into proper clothing and form, and then seeking to operationalize those laws. And it wasn't until September 2015 when Cabinet saw release to the Parliament, then Cabinet, on the 25th of May 2015, there was a bill entitled the Family and Children Division Bill 2015. That bill was passed on the 3rd of June 2015 in the Senate, but it unfortunately lapsed on the 17th of June 2015 due to the prorogation of Parliament. The 2015 bill, as this bill now before us has for consideration, was focused upon making the jurisdiction of all family matters and children matters exercisable in one division of the High Court, to be called the Family and Children Division Bill of the High Court. The High Court, the Supreme Court of Judicature, is comprised at the highest level of the Court of Appeal. Then next in level, there are the jurisdictions of the High Court in the civil jurisdiction and the criminal jurisdiction, and then below that is the magistracy, which has both the petty civil and the criminal jurisdiction. This bill seeks to introduce as an entirely new division, a division which ranks right alongside the civil jurisdiction and the criminal jurisdiction of the High Court, now to be called the Family and Children's Division of the High Court, a third separate and distinct division. But very importantly, in terms of its architecture, it seeks to merge in a very important way the jurisdictions of the magistracy and the High Court. Because, Madam Speaker, the position at law is, until this bill is accepted, if it is to be accepted, that the jurisdiction in the magistrate's court could only be exercised in respect of certain maintenance orders, and those aspects could not flow through to the High Court. So we had a rather unfortunate situation of trying to marry the efficacy of single matters in single areas, be they children or families, where we had to go to multiple courts. This work now before us, the crystallization of this work, is born upon the back of a very noble project which was undertaken by the judiciary of Trinidad and Tobago, which saw the piloting of a family court project. And I wish to commend for all, Madam Speaker, the preamble of this bill. The preamble of this bill really sets out in proper fashion exactly how much work, information, and positioning was done by way of analysis to come up with this kind of law. I wish to say, Madam Speaker, that in having this bill debated, the first thing that we did upon coming into the cabinet and then comprising our ministries was to take avail of all of the policy concerns before us. And the LRC has been very hard at work, particularly upon the expertise of a very phenomenal team of ladies and gentlemen that have worked literally, I would say conservatively, for hundreds of hours in umpteen meetings on a constant basis to deal with this. The bill that came in May 2015 was a bill which was similar in core context to the one that we're now dealing with, except there were four essential differences, if I put them in terms of categorization, that we now have before us. In the bill before us, we are now adding in administrative structure of the Family and Children Division Bill in subdivisions and units in a more clear and precise fashion, dealing with interrelationship. We are now dealing with the procedures with respect to pair resolution and how the court may refer eligible candidates to that particular category of services. We're dealing with the procedures for children drug treatment court process, and there is provision for children probation officers. What that resulted in, Madam Speaker, was a move away from 62 clauses in the last bill, 2015 bill, 4 schedules, a move now instead to 63 clauses and 5 schedules. But what we did, Madam Speaker, very, very, very importantly, in beefing out the very significant reforms, specifically as it relates to pair resolution, children drug treatment court, the appeals and transfers, and the positions that operate in terms of the miscellaneous positions, we took the opportunity to in fact amend 18 pieces of law at the same time. And the 18 pieces of law, which are consequential amendments set out in Schedule 5 to this bill, are as follows. The Supreme Court of Judicature Act, Chapter 401, the Bail Amendment Act, Chapter 460, the Summary Courts Act, Chapter 420, the Administration of Justice Deoxyribonucleic Acid Act, Chapter 534, Legal Aid and Advice Act, Chapter 707, Probation of Offenders Act, Chapter 1351, Indictable Offences Preliminary Inquiry Act, Chapter 1201, Prisons Act, Young Offenders Detention Act, Police Service Act, Matrimonial Proceedings and Property Act, Adoption of Children Act, Status of Children Act, Family and Proceedings Act, Children Authority, Children Community Residences Foster Care Nurseries Act, Children Act number 12 of 2020, the Indictable Offences Committal Proceedings Act number 14 of 2014. And Madam Speaker, I wish to stress the amount of work done there, because in the previous bill that was before us in 2015, and I do this by way of comparison to assist those opposite who participated in that work, in the schedule, the 4th schedule, which dealt with consequential amendments, we actually only amended then 3 pieces of law, which were the Supreme Court of Judicature Act, the Probation Act, and the Children's Act. Now, what does that mean? It means that in the clauses that we are identifying for consideration today, we're not only going into the particulars of the new divisions and the administration and the new and very novel and robust techniques to deal with the issue of child offenders and family matters, but we are in one move taking care of 18 important pieces of law that inter-articulate with this particular piece of legislation in a very robust fashion. Madam Speaker, it was open to the government to disaggregate all 18 pieces of law and deal with them bill by bill by bill. But that would have made a mockery of the process of harmonization. That would not have allowed us to engage as we have in our first 6 months of work with making sure that we harmonize not only the process of legislative making and drafting, but also the operationalization. Because, Madam Speaker, the approach that this government has taken has been one to insist upon efficiency of the operationalization of laws, so that we don't just have laws on the books of Trinidad and Tobago, but that we have laws that make sense when they are operationalized. This work, Madam Speaker, is representative of a very new approach to legislation. A very new approach which will meet with the publication of an express legislative agenda in a matter, if I'm able to do it within 1 week, but certainly before the month of April. But Madam Speaker, in contemplating the very robust fashion that we are dealing with now, it's important to note that we have paid very close attention, and my learned colleagues on this bench will speak to the operationalization that we have engaged in. And specifically, I wish to point out the role of the Attorney General and Minister of Legal Affairs has significant obligations for operationalization. There is significant input from the Ministry of Education, there's significant input from the Ministry of Social Development and Family Services, and significant input from the Ministry of National Security. And why did we do this? Madam Speaker, on the 7th of September 2015, we had a general election. On the 9th of September 2015, the Honorable Prime Minister nominated his Attorney General and his Minister of National Security, and we were being sworn in. In the middle of the swearing-in ceremony, I received a call as I had taken my oath, and the first matter on deck was the matter of a matter in the courts of Trinidad and Tobago brought by the past Attorney General of the members opposite, seeking a constitutional declaration against the law which he as Attorney General had proclaimed and operationalized in the face of objections from the opposition, now government, saying do not proclaim and create unconstitutional situations lest you expose the state to millions of dollars of damages, because you must factor legislation and the drafting and making and passage of it at the same time that you operationalized. And that was the birth of the journey that I just described in marrying operationalization with legislative approach, Madam Speaker. Madam Speaker, a bill like this would ideally be best served in a joint select committee. However, the entire rubric and backbone of this project has been facilitated specifically under the auspices of the US Aid project together with the judiciary of Trinidad and Tobago. The US Aid project was a project to deal with juvenile courts, but the attenuation of the term juvenile court was brought in our jurisdiction to a children's court on the basis of the consultation efforts that we have had, and I'll speak to that in a moment. There is a deadline for the operationalization of the fit-out of courts by June of this year. But this is very much a situation of how the domino falls. The first and most important aspect is to have the passage of this law. When this law is proclaimed, assuming that we have the cooperation of members of the Senate and the House, then, Madam Speaker, we must deal with the issue of the operationalization. The courts need to be in progress for outfitting. The rules of court and subsidiary legislation need to be done. And the operationalization across the several ministries that I just mentioned need to be factored as well. And what we have been doing in the last 5 months in particular is making sure that we build the platform in carrying forward the promise that this government has taken to have an autonomous judiciary. We have been actively supporting the work of the judiciary by allowing them to select their buildings for the use of courts under their auspices, by coordinating in the drafting of the subsidiary legislation, by coordinating with the constitutional arrangements to be put in effect, particularly with respect to child offenders at the YTC, at the St. Michael's and St. Jude homes, etc. And we have done that specifically so that we can keep track with the international funding that Trinidad and Tobago has been lucky enough to have by way of support, Madam Speaker. Madam Speaker, the bill itself, in the short time that I have, comprises 63 clauses, 5 schedules, and is arranged across 6 parts. The bill was had the benefit of some significant consultation, Madam Speaker, and I just wish to put on the record the kind of consultation that has happened. There's been wide local and international consultation with respect to processes and procedures in children matters. In 4 8 to 10 hour sessions chaired by the Honorable Chief Justice, the members of the Family Court Monitoring Committee, that committee, met and scrutinized the particular bill. The members of the committee included judges, magistrates, registrars, family court staff, social worker representatives, Ministry of the Attorney General representatives, Law Association representatives, Family Law Association representatives, the court administrators, and the court administration consultants. Specifically, the police, prisons, probation, criminal bar, DPP, Solicitor General, Legal Aid and Advice Authority, Children's Authority, Private Bar, Children's Authority staff, judicial officers, representatives of national PTAs, Ministry of Education, Ministry of Legal Affairs, Youth Development, specialists and religious leaders were all consulted. Internationally, family, juvenile and youth courts in the US and Canada, Children Probation and Support Services in the U.S., U.S. National Center for State Courts, study of rules of court in several jurisdictions, specialists in Jamaica, Canada, New Zealand, and England, and the study of scientific research on child and adolescent development was all factored. I received today, and I wish to put onto the record, a letter from the President of the Law Association, Mr. Reginald Armour, SC, indicating to me that the Law Association was engaged in an exercise of review at present, and that they would be commenting further on the work in progress. And I am indicating that the Office of the Attorney General, which is driving this particular exercise, is open to receiving further consultative points, because there is a gap between the passage of the law and its proclamation as is set out by way of a specific clause in this legislation. And the key is to make sure that we have our eyes on the marker properly. We have engaged in a direct consultative process with all agencies across the board, including the opposition. And I wish to put on the record that in dealing with this bill, I had a lot to say while I was in opposition about the approach to legislation making, and I didn't want to be eating my own words. So I specifically asked the Parliament to put into its repository, the rotunda, where members access legislation, the bill, the track change version of the bill as compared to the 2015 amendments, all 18 pieces of consequential law to be amended in their short form, and then the amendments fitted into a track change version so that members could access, see, factor, and appreciate the context of amendments into the body of the law that they were amending. I would like to say that from my own research, that that's a first. It's never been done before. It's something that we subscribe to. The caution is often that one can open the debate very widely by doing that, but there is nothing to hide under the veil of ignorance that legislators wear in drafting the laws by having full and open and frank disclosure, as we have done as a government, be it in disclosing advice to the Law Association for the first time ever for inspection, or this kind of approach. This is the way this government intends to operate. Madam Speaker, it is incumbent upon me to speak to the architecture of the bill, the clauses, and the consequential amendments. Clearly you realize that the time will not do justice to the measure. However, I do have a second bite at the cherry, and I will, in my wrap-up, and I will have the meaningful assistance of my learned colleagues who are prepared to speak today, and no doubt the learned members of the opposition who I am sure are willing to consider supporting this bit of legislation as it is proper to do so. We are open to receiving any comments and amendments that they may have. Permit me therefore to go through the clauses of the bill quickly. There is a degree of reciprocity and similarity between two stages of the bill. The 5 areas, the 5 sections, the 6 sections of the bill are the preliminary sections, the family and children court division, the administrative sections, the family court division, the children's court division, and then the miscellaneous provisions. Those are the 6 hierarchical headings inside of the bill. Specifically, in sections 4 and 5 of the bill, there is to be a degree of duplication in terms of terminology and processes as one compares the prescriptions as it relates to the family court and the children's court. Specifically, and I say this for the record to assist members, the mirroring sections between section 4 and 5 of the bill would be as follows. Clause 10 matches 26, clause 11, clause 27, clause 12 matches 28, clause 13 matches 29, clause 14 matches 30, clause 16 matches 31, clause 17 matches 32, clause 18 matches 33, clause 20 matches clause 34. That allows me therefore to focus on only one of the clauses because there is a mirror image on the others in the interest of time. Specifically, I'd like to point out for members that under the consequential amendments to be factored under Schedule 5 of the bill, one is invited to have careful approach to item 8, item 9, item 12, 13, 16, and 17. And they refer to the Prisons Act, Chapter 1301, the Young Offenders Detention Act, Chapter 1305, the Adoption of Children Act 2000, the Status of Children Act 4607, the Children Community Residences Act 2000, and the Children's Act Chapter 12, number 2 of 2012. Those are the big areas that I'd like members to focus on. Specifically, Madam Speaker, the clauses of the bill will show us, no doubt, in Part 1, the preliminary sections. We're dealing with the long title of the bill. We're dealing with the definitions, importantly, at Clause 3. And I'd like to focus on the definitions, 2 in particular, which have been significantly amended from the 2015 version of the bill. And those are with respect to the definition for children care matters and also children matter and family matters, Madam Speaker. Thank you.
Member.
Madam Speaker, on a point of clarification, would the Honourable Attorney General indicate whether or not the long list of organizations with respect to consultations were consulted on the 2016 changes and amendments?
Yes, Madam Speaker, they were.
Thank you.
And that's the consultation I'm speaking about. Yes, thank you. So, Madam Speaker, the 23 minutes that I have left, I have to do some justice with. So if members could hold their fire, I'd be very happy to answer as we go along. Madam Speaker, specifically, the 2 anchor definition points. 1, the definition as it relates to children care matters. I invite members to look at that. I invite members to look at children matter. And this is a broadened definition. A children matter, which is the substrata upon which the children court operates, includes children charge matters, children care matters, children drug matters, and I specify that, children mental health matters, matters which is not a matter which is not a family matter within the meaning of the Act, but a preliminary issue in respect of a matter is care and protection of a child. A matter in relation to a child where there is an application for an issuance of a protection order under the Domestic Violence Act, and a matter in which a child is required to appear in court. We have a specific definition for children mental health matters, and then we turn to the substrata of what the family court architecture is built upon, and that is the family matter to be found at page 8 of the definitions clause. A family matter means, and this is a much broadened scope than existed prior, matters under the Matrimonial Proceedings and Property Act, maintenance, guardianship, wardship, custody and access, applications under the Family Court Section 25, adoption, civil child abduction, succession and inheritance excluding probate and administration of estates, any matter in relation to an application for issue of a protection order under the Domestic Violence Act, and any matter arising out of the written laws listed in Schedule 1. And there is a prescription in Schedule 1 of a host of laws comprising some 23 pieces of law which have been broadened out, Madam Speaker. Coming upon that particular point, the definition of pair resolution is materially important, because in the 2 structural elements that we are creating, first of all, a hierarchy which sees the division divided administratively and physically, because there's a prescription against physical housing of the 2 courts in such a way as can cause harm. There may be courts sitting in similar areas, but they must be divided out. Charge matters being treated different from children matters, family matters. All of these things are factored in this particular arrangement. But in the hierarchy that we now approach, the family and children division has as a subdivision the family subdivision, and then another subdivision, the children subdivision, and each of them are comprised, each separate division, with a family court judge and family court masters. A children court judge and children court masters. And why we have done that is to take care of the workload administration. In amending the Supreme Court of Judicature Act, we're moving from 36 judges to 46 judges, 41 judges. I'll correct the number in just a moment. And specifically, we're broadening the application of masters. We have taken care in this particular bill of an anomaly where a clerk of the peace who was not a trained legal person dealt with certain matters in the summary jurisdiction, and now we are having the registrars as assistant registrars of those courts, deal with those matters. The bill prescribes that judges, registrars as assistant registrars, marshals as assistant marshals, clerks of the peace, etc., are to be trained specifically in this area with the nuances that come with the development of a progressive approach towards the rights of children and family matters. It specifically provides, and my learned colleague, the Minister of National Security, will no doubt speak to that. We're moving from 4 to 9 judges now. What we are dealing with, 49 judges now, what we're now dealing with, Madam Speaker, in this particular approach is a structural change so that the police officers who assist this have the benefit of a divisional support by the Trinidad and Tobago Police Service, which we have just announced very proudly yesterday at Cabinet. But more particularly in this bill, we're adding in the expertise of probation officers in a very serious way. And we've expanded this because far too often in the family court, in any jurisdiction that you may have appeared, be it the magistracy or the high court, far too often what we have had is an inability for the system to function appropriately because of a lack of human resource capacity and training. And we felt it a necessary fillip that this thing be approached from an operational structure by a supplementing of the positions on staff and by way of auxiliary support. Madam Speaker, the bill also provides for some very impactful positions for the court administration process. This bill seeks to take a very different step away from the Supreme Court of Judicature architecture, which at first in 2015 I didn't quite understand the need to change. Upon the further consultation, I can tell you I feel very satisfied, so to the members of the LRC, that in prescribing the architectural structure, as we do in this bill, to allow for executive court administration, court managers in the family court or children's court, what we're actually doing is to keeping by way of a robust structure the ability for divisions to maintain their boundaries, but to function with efficient staff. It allows for the Ministry of Public Administration to factor how these positions are to be created, and especially because of the type of specialist training, it allows for the CPO that considers salaries to take a new approach to the job description and analysis, because far too often we have very careful and specialist need for certain services, but we find that the state just can't pay enough. And it's important for us to look at this specialization to provide the routes for people to ascend into the ranks into specialist areas. Madam Speaker, very importantly, the voice of the child is something which we seek to protect by way of an expanded version here. And the Office of the Ministry of the Attorney General has an obligation to provide through the Solicitor General's Department children's attorneys, so that they may be on call in any matter that a child is required to appear in or give evidence in from the moment of an interview or charge straight through process. And that is entirely without prejudice to the child having separate legal representation, so that the state, in acting in the capacity as parens patrien, that is, a superior parent with the best interest of the child in mind, has a continuing obligation so that the mechanisms of the state which articulate together to give support in terms of meaningful coordination, be they in a community residence or a children home or through the probation officer's report or through the monitoring report, that these things can be coordinated. What has been lacking is the ability to coordinate efficiently, Madam Speaker, and this bill speaks to that. Madam Speaker, I wish to focus in the 15 minutes that I have left, not only upon some of the highlight provisions that I have referred honourable members to in the clauses which have reciprocity. Of course, Madam Speaker, we would have traversed in the mirroring sections between giving the jurisdiction for High Court and magistracy into the child court, into the family court. We would have allowed for High Court judges, puisne judges to operate together with masters You must give the jurisdiction to a High Court judge first, who then delegates to a master under the architecture of the Supreme Court of Judicature Act. You must then also, Madam Speaker, factor that under the child court, and permit me this opportunity, we have a very important position to factor. Let me deal with the smaller one first. I'll deal with the family court first. Under the family court, a very significant tool provided here now is the ability of the family court judge or master to enforce maintenance orders. There was an anomaly in the law where it was bifurcated. You had to go to one court, release from one court, go to another court. Now we are allowing, and by way of scheduling out in Schedule 2, is it? Or Schedule 3, we are scheduling out the maintenance provisions of law which are to be factored, and they are in fact in Schedule 2, where we describe 12 laws that provide for the maintenance prescriptions. But we're allowing a very unique feature. We're allowing those who are in default of their maintenance obligations to be brought through due process before the court on a show cause basis as to why they should not be punished or why they should be given extra time to comply with maintenance orders, because we must deal with the issue of parents or persons with responsibility for children who do not meet their societal obligations. Until parents are brought to bear on the obligation to support their children financially, by way of education, by way of support, dare I say that we will be breeding a terrible problem in our homes which spill out to society. And the government's response to this is to enable the structures in a broader sense, so that the law can be applied to deadbeat fathers, deadbeat mothers, deadbeat persons with responsibility who do not meet their obligations. Madam Speaker, very importantly, we also have to factor a significant move in the children's court, the point that I pressed pause on a moment ago, and that is in the inclusion in clauses 37 to 39 of monitoring hearing, children's probation officers, and report of children probation officers. These are new provisions. What this allows, Madam Speaker, in factoring the voice of the child or the child's best benefit and welfare, is the ability of the court on a continuous basis to track the progress of the child, to avoid recidivism, to avoid people falling through the cracks in the system, and to have a regular way of reporting to a supervising judge so that no child is left behind, Madam Speaker. Madam Speaker, very importantly under the children's architecture is the concept of peer resolution. And this is significantly broadened in clauses 40 to clauses 46. And we have developed, through the international support of the United States in particular, and the study of best practices in the world, we have now taken this position and expanded it to allow children under the supervision of a peer resolution process specified in the legislation in terms of its operationality, to have the benefit after having been charged, after having been brought to the court, after having entered a plea of guilty, to then engage in a system through constructive support, monitoring, and report back to a judge, ultimately to allow for convictions not to be entered, Madam Speaker. That allows us to avoid the mark on the child's character. That allows a degree of horizontal approach in those who are your judges and accusers, where a child feels that there is some degree of emotional understanding by his or her assessors duly supervised. Madam Speaker, very importantly is the Children Drug Treatment Court process, and this has been significantly expanded over the 2015 bill. And in this process, Madam Speaker, in clauses 47 to clauses 56, we are looking at a significant opportunity to allow children who have alcohol issues, who have drug issues, with consent, and sometimes, as it is in peer resolution in very circumscribed senses, to have the ability without consent to be brought to the Children's Drug Treatment Court and to escape the horrible dilemma that I've witnessed personally of children being housed in circumstances where they are with children who are charged or convicted of heinous crimes. This allows us to have children removed out of the system. This allows for an application of a revolving door of gradually increasing penalties to be applied inside of this matrix. In the 8 minutes I have left, Madam Speaker, not being able to do justice to the amount of work that this bill requires, I want to focus, after saying that the transitional provisions allow us to have a concurrency between matters that have started already and then move into the new system after proclamation, I want to focus on a couple of the material improvements to the consequential amendments set out in Schedule 5 to the bill. And in particular, the massive moves that we have made in what I refer to as YODA, the Young Offenders Detention Act, where we are removing the concept of a youth offender and dealing with charge matters, where we are inviting the Children's Authority to come in and work alongside the Commissioner of Prisons with teams of people to better associate with the issues of children, requiring as a matter of law that children who are in detention are educated, are clothed, are fed, are housed properly, allowing the Children's Authority the right to enter and inspect and deal with issues of monitoring license requirements, even though the institutions of the state may be determined and declared to be institutions of the state, they're still going to be monitored by the Children's Authority, lifting by way of a civil standard an outside approach the state and conditionality of our prisons, Madam Speaker. Very, very important amendment. And what we are allowing by this process is for the children's homes and the rehabilitation centers, as they are now amended in the schedule to be better described, to be under a constant supervision of the Children's Authority. The Commissioner of Prisons still has the right to inspect, take property, deal with certain matters. I wish that I had put a reciprocity of rights into this bill, but it would have required a 3/5 amendment to the bill, and it would have had some deeper consequential amendments. But I would love to have given, I will say this openly, the Children's Authority the ability to demand production of certain things. Commissioner of Prisons has that right now, but I would love to have had that authority in the children's homes environment, and perhaps we can attend to that at a later date, so that someone has the right to walk in and say, produce that child now, take pictures now. It can fall under the rubric of licensing. I personally, and I see those who have assisted me cringing while I say this, I personally would like to have seen a little heavier step on that. Madam Speaker, the Status of Children's Act makes some critical amendments. We have included DNA legislation to declare paternity. Blood tests are no longer appropriate. It is dealing with non-intimate samples. We are dealing with the fact that these have to be brought in together, but materially, in amendments to the police service legislation, the prisons legislation, the indictable preliminary inquiries legislation, we are protecting the personal information, be it fingerprints or be it DNA evidence, from disclosure other than for the purposes in which they were disclosed. Very significantly, Madam Speaker, we are also seeking to amend the consequential difficulties that we have in the nomenclature, in dealing with the harmonization of the tone and concept that we have as introduced in the Children's Act 2012, and we are now taking the opportunity in one fell swoop to attend to all of the harmonization issues. But I want to say, this kind of law, as I've experienced it living in the environment of amending the 18 pieces as well, this kind of law is something, the more you look at it, the more you're going to see, the more you want to fix, and so you go and go and go. It's very difficult to come up with a final product inside of this environment. However, I wish to again commend the fact that we have a deadline aspect to deal with in terms of the support of funding by the US aid, and that we have some significant factors. So I agree that we are open to amendments as we come. I could very easily have taken the approach to bring 18 separate pieces of law and occupy the Parliament week after week after week on 18 pieces of law, but it would not have given us the line of sight across the whole of package legislation to get this material right, Madam Speaker. in addressing the point that one could have amendments that could come ad infinitum, I can now say that amendments are going to be circulated to the package that we have before us. They're not draconian, but they're improvements that we would like members to sit and consider. At committee stage, we'll certainly entertain all of those proposals. But suffice it to say, Madam Speaker, this legislation is long overdue.
True.
This legislation, I don't think, is one that can be kicked around like a political football, notwithstanding the little barbs dropped here and there. But, Madam Speaker, I want to say that as a member of this government, I feel a great sense of pride in knowing that the Prime Minister, through the Office of the Prime Minister, has given financial support and supervision to the amendments and physical outfits that we had to do to St. Jude's, to St. Michael's, to the halfway homes, to supervising entities, that we are giving the Children's Authority the financial and human resource capacity that they so desperately reserve, that the Minister of National Security is able to tell the nation across 9 divisions, you will have a specialist police force dealing with this, that community development and family matters can be bolstered and supported in the fashion that we're doing now. I feel proud to know that in 6 months of constant hard work, that we are at the point exactly where estimated by the Honorable Prime Minister, where we will now begin to deliver on a continuous basis the work that we have analyzed, the work that we have considered, that which we have purchased. Because we've spent a lot of money as a nation on a whole lot of things, be it $120 million for a red house roof that doesn't exist or not. The fact is, we must factor the purchase that we have done as a country. Madam Speaker, I think I could go on for another hour. Standing orders don't permit that. And I estimate right now that my time is at an end. And so, Madam Speaker, I look forward to the contributions of those opposite me into this very noble debate on a well-aimed and intentioned bill. And I do pray that there will be support unanimously in this House on this occasion. Thank you, Madam Speaker. I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Make Jurisdiction for All Family Matters and Children Matters exercisable in a division of the High Court to be called the Family and Children Division, and to make provision for matters connected therewith, be now read a second time. Member for Princestown.
Madam Speaker, I am happy to be able to rise and contribute to the legislation presented to the Parliament today in the form of the Family and Children Division Bill 2016. Madam Speaker, as you and many in the national community would be aware, that in order to know where we are going, we have to determine from where we've come. Madam Speaker, this bill before us, the Family and Children Division Bill, is no stranger to the Parliament. In the last incarnation of the 10th Parliament, this bill was introduced in the Senate by the People's Partnership Government. Madam Speaker, members opposite, including the member for San Fernando West, member for Port of Spain North, served on those Senate benches, and they added their support together with the independent benches for this particular piece of legislation. Madam Speaker, unfortunately, the legislation did not reach this honourable House in that last incarnation of the Parliament, and here we are today. Madam Speaker, today we are essentially continuing on the strong, buoyant legacy of the People's Partnership in protecting the rights and freedoms of the children of Trinidad and Tobago. Today, Madam Speaker, we can say without a doubt that this legislation that has been brought to the Parliament is due to the hard work of the People's Partnership Government under the astute leadership of then Prime Minister Kamla Persad-Bissessar, a member for Siparia. Madam Speaker, let me be the first to recognize that the government has finally brought a measure to the Parliament that will ease the burden and suffering of the people of Trinidad and Tobago. But upon reflection, Madam Speaker, I must point out that the only piece of legislation to be brought by this PNM government in 6 months to reduce the pain and suffering of the people of this country is a partnership piece of legislation. Madam Speaker, this legislation comes from the bowels of the People's Partnership Government. And Madam Speaker, I will use the opportunity to show you the history to institute legislation in this country to protect the rights and freedoms of children, as has been a long history of the United National Congress and the People's Partnership. Madam Speaker, I was very happy today to hear the member for San Fernando West speak about a legislative agenda. And Madam Speaker, on many occasions we have heard the Honorable Attorney General, member for San Fernando West, indicate that a legislative agenda will be forthcoming to the Parliament. Madam Speaker, on the last occasion, in an interview with CNC3 Hema Ramkisoon, when I raised the issue of a sex offenders registry in this country, the establishment of a sex offenders registry, the Attorney General gave the undertaking that we will have a legislative agenda by the end of February. Madam Speaker, February has come and February has gone. Now, the Honorable Attorney General is saying that we can expect it in April. Honorable Attorney General, we look forward to you keeping that commitment to the Parliament and to the people of Trinidad and Tobago by bringing a legislative agenda. Madam Speaker, the People's Partnership Government spent a lot of time focusing on children's rights and children's issues in this country. Madam Speaker, the Family and Children Division Bill was a brainchild of the People's Partnership Government. And we became a government known for people-centered development. We became a government known for putting children and people first. And Madam Speaker, sometimes in this Honorable House, you hear week after week after week from members opposite on that side speaking about the legacy of Kamla Prasad Bisesa in the context of children's rights and children's freedom. And Madam Speaker, I would like to correct many myths that is said sometimes in this House, and sometimes you hear it coming from members opposite talking about Kamla's legacy with respect to stockings or no stockings. And Madam Speaker, I find that to be so utterly disrespectful, especially in a context when you've had a Prime Minister and a government in the People's Partnership that have brought legislation like the family.
Madam Speaker, I rise on 48-1.
Member, we understand the context. I'll just ask you to get to the matter that we're debating.
Thank you, Madam Speaker. Madam Speaker, what is the real intention of this bill? The bill is intended to deal with many of the issues affecting our nation's children in a negative way, whether it be criminal misconduct, drug abuse, foster care, bail, or probation. Madam Speaker, I would like to spend a few minutes going into the history of children's legislation in this country, and also with respect to the establishment of the family court. Madam Speaker, the history of this legislation spans back from the year 1999, under the first UNC-led government, to which a member for Siparia and several of my colleagues belonged to. Madam Speaker, on Friday, December 3rd, 1999, then Minister of Social Development, Manohar Ramsaran, stated, and I quote from the Hansard of that day, Madam Speaker, Mr. Speaker, today I have the honor of speaking to you on the Children's Authority Bill. This bill seeks to regulate all matters with respect to the children of Trinidad and Tobago to ensure that a comprehensive package of legislation and legal services is provided and delivered in a coordinated and integrated manner. This piece of legislation will address the care and protection of children in the context of the family situation and the community. End of quote. Madam Speaker, this was in the year 1999 under a UNC-led government who had the foresight and the vision for bringing legislation that would protect rights of the nation's children. Madam Speaker, I would be bold, brave, and brass-faced enough to shout to all and sundry today that this legislation is a work of many years by the UNC and the partnership government. I would be bold to say that the PNM is devoid of any real, tangible, legal innovation with respect to children and children's rights. Madam Speaker, The fact is that the first serious bill they have brought to this honorable parliament, which seeks to protect children, really belongs to the UNC and the partnership. This really is a testimony of the vision for the member for Siparia, and that, my dear friends, opposite is a legacy of Kamla Prasad-Bisesa. Madam Speaker, the members opposite in this House, Madam Speaker, Madam Speaker, I would not be distracted. Madam Speaker, when we brought the Children's Authority Bill in a different incarnation in 1999, we understood the socio-economic climate of the country at that time. We understood the dynamics of the bill needed to address what children endured in the context of their environment. And Madam Speaker, when the Minister of Social Development at that time brought the Children's Authority Bill, he said, and I quote, "The ravages brought about by poverty, consequent on structural adjustment, retrenchment and unemployment, poor parenting practices, mental illness, domestic violence, disability, HIV/AIDS pandemic, and substance abuse have all contributed in different degrees to family disintegration, resulting in a growing number of children needing care and protection from the state and growing numbers of children in conflict with the law." Madam Speaker, you would agree with me that a lot of what was said then is very applicable to today's society. Madam Speaker, a lot of the problems that we endured as a society, whether it be social or economic problems, stemmed back from that 1999 period, and is very much relatable to the context in which we have found ourselves today as a nation, with respect to unemployment, with respect to retrenchment, with respect to the social conditions and the social fabric of our society today, with respect to the problems that we are experiencing in our nation's schools, the problems of abuse. Madam Speaker, I can go on and on about what we experienced during those years and also the context in which we find ourselves at this time. Madam Speaker, having outlined the vision and the genesis for where this package of legislation was derived, I can assure you that from then until now, and even in the future, you can count on a UNC and a partnership government to protect the rights and freedoms of the most vulnerable in our society, children. Madam Speaker, what is the main purpose of this bill? The main purpose of the Family and Children Division Bill in both the 2015 and 2016 versions is to create jurisdiction for family and children matters to be exercised in a division of the High Court called the Family and Children Division. Madam Speaker, the bill creates two distinct courts within the division, the Family Court and the Children Court. It sets out the administrative units needed for those courts to operate, and it identifies several legal processes, which AG alluded to be utilized by the courts. The 2016 bill, Madam Speaker, includes consequential amendments to 18 existing acts. And while the Honorable Attorney General spoke about the time factor that it would have taken to bring 18 separate bills to the House, Madam Speaker, we in the opposition have a little bit of a concern in terms of some of the issues that have been raised in these 18 amendments and bringing it in totality in one bill. Madam Speaker, in the 2015 bill, we attempted to keep certain elements of the legal justice system separate when dealing with a bill. Today, the government has lumped additional areas of the legal justice system into the 2016 version, which would now also address the children's probation officer, continued court supervision, peer resolution process changes, and the children drug treatment process. Madam Speaker, the addition of the clauses that deals with these matters are a bit unclear. We have to believe that a full review of existing legislation for consistency is still needed. Madam Speaker, as it stands, these pieces of legislation are being amended in a vacuum. Madam Speaker, the Family and Children Division Bill 2016 has serious implications on the legal justice system in our nation, and it therefore begs the question, Madam Speaker, on whether the stakeholders that will be impacted by this legislation has been consulted. And that is why I took the opportunity to rise and ask of the Honorable Attorney General who were consulted in these matters. And Madam Speaker, the Attorney General was very forthcoming, and even before I asked the question, he said the Law Association, the head of the Law Association, was consulted on this matter. Then he took the opportunity to go through a number of organizations, a number of groups that he indicated was consulted on the 2016 amendments. Madam Speaker, I'm subject to correction, but I know and have been advised by several organizations in this country that deals with the rights and protections of children's issues who have not been consulted on this matter. Madam Speaker, I did not hear from the Honorable Attorney General, maybe it missed me, and he can correct me in his winding up, of whether or not the Police Service Association was also consulted on this bill. The Prison Service Association, were they also consulted on this bill? And Madam Speaker, let us deal with the issue of consultation with respect to the Family and Children Division Bill 2016. Madam Speaker, I dealt with the issue of consultation in the context of whether or not these organizations, such as the Police Service Association and Prison Service Association, were consulted. They have also indicated by way of using the mechanisms of the Parliament channel that the opposition was also consulted. Madam Speaker, can we seriously say in today's day that a bill that deals with family and children, an essential bill in our legal justice system, by way of utilizing the Parliament channel is website is an effective way of engaging members of the opposition with regard to this amendment? Madam Speaker, here again we are seeing the government putting the cart before the horse. Madam Speaker, I wish to read into the Hansard the achievements of the Child Protection Task Force and their report, and this report was initiated by former Prime Minister and a member for Siparia, which is contained in the March 26, 2014 report. And Madam Speaker, when we are dealing with children's rights and children's protection in this country, we on this side of the House, at that time, the government was serious about ensuring that we heard from professionals, from child psychologists, from the professionals who deals with these particular matters, that deals with children's issues. We were particularly interested in hearing what they had to say before bringing this bill to the House. And therefore, Madam Speaker, we established the Child Protection Task Force. Madam Speaker, today I would like to know what has become of that Child Protection Task Force. Has it been disbanded? Has the government consulted with Child Protection Task Force? And Madam Speaker, I ask those questions in the context of the achievements and the recommendations that came out of the Child Protection Task Force report in 2014, when we raised this bill in the Senate at that time. And Madam Speaker, allow me to quote the achievements of that Child Protection Task Force. And this was the March 26, 2014 report. The Children's Authority has expedited its recruitment with the approval of its compensation package. 41 professional staff from the required 97 have been recruited. The customization of the assessment center at the EWMSC is underway, and 2 centers are being constructed by the MGYCD in South and Central Trinidad. Training and monitoring of staff in the community residences is ongoing. Initial studies on the legislation that still needs to be passed and or proclaimed have been conducted. And Madam Speaker, we will come back to the history of this government with respect to proclamation of children's legislation. Madam Speaker, I continue to quote from the achievements of the Child Protection Task Force report of 2014. It spoke about the review and recommendations of the long-awaited youth justice policy having been completed by the task force members from the Children's Authority. A study on the need for children's ombudsman has been made and is in the process of being finally reviewed by the task force. Madam Speaker, it also, I quote, the issue of legislation regarding child protection from the Child Protection Task Force report of 2014, which spoke of the legal age of marriage being moved up to avoid the possibility of subjection of children to forced marriage and a need for a definition of reasonable corporal punishment of children by parents to prevent children being beaten to death as a form of parental discipline. Madam Speaker, Apart from the achievements, let us see what were the recommendations of this Child Protection Task Force. Madam Speaker, the recommendations were a children's ombudsman, first off. And Madam Speaker, this recommendation from the Child Protection Task Force was not the first time that the issue of a children's ombudsman was raised. And I would like to refer to an article of Sunday, July 5th, 2009, quoting, and it's a Newsday article, quoting Independent Senator Corinne Batiste-McKnight. And the senator said at that time that she was calling for the establishment of a children's ombudsman. Madam Speaker, she said that during the lifetime of the family court and during the establishment of the Children's Authority, not one single safe space had been provided by the government for problem children. She opposed the incarceration of children, but said they needed a safe place in which to be helped and they needed someone to go to, and she was recommending a children's ombudsman. Madam Speaker, in that article, she said that it was challenging the bill's proposal for an attorney to seek the interests of a child at the family court, and she made a different suggestion of a children's ombudsman. Madam Speaker, the Independent Senator Batiste-McKnight further went on to say, rather than just have a senior attorney, should we not at this stage give some thought to the children's ombudsman who will head up that function and really be the person to ensure that everything will be done to protect the child involved? Madam Speaker, that was one of the recommendations of the Children's Task Force. Madam Speaker, I have reviewed this legislation, the 2016 bill, and while we would like a holistic approach, and the member for San Fernando West spoke about that we can continue to add and add and add to the existing legislation, it is one of the issues that I would like the government to consider. Madam Speaker, one of the other recommendations was a youth justice system, the family court, student support services, National Children's Registry, community residences, child protection and family violence unit. Madam Speaker, the task force recommended, and it made specific mention of the Ministry of Gender, Youth and Child Development's involvement. Madam Speaker, as of September 7, 2015, the Ministry of Gender, Youth and Child Development was disbanded. And Madam Speaker, a lot of the work that was done with respect to the 2015 bill that was brought to the Senate was because of these recommendations and reports coming out and emanating from the Child Protection Task Force, which fell under the Ministry of Gender, Youth and Child Development. Madam Speaker, I would like to turn to the issue of the Child Protection Task Force evaluation of the support that was received from the People's Partnership Government with respect to children's issues and children's matters. And Madam Speaker, I will recall on the day that this report, the 2014 report, was presented to then Prime Minister Kamala Persaud-Bissessar, a member for Siparia, the chairman and members of the Child Protection Task Force, which included former Independent Senator Diana Mahabir-Wyatt, also included Mrs. Stephanie Daly, Senior Counsel. Madam Speaker, on that day, the chairman of that task force congratulated, and I remember specifically, she congratulated the role that the Prime Minister, then Prime Minister, played in terms of the level of support and the accessibility the Prime Minister gave to the task force with regards to the work that it has done. And Madam Speaker, I'm hoping today that when we come, that we can see a similar level of support being provided by the government, and not just lip service being provided by the government. We have been seeing instances where children's rights and children's issues have continued to be a back burner issue for this government. It is only because, Madam Speaker, that they had nothing meaningful to bring to this Parliament after 6 months of being in office that they have turned the partnership bill into their own. But Madam Speaker, we take ownership of this piece of legislation because we have demonstrated while in government and even outside of government our commitment to children and children's rights in this country. Madam Speaker, I would like to also raise the issue of whether or not the Prime Minister has engaged the Children's Task Force. Madam Speaker, you would recall that the Ministry of Education held a consultation with respect to the curriculum. And the Prime Minister made statements at that consultation that rubbed many in the national community the wrong way. Madam Speaker, to borrow the Prime Minister's words, he said that we were breeding monsters. And Madam Speaker, I want to ask, in the context of the Family and Children Division Bill, whether or not the Prime Minister at that time, whether or not before making his comments, that he engaged the Children's Task Force to find out what were the root causes of many of those issues taking place in the school. Madam Speaker, as a responsible Prime Minister, as a responsible representative of the people, one would have hoped that before he opened his mouth, and knowing that the government was bringing the Family and Children Division Bill 2016 to this House, that the Honourable Prime Minister would have consulted with the Children's Task Force. What have they done with the Children's Task Force? Has it been disbanded? And I'm hoping that the Honourable Attorney General will be able to share clarity on this particular matter. Madam Speaker, we had a Prime Minister in this country prior to September 7th, 2015 that loved children and showed it. And Madam Speaker, I will relate it to this Family and Children Division Bill 2016 because I know members opposite will be eager to jump off their seats. And let me relate it, Madam Speaker, in the context of the Family and Children Division Bill 2016. Madam Speaker, leadership is very important in terms of where our children are going in our society today. And we did not have a Prime Minister prior to September 7 who called children dunce-head children. We did not have a Prime Minister that spoke about children fighting as though they were hyenas in an African jungle. Madam Speaker, we did not have leaders who called a little Rastafarian boy stupid for kissing a Prime Minister's hands. Madam Speaker, we did not disrespect the society at large and the children by ventilating her shopping practices for foundation garments for her spouse. That is a mark and a distinction of leadership with respect to children's issues in this country. Madam Speaker, it begs the question, is that the type of leadership that Diego Martin West, that every time you pick up a newspaper, that is a quality of language coming from the Honourable Prime Minister and members opposite? Madam Speaker, I want to turn to a very important issue with respect to the consultation process. And that process has to do with the role that the Law Association has in ensuring that whatever support or whatever interest it expresses on behalf of its members is an interest that is one of collectivity. And Madam Speaker, an important matter has been raised in the public domain in the past few days. And Madam Speaker, I think it is a very important, but it is also a very dangerous development in our country. Madam Speaker, the issue of the head of the Law Association relationship with the Attorney General. And Madam Speaker, I will relate it in the context.
I've allowed you a considerable breath. We are debating a particular piece of legislation, and I would ask you, in the few minutes you have left, to please stick to that.
Certainly. Thank you, Madam Speaker. Madam Speaker, suffice to say, I wish to make the point that therefore, if we are consulting, that we have to be careful of the blurring of lines with respect to persons in our judicial system. And Madam Speaker, we on this side, for years, we were told that we were a box-drain government. Madam Speaker, I would like to declare today that this government is an A-box government. And therefore, Madam Speaker, we will not be silenced on this side of the House with respect to important issues that need to be ventilated with important office holders.
I have warned you to please stick to the context of the bill.
Madam Speaker, having said that, let me turn to the clauses of the bill. Madam Speaker, let us deal with some of the administrative clauses of this bill. Madam Speaker, a lot of what has been amended are really cosmetic changes. But they are cosmetic changes that also warrant some improvement and also warrant some clarity. Madam Speaker, the administrative issues that exist in clause 8.1 to 8.5 deals with the responsibility by the Chief Justice in the staffing and the decision-making of the Family and Children Division of the High Court. And Madam Speaker, we would like on this side some clarity in terms of what really will be the role of the Chief Justice and whether or not the specificity of removing the Chief Justice's role and function here has to do with which area in the court in terms of the staffing issues, in terms of the allocation of resources, in terms of the
Member, would you give way? Madam Speaker, I'm just looking at the specific clause, and could the member point us to directly what he is speaking about? Because I'm not seeing the nexus with what he's speaking about.
Madam Speaker, the clause says in the 2016...
Which clause?
8.1. Which follows into 8.2. Madam Speaker, it says that the Family and Children Court Administration Department shall be headed by a Deputy Court Executive Administrator, Family and Children Division, be assisted by a Family Court Administrator and Children Court Administrator. It goes on to 8.2, and it says the Deputy Court Administrator, Family Court Administrator.
That's 8.3.
Oh, sorry, I'm reading the 2015 version. My apologies, Madam Speaker, I was reading 2015 version. And therefore, we are now looking at the 2016 version. And I'm coming back to the point, Madam Speaker, of whether or not the use of the specifying the Chief Justice's role here in terms of the language, in terms of the clarity, simple clarification, member.
Madam Speaker, if I may, just so that when either the Attorney General or any other member responds, could the member for Princestown tell us where in these clauses the role of the Chief Justice has been either spoken about or abrogated in any way, please? Thank you.
Madam Speaker, in the 2015 version...
No.
I will relate it to the 2016 version. I will relate it to the 2016 version, Madam Speaker, where it says...
Ask for clarification. Please allow the member to...
Thank you, Madam Speaker. The 2015 version and the 2016 version. The 2015 version, we have to look at what it says. And it says the Deputy Court Administrator, Family Court Administrator, and Children Court Administrator shall possess the appropriate training and experience, which in the opinion of the Chief Justice for appointment to the Family and Children's Court. That's what the 2015 version said. Now, the 2016 version, Madam Speaker, speaks about as required by the judiciary. Now, Madam Speaker, who in the judiciary? And therefore, we are just seeking simple clarification with regards to language.
Would you give way so I could clarify, please?
Sure.
If you look at clause 7.1 or 7.5, 7.5D, the Children Court Administrative Office shall comprise, and D, such other units and subunits as may be determined by the Chief Justice. So I don't know what your concern is. The Chief Justice has a direct role,
Madam Speaker,
in all of this.
Madam Speaker, on the onset I had indicated that we were seeking clarity with regards, simple clarity with regards to language, because it has to deal with the judicial legal system of our country, and we need to have clear and precise language in terms of the bill. Madam Speaker, I want to turn to the issue of the costing and the operationalizing of the court.
30 minutes have expired. I have given you a little entry time because of the clarification. You're entitled
Thank you, Madam
15 more minutes.
Yes.
If you're entitled, if you are willing to ask leave for that, please proceed.
Thank you, Madam Speaker. Madam Speaker, I turn to the matter of costing for the operationalizing of the Family and Children Division. Madam Speaker, this government has had a long history of bringing legislation to the Parliament and not operationalizing it. This is a huge concern for us in the opposition. Madam Speaker, and I will turn, Madam Speaker, Madam Speaker, I will link the point with respect to the Family and Children Division Bill. Madam Speaker, recently I called for the strengthening of the Criminal Injuries Compensation Act and also recommended that government increase the ceiling figures. And Madam Speaker, I would like to use this as a comparison with respect to the Family and Children Division. In that, Madam Speaker, for years, Madam Speaker, that particular bill was brought to the Parliament, it was debated, it was passed. And Madam Speaker, for years, even despite Justice Myers' judgment in 2006, the government refused to set up the Criminal Injuries Compensation Board. And Madam Speaker, we fear on this side of the House that a similar approach will be taken with respect to this Family and Children Court. Madam Speaker, it takes the political will. It takes the political will of any government to ensure that the court is operationalized in the context that it gives the continued support from the government. Madam Speaker, I turn to the developmental program for 2015-2016. And in that program, one can see that the government budgeted $500,000 for the establishment of a juvenile court. Madam Speaker, that is laughable. If this government was serious about children in this country, they would have ensured that appropriate funds were put in place to properly operationalize this court. Instead, Madam Speaker, in the same developmental program, they allocated $1.5 million to the outfitting for the accommodation of the Director of Public Prosecution's Office. Madam Speaker, it begs the question, really it begs the question of whether or not this government has the political will to ensure that this Family and Children Court is realized. Madam Speaker, there are many instances and examples of cases involving children that continue to languish in this country. And it is languishing because of the bogged down system we have here in our nation. An overworked criminal justice system, Madam Speaker, has yielded little results or justice for children in this country who are victims of serious crimes and murders. I'm happy to hear that the AG is speaking about the operationalizing of this court. Madam Speaker, while we take a very nationalistic approach and we agree that this is a measure that is very much needed, Madam Speaker, one of the clauses in this bill speaks specifically with respect to the issue of repeat offenders, with respect to drug use and criminal conduct. And Madam Speaker, I think this would be an area that can really help many troubled children in our system, in that we have to acknowledge that there are children in our nation's schools who simply cannot cope. And they need help. Their cries through violence and other means is a cry for help, but our criminal justice system needs to identify these children and get them the help that they need. Madam Speaker, for too long we have been putting plasters on sores. And therefore, Madam Speaker, I think together with the government, it is a good idea for us to send this bill to a joint select committee where it will receive the attention that it deserves so we can go through into detail. We can go through into detail, Madam Speaker, the clauses and also some of the issues that were raised in the Child Protection Task Force, which they have abandoned, as well as the amendments. Madam Speaker, I want to deal with an issue that is very contentious. And I know those on the other side will jump up every 2 minutes again, Madam Speaker, and that is why we wish to provide support through a joint select committee for this particular bill, to deal with the amendments and so on. We also have to take into context about whether or not the government is really serious about seeing this court actualized. And Madam Speaker, what has been the history? Madam Speaker, this bill, this Family and Division Bill 2016, is a step in the right direction. But Madam Speaker, since coming into office, many of the measures taken by the People's Partnership with respect to children and children's rights in this country, they have abandoned. And Madam Speaker, what have they abandoned? They have abandoned the Couva Children's Hospital. It remains unopened despite being fully equipped. But they come with the Family and Children Division Bill 2016. Their government has refused to contribute to the Children's Life Fund. The government has refused to give laptops. And Madam Speaker, they refuse to do that, but they bring the Family and Children Division Bill 2016. Madam Speaker, they have removed the baby grant. They have taken bread and butter out of the mouths of children of this country, Madam Speaker. But yet, Madam Speaker, they bring the Family and Children Division Bill 2016, beating their chest loudly. Beating their chest loudly. But Madam Speaker, what have they done? They have reduced the textbook program. They have now placed VAT on books. Their Prime Minister said we are not a reading society, but yet they beat their chest. We have brought the Family and Children Division Bill 2016. Madam Speaker, they have shut down the Ministry of Gender, Youth and Child Development, but yet they beat their chest. We have brought the Family and Children Division Bill 2016. Madam Speaker, allow me a little attitude with respect to the Ministry of Education. Madam Speaker, in several opposition constituencies, several schools that were under construction have stopped. The Parvati girls and Shiva boys in Penal Devi have been stopped since this government has come into office, but they beat their chests and sing loudly. The Family and Children Division Bill has been brought to the Parliament. Madam Speaker, if that is not hypocrisy, I do not know what is. Madam Speaker, in the few minutes that I have in wrapping up, I would like to turn to the issue of the Attorney General in the role, and he raised, I think it was the Minister of Health that raised the issue of little baby miracle. And Madam Speaker, I raised that in the context of the family and... I'll title Madam.
Please.
Madam Speaker, I intend on tying it into debate, have no fear. And Madam Speaker, the Newsday article of Friday, March 4, 2016, headlines, "No Miracle." And Madam Speaker, who is a member of Parliament for little baby miracle, or who was the member for San Fernando West, the Honorable Attorney General, who comes here today to say that this government cares, they care so much about family and children in this country. Madam Speaker, he is a member of Parliament for that particular family. Madam Speaker, the report says that they contacted him on February 20th. 20th go on 21st, 22nd, 23rd, 24th, 25th, 26th, 27th, 28th. Even February gave them an extra day this year, through the 29th. And not a word, Madam Speaker, from the member for San Fernando West. But what do? They come to the Parliament and they beat their chest loudly. The Family and Children Division Bill. Madam Speaker, as I wrap up, I wish to remind members of a Shakespearean quote from Macbeth. And Madam Speaker, it is very applicable today more than ever, and especially so for the member for San Fernando West. Madam Speaker, take your time. Act 5, Scene 1. Madam Speaker, and I quote, and maybe it might be prophetic that the Honorable Attorney General has just joined us. Act 5, Scene 1. Here smells the blood still. All the perfumes of Arabia cannot sweeten thy little hand. Oh, wash your hands. Put on your nightgown. Look not so pale. Madam Speaker, that is a temerity that this government comes today to beat their chest to talk about the Family and Children Division Bill when their own Attorney General, member for San Fernando West, did nothing to help little baby miracle. Madam Speaker,
I stand on Standing Order 48-6. You cannot say that.
And Honourable Member for Princestown, I'd ask you to withdraw that statement, please.
Madam Speaker, I withdraw with much hesitation. But Madam Speaker,
Madam Speaker.
Honorable members, please. Honorable member, when I've ruled, I wish you will desist from making any comment that contradicts my ruling. And I hope this, excuse me please members, I don't want any support. It has happened before. It won't be tolerated.
Thank you, Madam Speaker. Madam Speaker, the few minutes that I have in wrapping up, I would once again like to reiterate my call for this bill to be sent to a joint select committee. We on this side believe that this is a very important bill that needs a lot of attention. It needs some more work being done to it. And we would like the opportunity to spend some time looking at the amendments and the implications that that will have with respect to the judicial system of our nation. Madam Speaker, as I wrap up, it is my hope that during this Lenten season that the honourable members opposite will repent, Madam Speaker, for their wicked ways in terms of what they have done to the children of the Republic of Trinidad and Tobago. I thank you, Madam Speaker.
Member for Princestown, again I ask you to withdraw that statement. You cannot impute improper motives. Please
I withdraw, Madam Speaker. Thank you.
Do I take it that you've finished your contribution?
Yes.
Member for Tobago East.
Thank you, Madam Speaker. I'll now bring us back into focus on the matter at hand after the light entertainment. Madam Speaker, issues relating to family matters and children matters as defined in the bill are closely connected to the core work of gender and child affairs, for which I have responsibility as Minister of State in the Office of the Prime Minister. The many troubling incidents concerning crimes against children and acts of violence against women, which have been occupying the nation's attention and receiving much highlight in all forms of media, point to an urgent need to get all our systems right as they relate to both families and children, and in particular, Madam Speaker, children in conflict with the law. Madam Speaker, family matters are fraught with complexity, as are matters involving children in conflict with the law, and they both require special judicial attention. Creating the legislative landscape to deal appropriately with family matters and with child justice matters, as this bill seeks to do, is an important step in the right direction. Madam Speaker, the bill under consideration has had the benefit of further review over the past few months and is now considerably strengthened to deal with these matters. The bill seeks to streamline a significant number of statutes that will directly touch and concern these two courts, including statutes which are fundamentally touch and concern children and gender affairs. These include, Madam Speaker, the Children Act 2012 and the Children's Community Residences, Foster Care and Nurseries Act 2000, among others. Madam Speaker, we have had the benefit of a pilot family court in Port of Spain since 2004. The many advantages of dealing holistically with family matters in a specialized family court with appropriate support services have been clearly demonstrated through this pilot. As noted in the preamble, the Family and the Children Division Bill builds on the successes of the pilot and the lessons learned. The concept of a family court is therefore not new to our jurisdiction, and the bill before this Honourable House refines this concept in fundamentally important ways and sets out the necessary legislative framework to ensure its effectiveness. Having regard to the Children's Court, while we may have not had the benefit of a specialized Children's Court as envisaged by the bill, we have long recognized that children in conflict with the law need to be treated differently from adult offenders. And a juvenile court for these purposes was established since at least 1925 under the 1925 Children Act, now repealed. The Children Act 2012 refines the concept by not limiting the juvenile court to the magistrate's court and therefore establishes the basis for a children's court. The Family and Children Division Bill 2016 seeks to transform the old notion of a juvenile court by establishing a specialized children's court in keeping with modern concepts of child protection and child justice. The government, therefore, fully supports this initiative of the judiciary of the Republic of Trinidad and Tobago. Madam Speaker, I wish to dwell for a moment on some of the advantages of a specialized family court. A key aspect of a unified family court, which resonates with this government and the wider society, is that it is designed to ensure not only that parties have access to justice, but more importantly, to minimize the impact of the breakdown of family life on children. The importance of family to a child cannot be overstated, Madam Speaker. A child's physical, emotional, psychological development occurs within a family. It is where children learn essential life skills. Regrettably, however, Madam Speaker, family breakdown is a fact of life in our society, as in many societies. Nevertheless, its negative impact on children can be mitigated to a large extent by an effectively functioning family justice system that can achieve the objectives of access to justice and minimizing the impact of the breakdown of family life on children. It is right that children should be the central focus of a family court. They are likely to be most affected psychologically and otherwise. And the ordinary courts, Madam Speaker, do not provide the environment or the support services for resolving family conflict in the best interest of a child. Both research and experience have shown the family breakdown can have short-term and long-term effects on children. A young child may become more regressive, while an adolescent may become more aggressive. And the adversarial court proceedings, where the emphasis tends to be shifted and focused on the adults rather than the welfare of the child, may cause these tendencies to become more pronounced. Madam Speaker, divorcing parties or parties seeking custody or maintenance who cannot arrive peaceably at decisions about their children's welfare and negotiate issues related to their children may put those very children at risk. Children may become more maladjusted, and this may even last into adulthood. Children who are beyond the control of a parent are now classified under the Children's Authority Act, Chapter 4610, as children in need of care and protection. Assessments of these children reveal underlying causes ranging from sexual abuse to repressed feelings of abandonment and alienation resulting from family breakdowns. This government recognizes the absolute importance of minimizing the risk of children becoming maladjusted post-family breakdown. Madam Speaker, the annual reports of the Judiciary of the Republic of Trinidad and Tobago give an idea of the enormity of family breakdown and its implication to our society. For example, the law term 2012 to 2013, a total of 2,922 divorce matters were filed in the High Court. Of these, 2,439 were filed in the Family High Court. That is, most of the applications were filed in the pilot Family High Court, since the jurisdiction of the Family High Court is not limited to a specific geographic area. It could be, Madam Speaker, it could be that parties have elected to file their petitions in the Family High Court in Port of Spain, irrespective of where they live, preferring its user-friendly atmosphere and availing themselves to the services provided by that court. On the other hand, during the same period, that is, for law term 2012 to 2013, a total of 15,755 family matters, comprising mainly maintenance and custody applications, were filed in the Magistrates' Court, excluding the Family's Magistrates' Court. Magisterial proceedings in the Family Court are limited to the St. George West District, and so for the same period, 2012 to 2013, some 5,744 family matters were filed in the Family Magistrates' Court. The Magistrates' Court were designed primarily as criminal courts, as the Honourable Member for Princestown would have mentioned before. And although they have been adjudicating in the bulk of family matters, they lack proper alternative dispute resolution mechanisms and other services that are necessary to give effect to the best interest principle and to achieve the best outcome for children. Madam Speaker, the layout of these courts is also not conducive to hearing family matters. In stark contrast, the Family Court, which includes the Family's Magistrates Court, adopts a participatory approach to problem solving, and its design and layout reflect this. Madam Speaker, in those courts, parties sit at a rectangular table with the Family Court judge or the Family Court magistrate. It adopts a participatory approach, which is exceedingly important because of the huge emotional investment attached to these relationships. The Family Court has access to the same support services as the Family High Court. It is fair to say that the 15,000 or so family applications made in other magistrates' courts should have the benefit of being heard in a similar court setting. They should be heard, Madam Speaker, in a family court. Based on these figures, it is not difficult to imagine that the number of children affected by family breakdown is significant. It is therefore crucial that divorcing couples or parties seeking custody, access, or maintenance arrive at decisions concerning the welfare of their children in an environment that is designed to achieve this. Madam Speaker, family conflict is not the same as conflict between strangers. And the dedicated family court to resolve family conflict should be an important and essential part of the judicial system in Trinidad and Tobago. Madam Speaker, given the foregoing, it is important that the family courts be staffed by trained and experienced judicial officers and that the law provide for this. In this regard, clause 10 and 12 of the bill provide that family court judges and masters must be suitable to adjudicate in such matters by reasons of their special training, experience, and temperament. Madam Speaker, the aspect of temperament is crucial. You could have all the degrees and all the qualifications in the world. If you don't have the right personality or the right attitude, you will still make a mess of it. Madam Speaker, these attributes, together with the social support, counseling, mediation, and the other adjunct services of the family court will ensure the best possible outcomes for the parties and for their children. This is important not only to the families involved and the children of those families, but also to the society at large. Since the effects of family breakdowns spill over into wider society, whether in school, the workplace, or the community. And every day we see the effects of this by the rising crime and the level of violence in our communities. Madam Speaker, families make up the fabric of a society, and we depend on families to raise children. Children who come out to be good citizens. Children who come out to be citizens that make a meaningful contribution. In turn, when breakdowns occur, families should be able to depend on society and on the state to provide the support needed so that post-breakdown families continue to participate in their children's upbringing in a positive way. Madam Speaker, crucially important also is that this bill, at Clause 11, provides for applications for protection orders under the Domestic Violence Act to be heard in the family court. Applications for protection orders where the child is a victim or an affected bystander will be heard in the children's court. Domestic violence has been plaguing this society for a very long time. Levels continue to remain unacceptable despite efforts of successive governments and civil society to eradicate this scourge. Recent media reports also reveal that extreme brutality is frequently associated with domestic violence. The Office of the Prime Minister, Gender and Child Affairs, and by extension this government, recognizes that eradication of domestic violence with its deep complexities requires a multi-dimensional and multi-sectorial framework that will facilitate increased social, political, and economic freedoms and rights for women and girls. Indeed, in this regard, several initiatives are being pursued by Gender and Child Affairs. The Gender Division has developed, as I would have mentioned earlier, a national strategic action plan for ending gender-based violence, which addresses domestic abuse and other forms of violence against women and children. An initiative that has been supported by the Entity for Gender Equality and Empowerment of Women, UN Women. The Gender Affairs Division is also preparing a national communication strategy for the prevention of violence against women and children with the support of the Pan-American Health Organization. Madam Speaker, in addition, a domestic violence registry which will harmonize and analyze data across key state and non-state agencies involved in data collection will be launched by the Gender Affairs Division in a very, very near future. The registry aims to develop profiles of victims and perpetrators with a view to effectively allocating resources and developing targeted programs and projects to eradicate domestic violence. It is important, it is very important for victims to also utilize the court in order to obtain freedom from the abusers, both for themselves and for their children, Madam Speaker. Access to justice is a critical component of the National Strategic Action Plan for ending gender-based violence, and we are on top of it in this government. At present, victims are required to file the applications for protection orders in a magistrate's court, the exception being the family magistrate's court, where only applications connected to family matters such as custody may be filed. Madam Speaker, statistics published in the annual reports of the Judiciary of Trinidad and Tobago reveal that a significant number of persons seek the protection of the Magistrates' Court under the Domestic Violence Act. For example, the law term 2012 to 2013, 2011 to 2012, and 2010 to 2011, applications for protection orders filed in magistrates' courts were 11,382, 11,627, and 11,984 respectively. For the 6-year period 2007 to 2013, a total of 69,941 applications were made in these courts. And as mentioned, Madam Speaker, these figures exclude the applications filed in the family magistrates' courts. Madam Speaker, while criminality is frequently associated with these applications, applicants are nevertheless seeking civil protection, and the vast majority seeking this form of protection is or were in intimate relationships. Indeed, research conducted in 1996 to 1997 by Mindy Lazarus Black on the implementation of the Trinidad and Tobago Domestic Violence Act of 1991 revealed that the vast majority of applications were made by women against their married or unmarried partners. Madam Speaker, anecdotal evidence suggests that these findings may still be relevant today. While Lazarus Black's research also revealed was that the majority of applications were dismissed. Madam Speaker, when I made the earlier point about people could have the qualification but not having the temperament, it comes back to this. Note, most of the applications were dismissed. While the family court is not a specialist domestic violence or family violence court, the family court envisaged by this bill, which is trained judicial and other personnel, will be better able to respond to domestic violence applications and to meet the needs of victims seeking its protection. Madam Speaker, that is commendable. In addition, domestic violence is frequently associated with divorce, custody, and maintenance matters. And these matters will be heard in the Unified Family Court, resulting in improved quality of referral, access to services, monitoring, case coordination, and case management. Madam Speaker, the family court should also permit closer tracking of domestic violence cases and result in improved data capture and outcomes. Disaggregated by sex, age, relationship to perpetrator, and other demographics, this will permit analysis of the domestic violence central registry and lead to better understanding of why the majority of applications do not result in protection orders. Bearing in mind that both factors, intrinsic and extrinsic, to the justice system are implicated. This should result in improved targeting of our resources. At present, the court statistics collected are limited to the number of applications made and the number disposed of. Madam Speaker, I now turn to the children courts as proposed under the bill. As noted earlier, the bill is also creating a subdivision of the High Court to focus exclusively on children matters through the establishment of a children court. The definition of children matters specified in the bill gives an insight into the scope and importance of a specialized children court. Not only will the children court have jurisdiction to deal with children in conflict with the law, but will also oversee a range of other children matters, including children in need of care and protection, children mental health matters, children who have a history of alcohol or substance abuse, application for protection orders on behalf of a child under the Domestic Violence Act, and matters in which a child is required to appear in court. Madam Speaker, there may be some differences in scope of the Children's Court in other jurisdictions, such as Australia, the United States, and England. But the common thread throughout all of these is juvenile justice. Some jurisdictions have widened the scope to include child protection matters, as is the case with the bill under consideration. The concept of juvenile court for hearing and determining criminal matters involving children is not new. It was implanted and repealed in the 1925 Children Act and is repeated at Section 81 of the Children Act 2012. Juvenile courts also exist in most, if not all, Commonwealth Caribbean countries, and in one form or the other in many other jurisdictions. The concept is nevertheless significantly developed and refined in the bill in order to give proper effect and meaning to Section 81 of the Children Act 2012. A major refinement is that the court hearing these matters will be a subdivision of the Family and Children Division of the High Court, with trained and experienced judges and masters with temperament to adjudicate in children matters. Training, experience, and temperament of judicial officers, as well as the staff, as outlined at Clause 26, 28, and 31 of the bill, are crucial in order to give effect to the rehabilitative and restorative principles underlying the juvenile aspect of the children courts, and which are also key underlying principles in the Children Act of 2012. The bill before this Honorable House seeks to modernize the approaches to juvenile offending and reoffending in keeping with international best practices and research. Additionally, the Children Court will also have available to it specialized services which focus on juvenile restorative practices, including the support of duty counsel, children's attorneys, children's probation officers, and other psychological and social services with the goal of preventing juvenile reoffending and offending. Unfortunately, Madam Speaker, recidivism is a feature of juvenile offending in this jurisdiction as it is in many others. And a court dealing with juvenile justice matters must be equipped to prevent reoffending at all costs. Within recent years, the number of young people committing crimes has increased, and it is clear that the justice system and the traditional punitive approaches have failed to deter our young people from the allure of a life of crime, as highlighted on a regular basis in both conventional media and social media. Madam Speaker, the importance of preventing juvenile offending and reoffending in our society cannot be overemphasized. Children do not become offenders overnight. There are a plethora of factors that lead to first-time offending, and a children court with trained and experienced judicial officers radically shifts the emphasis from a punitive approach to one emphasizing rehabilitation and restoration, approaches which have had successes in other jurisdictions. Children must not fall through offender cracks and remain there, whatever may be the reason for the first time that they would have gotten into that situation. The implications are too grave for us, it is too grave for our nation. And it is therefore critical that the necessary resources be deployed to rescue them, turn around their lives, and help them to become productive citizens of this nation. This government understands this and will do all in its power to achieve this goal, Madam Speaker. That is a guarantee to the people of Trinidad and Tobago. The Children Court, with the necessary resources as envisaged by the Family and Children Division Bill 2016, will play a crucial role in ensuring that our children do not fall through the cracks. Madam Speaker, I also wish to highlight another important development reflected in the Family and Children Division Bill 2016 as it relates to juvenile justice, and this is the restorative practice of peer resolution. Peer resolution is a voluntary restorative justice concept whereby children participate in a court-like process of assessment to recommend sanctions appropriate to the offense committed by a child offender. It is a new concept to Trinidad and Tobago, but it has been tried and tested in other jurisdictions, and it is variously known as teen court, youth court, or peer court, whereby young offenders are held accountable by their peers. Again, this is a concept which is in keeping with international trends and best practices. Madam Speaker, programs incorporating this concept have been implemented in several states of the United States of America, as well as other countries, as mentioned, to reduce future recidivism. The manner of implementation in each country may vary. For example, in some countries, the programs may be used as a diversionary program before the child even interacts with the court, as in the case of Barbados. In others, the programs may be court-annexed and used as an alternative dispute resolution mechanism, as is being proposed by the bill before this Honorable House. Peer resolution relies heavily on the transformative power of positive peer pressure, which can propel delinquent youth to law-abiding behavior. Madam Speaker, the checks and balances proposed in the bill will ensure the worthiness and robustness of the peer resolution program. Madam Speaker, in the first place, as provided at Clause 40, peer resolution is a court annex, which means that the referral comes to the court only if the child enters a plea of guilty. Further, the court can only refer such a matter with the agreement of the child and the consent of the guardian. However, where the child agrees, but consent is withheld by the relevant parties, the court may nevertheless refer the child to peer resolution, where the court considers it to be in the best interest of the child.
The minutes have expired. Might I inquire how much longer you will be?
Not very long, Madam Speaker.
Okay, so you may continue.
Madam Speaker, I'm really proud of the fact that the peer resolution process was piloted. And in October 2015, schools in Tobago took part in that process. And I'm really proud to say that 2 schools in Tobago East benefited. Students from Roxborough Secondary and Mason Hall High School benefited from this training. Madam Speaker, the Family and Children Division Bill 2016 further strengthens the rehabilitative justice landscape for child offenders by providing for a children drug treatment court process. A judge or master will preside over the process, thus ensuring judicial control, and will be assisted by an interdisciplinary children drug treatment court process team. Madam Speaker, this is revolutionary for our time, and I'm really proud. Madam Speaker, drug treatment courts offer an alternative to incarceration and generally combine judicial supervision, mandatory drug testing, increasing sanctions, and treatment to help substance abusers, offenders, or even non-offenders break the cycle of addiction and avoid the crimes that tend to accompany such addiction. In Trinidad and Tobago, most young persons remanded in custody for drug-related offenses tend to be charged with possession rather than possession for the purpose of trafficking, suggesting that many have been abusing the relevant drugs or experimenting. Madam Speaker, it makes no sense for us to send a young person to jail for approximately 9 months. 9 months is an entire school term. 9 months is a large chunk of a child's life for a drug offense when they could get the right treatment through counseling and support from a judicial framework, Madam Speaker. That is why this bill is so important to me and to others out there who care about nurturing our nation's future leaders. Madam Speaker, as I close, I just want to speak to both sides of the House. my very honorable friend and member for Princess Town would have gone into a lot of politicking. Madam Speaker, there's a time and a place for everything. Madam Speaker, the time in this honorable house was to focus on a bill to change the lives of our children and to create a judicial framework to improve Trinidad and Tobago. Sometimes we need to put the politicking aside and do the work that the people elected us to do. We are here, Madam Speaker, we are here to serve. We are here to serve the people who elected us, and we should do it, Madam Speaker, without party and politics constantly being a factor, but people being a factor, Madam Speaker, and the work that we will do once we do it, Madam Speaker, in earnest and in truth and with dignity, we could create a better Trinidad and Tobago and honor the Father who put us here to serve. Thank you, Madam Speaker.
Members, it's 4:27. Might I suggest we suspend now for 30 minutes?
This has been a presentation of the Parliament Channel and Parliament Radio 105.5 FM. You're viewing the Parliament Channel 11, also broadcasting on 105.5 FM.
This is surreal. You dream it, you plan it, and now democracy becomes a living reality.
I, Jared Anthony Seeley.
That's it. My decision is made. After so many years debating and public speaking in secondary school, agitating in UB Guild on campus, and through our youth pressure group, I have to stop just talking about change and be the change. Come to think of it, I'm going to radicalize this place. I wonder if that's even really a word. Radicalize. I think I'll use it in my campaign slogan.
Taking this away, I send me this, you know.
That's what
Hey,
where's
the scene? Right.
The scene cool, but you know I intend to change that.
Change? You're not trying to change the status quo. Rest up now. How many various issues we try to bring up with our youth?
A few.
Has it gotten us anywhere?
Yeah, but
disillusionment, man.
check us. We're all at our first jobs, and we've already realized that we can't change anything. So much for shaking things up, eh?
Look, I'm not saying change happens overnight, and no one can see into infinity.
True.
But I can certainly try to take charge of my destiny. And maybe by doing so, influence a few others to join me in creating some sort of change.
Right, right. You advocated and you manifest destiny. But what Google it now is when somebody advocates something in the belief that it's best for everyone, like your partner, Ayanna.
Jared, you have things to do, places to go, people to annoy.
Yes, I do. But you know people like me. It's my charm and my intellect, which makes me a perfect conduit to effect change. You all know this, which is exactly what I intend to do by stepping into Parliament as a new member of Parliament for Shagarama Central.
Conrad, why would somebody want to become a political candidate?
My initial response is they don't, but having regard to what occurs, I think that as a candidate, you have a responsibility to your constituents. You have, in some instances, 20,000 people that you have to speak for, that you have to represent. And that's a responsibility that people don't understand. My experience has been that candidates basically are people who can win a constituency. And to win a constituency, it means that you would have had to have a background in wanting to help people. And usually that is what comes to the table. I want to help people. I understand what their needs are. I keep talking to them all the time. They think that they could trust me. And therefore, if somebody says that, listen, I want you to represent me, then I say, okay, can I get the support?
But Kevin, certainly the whole notion of someone running as a political candidate under the banner of a political party means that to some extent they would need to subsume their personal convictions and projects that they have for themselves as individuals. How do you see that working?
Well, the fact is candidates very rarely win a constituency. It is the party, and therefore when the party is choosing a candidate, they're really looking at someone who will not offend or lose them votes according to the sensibilities of who they're trying to appeal to. So in that context, it's really a matter of choosing a candidate who already, I think, mostly agrees with the party's philosophy and approach, or really has no problems with the party's problems.
This house has 2 voters. This person's going to need assistance. She'll need transport on the day.
And this elector wanted a tree trim there, the branches that touching the electricity line.
Now guys, take careful notes. I don't want to forget what I promised. Okay? Good morning.
Good
How are
morning.
you?
I'm good, thank you.
My name is Gerald.
Hi,
Very nice to
Gerald.
meet you.
Nice to meet you.
I appreciate your vote in the upcoming
Not
election.
a problem.
Thank you.
Good luck.
Hi, good morning. How are you?
I'm fine, thank you.
Very nice to meet you.
Nice to meet you too.
That was a long walk.
Boy, have a new respect for candidates now, yes?
I have a new respect for MPs. I mean, trying to listen to as many constituents as possible and then attempting to fulfill all their needs, that's a monumental task.
It's you who signed up with it, though.
Politics chose me. You know I've always championed causes and ran for office at Students' Guild and social organizations. Yeah. So my commitment to improving people's lives is my raison d'etre.
His reason for being there.
Practicing for Parliament.
No, I genuinely want good for my country and its people, as cliche as that may sound.
What happens then is that you go into the constituency, you convince people that this is who I am. You may not know me, but I will represent you properly. And then on that basis, during the election process, if sufficient people think that you are okay, then you are elected and you get into the parliament. Now, once you get into the parliament, it is expected that you would represent their interests. Now, being in parliament and being in government are 2 separate things. Being in parliament means that you have the final say in the laws of the society. You also have the final say in representation, because your constituencies' voices, their concerns, the issues that are important to them are represented by you in that forum.
And what happens when the aspirations of your constituents collide with the broader national agenda, Kevin?
Well, then always in our political culture, the party takes precedence. And what Conrad said is technically correct, but not so in practice, in the sense that what the party wants, there's no separation between constituency and government, or parliament and government, because nowadays, with a small size, every MP gets appointed to be a government minister. The only way they don't is if they fall out with the political leader.
Yes, but the appointment of a cabinet position does not guarantee anything. Because if you think about it, when you get into government, you have a structure of expenditure. So when you get into government, you know that there's $9 billion worth of costs related to salaries and wages. There's $9 billion worth of costs related to debt repayment. That's $18 billion, it doesn't really matter. So when you are a minister, for example, and you're a minister of works, it means that your budget and what you can do is constrained by the amount you have. And therefore, the ability for the constituents to get what you want as a result of you holding office is usually not something that happens very easily. You really have to go and negotiate. You have to make friends. You have to ensure that you could do a better job than everybody else in looking after your people.
Okay, guys, guess what? I have the figures from our sample survey. And guess what? We're trending well.
Ah, boy! Well done. We're doing good.
Yeah.
Well, good.
I still want us to concentrate on these areas though, because if we look at the previous statistics, it's polling division 1789, 2112, and 4753 that attracts the most swing votes.
Brendan, let me see that. But we walked these areas 3 times already.
Yes, and we'll walk it again, and again, and again. A candidate must walk his constituency 3 times. First, to make initial contact. Second, to reach those that we've missed the first time. And the third time, to solidify voter acceptance. So we're behind.
But by your logic, that means it's 5 times in the critical polling divisions and 3 times in the rest of the constituency?
No sacrifice, no victory, Gerard.
Speaking of being victorious, though, I wanted us to check the EBC's website. They have a section on the electoral process.
I'm a bit absorbed right now in reading the standing orders of the Parliament and the Constitution. Like I said before, I have a new respect for parliamentarians.
You know, I wasn't really aware of how detailed the functions of the Parliament are. Or for that matter, the function of an MP.
Yeah. I always thought you just convince people to vote for you, you win, and then you enter Parliament and talk now and again.
Actually, the work begins almost immediately. First, you must establish a constituency office, attend orientation in Parliament, then learn the basics of creating legislation, and start lobbying your parliamentary colleagues. Because to deliver to your constituents, you have to be able to lobby the government ministers in the various ministries.
For box trades?
Box everything. Debating is one thing, you know, but forming alliances and networking is a whole different political ballgame.
As well as an independent MP, I also have to ensure that I can successfully negotiate with the leader of government business and the chief opposition whip.
Let's hit the trail again. Yeah?
I wouldn't mind if it was a trail to Maracas.
With big and shark.
Let's look at election polls now and surveys. In some parts of the world, the UK most recently, polling got a bit of a bad name because of the inaccuracy, the patent inaccuracy of what the pollsters had to say. What role do polls play, and do you think they're an effective way of really gauging where political parties stand in a campaign?
I think polls help you to identify how your strategy should be shaped. But like everything else, if the society is very uncertain, and that is evolving as time goes on, you are going to see that reflected in polls changing. I think in the case of our society today, and certainly in the case of the England experience, there was a level of uncertainty about the decision-making process. People were going to be swayed on the basis of evidence, on the basis of likes, all those kind of things. And I think that that is what is reflected in the poll. So that the poll really is simply something to guide you, to tell you where you have to go and what you have to do. If you look at our situation, for example, and you see the parties changing strategy, that would be as a result of polls, because polls really tell you what people are thinking. I don't think polls could tell you with some certainty what the results are going to be,
but it tells you as you are going along the way, what are the hot button issues, what are the issues you have to take to look at, where your campaign is going good, where your campaign is going bad.
Kevin, your take on polls?
No, polls have been improving constantly, and I think the British thing was really an exception to the rule. So in terms of accurate forecasting, but Conrad makes an important point there. The importance of polls now is how do you shape your strategy, because you link your poll results to new psychological techniques which have been experimented on in other cultures, but you can extrapolate here a lot of the time and shape your strategy that way. The unfortunate thing about that is that it then deals with people's kind of psychological buttons rather than issues and actual implementation of policies and so on.
This is overkill. Why do I need a matrix rollout to plan my every move and activity? Just examine it, Brenda. Advertising and marketing campaign, media talk show schedule, walkabouts and cottage meetings, a manifesto, a pamphlet, t-shirts, flyers, banners. Next, you'll include a campaign song with a video and have a music track while I'm walking.
Yes, Gerard. Trust me, all of this is needed. Don't you want to communicate your message effectively?
Of course.
Aren't you vying for political office? Let me tell you something that you already know. Becoming an MP starts by campaigning and outlining your vision. And in our Westminster system, it's not just about connecting with people and sharing that vision. There's a competitive element to it. And that's where the candidate with the best and most effective plan pulls ahead.
Like you said, I already know this, but my concern is the cost, Brenda. This plan is too costly.
Welcome to the real world. You have to spend to win. If not your own money, you need to attract investors. Let's say you become Prime Minister. You're going to have to sell TNT. You have to have that core ability to attract investment. You have to sell TNT.
Prime Minister may be a bit far-reaching. Let's stay focused on my immediate intention, getting into Parliament.
Understood.
Good. So, let's also limit the scripted talking points. I know how to articulate my vision in the way that I want to. I intend to be a parliamentarian that debates, not just reads from a piece of paper. You wait till I'm an MP in the House of Representatives.
And you will be. Meanwhile, let's stay on message.
And matrix.
Conrad, what's your assessment of the conduct of campaigns, political campaigns in Trinidad and Tobago?
I think that we are in transition. I still think that the question of do you play to the audience in front of you and get them really excited, or do you actually talk to the undecideds in the society who really want to hear a different message? I think that the traditional parties, their bases will support them in spite of, but the way the society is becoming more, with more individuals wanting to understand what is it that you propose to do insofar as quality of life issues are concerned, I think that is going to change significantly in the future, the way campaigns are being held. If you look, for example, today you'd see there's a lot more conversations with people. And the reason that these conversations are taking place is because people really want to understand what it is you're going to do. You have major issues. You have issues in this society about revenue, aging population, the economy, the whole change in terms of our competitiveness, productivity. These are real issues. And people want to understand, well, how are you going to solve these problems? Because we can understand the problems because we went to school. We're educated.
Kevin, do you agree that the campaigns have this sort of agenda-setting value?
No. At this stage, not. I think that they're still appealing to the lowest common denominator in many ways. But the question of the undecideds is key. You have to profile these people. Only one pollster has done this so far, and he has found really no substantive differences between what we call the floating voter and the usual traditional voter. So there'll need to be more polling of this group, and in terms, particularly their presence in the marginal constituencies, and then maybe what Conrad has spoken about in terms of more dealing with issues, agendas, and so on, we'll see more of an emphasis on that because you're trying to court those people.
Every election, the political parties put out manifestos. do they have any impact, you think, in the final outcome of the elections?
They must, even if it's just because people are bad talking them. So what the manifesto does, it really gives people a kind of concrete printing now that they can comment on and cite and so on. So it's going to have some effect. What that might be, I have no clue, nor does anybody else. I will say that the proofreading has improved, so I'm happy about that.
Conrad?
The danger, that's correct, but the danger in that is this. Political parties put out manifestos. Some people don't look at it. But once the party wins the election, it assumes that it was based on the manifesto. And then usually what they do is they say, okay, manifesto is now government policy. So we put it in the parliament, we say, okay, this is what we will do, and we start to move to implement things that nobody in the country has taken time to look at. So while it is true that during the election process, the election period, people don't spend a lot of time understanding what manifestos say. When you get into government and you are seeing the implementation for the very first time, you say, but why are we doing this? Why are we building smelter? Why are we doing it? Well, it's in the manifesto. And to the extent that you are elected and you think that the manifesto is what caused you to be elected because you have superior policies to your opponents, then the country goes down in a particular place and, you know, we have all the dissonance that we currently have in the system.
But is it really true, Kevin, that people call parties to account on the basis of their manifesto promises?
The manifesto, certainly for me, and I think for many other commentators, is a useful whip. Because then you can say, but you said so-and-so. Why are you not doing so-and-so? Yeah. These were your promises. Yeah. And so in that sense, the manifesto, it's better to have it than not have it because it makes, it commits the politicians to something.
But the manifesto is also for the next election. Because when you go back to the population, you say, hey, what? I told you I was going to do all of this, and I've completed 99.99%. So it means that if I have a record of performance, then you should elect me because I am going to perform for you in the same way I've performed over the last period. So it has a value in terms of how you validate what you have been able to accomplish to the population.
On that note, I want to thank you very much for joining us. Kevin Baloo-Singh, Conrad Enel, thank you very much.
The Honorable the Speaker.
I, Jared Anthony Seeley, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter. Congrats. All right, that was a long one.
You'll speech tomorrow. Good.
Nice to meet you. Nice to see you. Congrats. Congrats. Congrats, love. Congrats. Congrats.
Good thing all that walking done now, eh?
Agreed. Less walking now. More talking. Dreaming convinces us that we know our path in life. But even I didn't foresee such a clear path to Parliament. No doubt my conviction to create a better world by impacting people's lives positively led me to this moment. Here's to Jared Seeley, the parliamentarian. Let the work begin.
Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament.
Join us on Monday, March 14th, 2016 at 9 a.m. as we observe Commonwealth Day here on the Parliament Channel. Students from schools throughout Trinidad and Tobago have been invited to listen to a presentation by a member of the Diplomatic Center of the University of the West Indies on the topic An Inclusive Commonwealth, Trinidad and Tobago's Role in the Commonwealth. This will be followed by a question and answer session. You can also view the live stream of this program at ttparliament.org or tune in to Parliament Radio 105.5 FM. That's Commonwealth Day, Monday, 14th March 2016 at 9 a.m. The Red House, situated in the heart of Port of Spain, has a legacy as the home of democracy in Trinidad and Tobago and contains within its walls a remarkable history. The historical significance of the building was further enhanced when, during recent restorative works, there was a discovery of archaeological relics and even evidence of indigenous burials. In order to preserve this history, careful consideration was given to the renovation of the building, which led to the Restoration Committee employing the services of an American architectural company to carry out specific restoration and preservative functions on the building.
Evergreen is a specialty contractor based in New York City in the United States, and we specialize in the restoration and conservation of decorative arts in buildings. So we work on ornamental plaster, decorative painting, works of art such as murals on canvas and on walls. We've worked in Port of Spain at Queen's Royal College, and recently in the United States we've worked at the U.S. Capitol and the United Nations building. What's interesting to me is that the red plaster that's at Queen's Royal College is here at Red House, and it gave this building its distinctive red color before it was painted over. Our objective is to determine historic colors used in the interior of the building, and that would include paint on plaster and possibly wood, or we found that a lot of the wood surfaces were originally stained or clear-coated, so you're meant to see the grain of the wood. And we're also tasked with understanding the exterior color scheme, basically anything having to do with the original color of the building as it was articulated after 1903. So for the finishes analysis and determining the historic colors, we use two main techniques. One is collecting paint samples from the walls and ceiling and other features, and we'll examine those to determine the different color schemes over time. And we also conduct what we call exposure windows in place. And an exposure window is when we remove layers of paint a bit at a time so we can see on the wall what different colors and finishes were placed. Another goal of this project is to preserve the plaster molds that were created previously by Evergreen. In the south chamber, the ceiling was dismantled and the ornamental plaster pieces were cast, meaning we made replica molds, I should say, for those pieces so that in the future we can cast replicas of pieces that have been damaged and then place them back in the south chamber exactly as they were originally. I think the most interesting thing about the Red House to me is the exterior red plaster. The red color you see today is achieved through multiple layers of paint, which has a tendency to fade over time as any paint will. But the red color that this building has was originally imparted by a very deep red plaster. It's very beautiful material. The next step for me is I examine the paint samples under the microscope and I cut them in cross-section, and that way I can see the paint layers one over the other, so I can determine what colors were used over time in the Red House.
The Red House Restoration Project has uncovered many
Honorable Speaker.
The member for Couva North.
Thank you very much, Madam Speaker, for allowing me the opportunity to present on this bill. And Madam Speaker, we would have heard the Honorable Attorney General pilot this bill in the House today, and we would have heard from my honorable colleague and Member of Parliament for Princestown when he also spoke on this bill and of course identified in the first instance that this bill was drafted and done under the People's Partnership Government. And I think that by itself is an indicator, Madam Speaker, that we were very serious about the citizens and taking care and protecting the citizens of Trinidad and Tobago, and by extension, leading by example to the wider Caribbean region. Madam Speaker, I myself served for a year as Minister of State in the Ministry of Gender, Youth and Child Development. And it is very unfortunate, Madam Speaker, that when this government came into power on September 7th, one of the first actions by the Prime Minister and the Honourable Member for Diego Martin West was to dismantle the Ministry of Gender, Youth and Child Development. And I think the citizens were up in arms about this because this particular ministry was created, again, to deal with the protection and rights of our children, our women, and by extension, every single citizen in Trinidad and Tobago. And the major influencing factor behind that was because over the years we saw an increase in crimes against our children, against our women, and it continues to go up to present time, as we have been seeing in the media. Madam Speaker, so we have seen the dismantling of the Ministry of Gender, Youth and Child Development with their units going into different ministries, and we were very thankful to see that opposition just did not come from us, but it came from the public, and there were calls from different stakeholders and different interest groups, those from the academia, those from the NGOs, CBOs, that this was a very important ministry to dismantle, and being one of the first actions of the Prime Minister and that government, it really did not bode well for them. So, Madam Speaker, as I move on, I just also want to quote from a research note from the Ministry of the People and Social Development in January of 2014. And in one of his editorials, "Save our children, 38 children murdered, baby beaten to death. We are treating our children like trash." And these were just some of the editorials that we were seeing over the past years in news reports and of course on print media. And it was because of this, again, under the People's Partnership Government and under the leadership of the Honourable Kamala Persad-Bissessar, the first female Prime Minister of Trinidad and Tobago, we were really on the move and on the path to create an establishment and to create a way forward in dealing with all protection for our citizens of Trinidad and Tobago. Now, the member for Tobago East spoke about the ramifications of the bill with respect to the Family and Children Division bill going to the High Court and all of that. And she was very much into the operations of it, and I will talk a little bit about that also a little later on. But what it is that we need to identify, Madam Speaker, is that our children, they are the future of this country. We need to take action in terms of protecting them, and we have been taking actions to protect them. And in one of the recommendations, it was, of course, one of the requirements, it was identified that a special task force or the Child Protection Task Force be formed to deal with these abuses against our children and child homicides. So in 2014, under the previous government, a special unit of the Trinidad and Tobago Police Service to address issues of child protection and family violence was established. And the then Prime Minister, the Honourable Kamala Persad-Bissessar, was presented with the second report of the Child Protection Task Force, which she appointed in December 2013. Other recommendations of the task force, Madam Speaker, included the implementation through the Ministry of Gender, Youth and Child Protection of the National Children's Register to keep statistical track of all children from birth to early childhood. The reassignment of regional health visitors to concentrate on community work and monitoring the physical and mental development of all children, especially those at risk from birth onward. The upgrade of professional services for counseling and remedial work for traumatized children in all schools to help prevent bullying and disruptive behavior, and the establishment of the Office of a Children's Ombudsman and the integration of the Ministry of Justice draft policy on a youth justice system to deal with the special needs of children who contravene the law. At that point in time, Madam Speaker, the Prime Minister also announced that Cabinet had approved the drafting of legislation to support the operations and regulation of the Children's Authority community residences and foster care homes. It was also highlighted at that special meeting that the Children's Authority has now recruited 41 out of an expected 97 people in critically important positions, and we were, of course, in the move to fill in these vacancies. In another report, Madam Speaker, and this came from Sharifa Abdullah Ali, one of the directors of the Children's Authority, she also reiterated last year that over the last 6 months alone, with the operationalization of the Children's Authority, they had dealt with more than 2,500 cases of child abuse, averaging between 400 to 500 cases per month. And around 150 of these cases were emergency cases, Madam Speaker. So it is, of course, very critical, and it was at that time and continues to be very critical for us to deal with the protection of our children and women. And she went on to say, Madam Speaker, that sexual abuse accounted for 22% of the cases, while neglect and physical abuse cases were also common. And in Trinidad and Tobago, the level of violence and the kind of cruelty against children we are seeing is very alarming. And this, I'm quoting what she had said. She said, we are getting cases of parents who are burning their children's hands on hot stoves. There are parents who are beating their children to a pulp using a rolling pin and other instruments, she said. She said some children were beaten mercilessly to the point where medical attention was necessary. Some cases have involved children being denied food or given dog food to eat. We have found children, including babies, in human filth. And it is very, very alarming and very, very concerning that the kinds of cases that are coming to us, it is a disturbing trend. And again, at the end of that media conference, the media was, of course, encouraged to continue to cover cases like this to raise awareness. So, Madam Speaker, coming out of these reports and all of the thousands of cases before our time, this is where the operationalization of the Children's Authority and other pieces of legislation to enable, now we are seeing here, the Family and Children Division at the High Court was implemented under the previous government. And I don't think, Madam Speaker, that we can ever be accused of neglecting and ignoring the people of Trinidad and Tobago and their plight. I don't think, as a previous government, that we can ever be accused of that. However, we are seeing today, and my colleagues made mention of it, we are seeing today where the Honorable Attorney General and member for San Fernando West failed to act, as in my humble opinion, failed to act to deal with the expediting of money from the Children's Life Fund to deal with saving babies' Miracle life. And Madam Speaker, information has come to me, Madam Speaker.
48.6, the Attorney General does not administer the Children's Life Fund.
Member, again, I will caution you. A similar type of statement was made prior by another speaker. And I would ask you all to be very cautious. And I just want to, for the purposes for everybody else who would speak on this, to remind members of Standing Order 55B, which speaks tedious repetition of either one's own argument or that of a previous speaker.
Thank you, Madam Speaker. let me just also add to that, that as the Member of Parliament for San Fernando West, he is yet to make a statement apologizing or even showing mercy or giving apologies for the death of baby Miracle. And that is all I have to say.
Madam Speaker, standing order 48-4. 6. What does the Honourable Member of Parliament have to apologize for?
I would really refer to Standing Order 48-1 with respect to relevance and ask the member, please, to relate her comments to the bill that is before the House.
Thank you, Madam Speaker. So we are speaking about children and children authority and protecting our children and saving the lives of our children. And therefore, Madam Speaker, new information that has come to hand that I also want to mention here in the chamber is that one of the reasons, and we are being told one of the reasons that there was a delay in the access of funding from the Children's Life Fund was that there are 2 directors of the Children's Life Fund board who had resigned. Is this true? And is it because of the poor response to Baby's Miracle request because of these resignations from the Children's Life Fund board? So I think that the Minister of Health has a little bit of explanation to give us probably later on or otherwise, or probably the Member of Parliament for San Fernando West. In his winding up, he can tell us on this package of legislation for children and the protection of children whether or not this information is true and whether it would have hampered the process of accessing that life-saving fund for Baby Miracle. So, Madam Speaker, I continue. In addition to that, Madam Speaker, we have seen, and it's not a trend, but it is really very important to note that with the massive job losses taking place, we have seen that CSO sent out a bulletin just this week. 8,000 persons now unemployed in Trinidad and Tobago from September 7 to now. 8,000 persons unemployed. And we all know that high unemployment rates lead to high crime. And when we have high crime, the family unit is affected. It is fractured, it becomes broken, because now you have breadwinners and home earners who are unable to find funding to earn money to take care of their children. And this sort of stress relates and trickles down to the children of the home. And when they go to school, they may behave in a violent way, they may behave in a violent manner. Probably that is one factor that has influenced high violence and increased violence in schools. We don't know. It's a measure that has been put forward. It's a factor that has been put forward by those from different schools of thought. And Madam Speaker, it is very important that the government of the day creates the enabling environment to allow for our children and for all citizens of Trinidad and Tobago to flourish even under harsh economic times. It's very, very important. And I must say that after 6 months in office, we have not seen that type of action. There was just a poll run recently, Madam Speaker, and I'm talking about the performance of the government and the impact on children in Trinidad and Tobago and the impact on the family unit in Trinidad and Tobago. And there was a poll run on one of the media stations where they asked, are you satisfied with the government's performance after 6 months? And it was, of course, in their polling, 65% was not happy. 65% of the population was not happy with their performance. And then we have the Prime Minister coming on TV and saying, he is satisfied. Again, the public has sent a message to this government that they need to tie their bootstraps, pull it up, and get to work. The member for Laventille West likes to throw talk sometimes, Madam Speaker. I have written to him 10 letters on behalf of the constituents of Couva North. 10 letters. And Port of Spain South has gotten over 30 letters from the Member of Parliament for Couva North asking
Speaker,
and begging them to assist. Madam Speaker.
Member, and I will give you a little latitude, but please tie the point to the bill under consideration.
Madam Speaker, and I was about to do that before. Exactly. So, Madam Speaker, when I speak about the government creating an enabling environment, I'm speaking about infrastructural development that will enable families to enjoy a better standard of living. I am talking about the Minister of Housing giving families who deserve housing so that they can afford a better standard of living and build that home around their children. So when as a Member of Parliament, I represent at least 28,000 constituents in my constituency, Madam Speaker. I am writing on behalf of the persons who put me there, who elected me into office. And if it is we have ministers of government who cannot even respond via letter, what does that say for the government and by extension the country? When we were in government, Madam Speaker, we responded to every or most of their requests. I was, and I can speak for many of my colleagues, Madam Speaker, but there is no respect for the sitting Member of Parliament to even respond via letter to some of the concerns that we send across to them. In the interest of family and holistic development of the family in Trinidad and Tobago. So, Madam Speaker, and you know, these things are very important because whilst we come here to the Parliament and we are elected members of Parliament and we come here to make policy, make legislation, pass bills so that we can, you know, continue to improve the lives of our people in Trinidad and Tobago, there are other mechanisms and strategies that the government can also implement to make the citizens of this country feel safe. So as ministers of government and MPs themselves, I am really experiencing as a Member of Parliament inequality in the distribution of resources at this point in time. And that is the truth, Madam Speaker. And I speak with conviction and I speak from experience. So my appeal actually here today, and you know, just this morning I was on the media making an appeal also to the Minister of Social Development for food cards for the poor and impoverished. After 6 months, constituents of Couva have not been able to receive food cards for those who have applied to the Central Regional Office. And these are very impoverished families with children, single mothers with children who go out there, who come to my office, apply for the food cards. We send in the forms to the central office. We're calling, no feedback. And then we're writing letters to the minister, no feedback. So I have to take it to the media to represent. And you know, Madam Speaker, we owe a duty of care to the citizens of this country. A duty of care because we are all elected. And it is really embarrassing as a younger Member of Parliament to be writing these letters. Every Tuesday when I go to my constituency office, Madam Speaker, there are about 15 of them. It's housing, it's employment, it's social development, food cards, it's water, it's a host of issues. And, relax. So, Madam Speaker, at the end of the day, what I am saying is that when we do our jobs as elected members of Parliament and we depend on the government of the day and these ministers of government to distribute the resources like we did when we were in government, and it's
Madam
not
Speaker,
forthcoming.
48-1. How is that linked to the bill?
I am linking.
And member, while I understand we have different styles, I would hope the link will be made soon.
Yes. Thank you very much, Madam Speaker, for understanding where I'm coming from. And therefore, Madam Speaker, my point is, if we are talking about serious legislation, trying to protect our children, continuing the good work of the People's Partnership with respect to families in this country, there are other strategies that the ministers and the government also needs to implement to create the enabling environment for it to be workable, Madam Speaker. And this is my plea as a Member of Parliament to these ministers and members of Parliament themselves also. So please, respond to the Member of Parliament for Couva North, write me letters, tell me what the problems are so I can explain to my constituents. So, Madam Speaker, I will continue. So, Madam Speaker, we are talking today about the Family Children Division Bill, and let me also reiterate the call from the opposition that we here have agreed and decided that we would like to see this bill go to the JSC, the Joint Select Committee, for further work dealing with the different amendments that the Honorable Attorney General spoke of today. Now, Madam Speaker, in addition to that, in a Newsday article on Thursday, May the 21st, 2015. And that was a red letter day for the People's Partnership Government because that was the day that the Children's Authority came into force. And it was something...
I know we might have a little heightened energy because of the tea, but I would like to hear the member for Couva North, please. Continue, please, Couva North.
Thank you very much, Madam Speaker. So on Thursday, May the 24th, 2015, the Children's Authority was launched at the Hyatt Regency Dock Road, Port of Spain. And this was a red letter day for the People's Partnership Government. And the minister at that time, the Honorable Minister de Cotto, indicated that the Children's Authority will both be responsive and proactive to the needs of children. He continued to give and to speak about the mandate of the Children's Authority, and I quote from him, "The public can be assured that there will be a mutual relationship between the Children's Authority and its clientele, as well as the rest of the society. This will ensure a high level of quality service by the authority," the minister said. He noted that on May the 18th, 2015, it was also a historic day for the children of this nation. And he continued to explain the purpose of the Children's Authority. He said that the President of Trinidad and Tobago on that day proclaimed the Children's Authority of Trinidad and Tobago, and it would be the new children's protection system which will be fulfilling the needs of the children in the need of protection in a holistic and comprehensive matter. De Cotto said the authority will be focusing on children and their families. Family reintegration is the overarching philosophy of the authority and accords with the government's commitment to family and family life. The principle that a child is best placed with a family will be facilitated through adoption and foster care, both of which are now the responsibilities of the authority. And he went on to explain some of the workings of the authority that citizens would have been privy to in the coming months. And again, Madam Speaker, it just shows the commitment of this government to take the protection of our children to a better place. Now, this Family and Children Division Bill, Madam Speaker, will put in place a judicial structure that completes the placement picture. The intention of this is that the Family Court Project before has been functioning in Port of Spain since May of 2014. It deals with a wide range of family matters including divorce, maintenance, custody, care and control of children, and access by children to parents. It is essentially a civil court, and of course it is explained in our version of the 2015 bill that the 1925 Children's Act enables a parent, guardian, or person with responsibility for a child to come before the magistrate's courts and claim that the child is beyond control. In practice, this has meant that such children are often placed in the same institutional care as children who have been charged and convicted of a criminal offense, despite the requirements in the legislation that the two groups should not mingle. And because of this, Madam Speaker, in 2012, the Children's Act was introduced, and a far wider range of order that the court may make in relation to a child offender with greater focus on rehabilitation and diversion from criminal activities to activities that may assist in the child being redirected. Madam Speaker, the bill also speaks to the Family Court Committee, which was established in 2002. The Family Court Project resulted in the Family Court being opened in May 2004. And of course, with a discretion vested in the Chief Justice and the Rules Committee. Madam Speaker, the direction that the court is going to be given to apply the family proceeding rules, they are very innovative. Most importantly, it is a solution-oriented or problem-solving court, and it is focused on customer service. The environment has been designed so that it does not increase the tension most people experiencing in attending court would encounter. The hearing rooms are small and private. The judicial officers wear court jackets rather than robes. Hearings are by appointment rather than all being fixed for 9 a.m. There are social workers and mediators employed by the court, and there can be referrals for investigation on family conditions, counseling, or a workshop on co-parenting. There are small meeting rooms where attorneys may meet with clients. There's a nursery where babies and small children may be left, and it is staffed by professional caregivers. There's a waiting room for youths, Madam Speaker, with access to books and computers. There's a specialist family law library, and some resources are available even without litigation, where we have members of the public also attending to be trained. Madam Speaker, it should be noted also that the bill being considered would build on that experience, not only formalizing the family division of the High Court, where the family court will continue to function, but also by creating a children's court that will function as the children division of the High Court. Madam Speaker, both courts are to understand the needs of the children, but in the context of the children court, there is likely to be a greater emphasis on the needs of children who may present as traumatized, and on making a connection between those children and the support services that should be accessed on their behalf. Where children are charged with criminal offenses, the children court will be fully aware of the range of options open to it and craft an order that will do most good. In addition to that, Madam Speaker, the new child protection system is managed by the Children's Authority of Trinidad and Tobago. The importance of the family court is very critical to the workings of the Children's Authority. And it was seen in 2001 via the Family Court Bill, which of course lapsed, but then it was really the intention of that bill to ensure that the family court operate adequately with other pieces of legislation in the legislative package, that is the Children's Authority Act, the Children's Community Residences and Foster Care and Nurseries Act, the Adoption of Children Act, and the Children Act as amended. Madam Speaker, and I know that the Honorable AG in the piloting of his bill spoke about consultations, new consultations that was had, and we are a little bit confused about these consultations with respect to who were the stakeholder groups, that these stakeholder consultations were held. When were these consultations held? Because it would have been in our best interest also as an opposition to be invited to these consultations so that we could have also given our views and opinions on the amendments that the Honorable AG spoke about. So we would really like to find out about these new stakeholder consultations that he said took place. Madam Speaker, in addition to that, children matters are very extensive, and therefore a lot of training has to go into the court practitioners in order to deal with this. Clause 27 reflects novel approaches to reducing and preventing recidivism. And of course, we refer to the Peer Resolution Center Coordination Unit and the approaches outlined at clauses 38 to 41, whereby first-time offenders charged with a minor offense and admits guilt may be referred to court-annexed peer resolution with the agreement of the child and the consent of the parent or guardian or person with responsibility for the child. The approach taken here, Madam Speaker, according to the Children's Act of 2012 and also in keeping with the modern principles articulated in the CRC, which Trinidad and Tobago has ratified, and other international documents such as the Beijing Rules and the Riyadh Guidelines, young people, of course, are our future, Madam Speaker, and adhering to these international agreements, we are able to come up with this new bill. Madam Speaker, I crave your protection for the Member of Parliament of Diego Martin Northeast, please.
Do you know you quoted? Our members.
Exactly.
Members, as I indicated before, we might be a little energetic, but please allow the member for Couva North to make a contribution, which I think would be of invaluable assistance to all of us. Continue, please.
Thank you, Madam Speaker. Madam Speaker, with the development of this children's court, we can expect to see similar development of a new practice area and new professional specialization. Family lawyers will be interested because they have always practiced with the welfare of children being a paramount consideration, and criminal lawyers should welcome the new focus on rehabilitation and redirection designed to keep young people out of the criminal activities that have brought them to the court. This new system, Madam Speaker, would no longer have conviction and sanctions as its primary purpose once there is a child involved who may be able to be guided back into the more morally responsible society that does not embrace crime. And, Madam Speaker, as in the family court, access to social services, training and counseling will be an important issue to be dealt with. The development of this new legislation, Madam Speaker, and the new children court provides a hope for a future where even the children who have made errors...
Remember, your 30 minutes have expired. You're entitled to a further 15 minutes. Would you like to avail yourself of it?
Just
yes?
A couple
minutes. So
minutes.
you may continue.
Thank you. So, Madam Speaker, I was talking about the new legislation and the new children's court, which, of course, will serve to provide hope for the future where even the children who have made errors, who have never enjoyed a nurturing home life, can still be seen as valuable resources who can benefit from special attention and assisted in overcoming the situation that has brought them into contact with the court. Now, Madam Speaker, again, I want to reiterate that the amendments...
Standing Order 4410, the AG was pulled up on this recently.
Member, would you kindly continue? I would ask you to be guided by the fact that it's a debate, and therefore, while you can refer to notes, you can't read extensively.
Thank you, Madam Speaker. All right. Madam Speaker, I would just simply like to state it is a complex bill, and there are specialities and operations that it's including in the bill that we have to speak about. I mean, come on, they go Martin Northeast. Try to deal with the economy. Anyways, Madam Speaker, thank you very much for understanding. I will ignore Diego Martin Northeast and his ramblings. Madam Speaker, in ending, I would really like to say that in support of the 2015 version of this bill, the opposition supports the 2015 version. We have decided as an opposition that we would like to see this go to a joint select committee. But the purpose of this bill, Madam Speaker, is to continue the good work of the People's Partnership Government so that we can see that our citizens, our children, our women, our men, well protected under the establishment of Trinidad and Tobago. It is very important, Madam Speaker, in the face of high unemployment, rampant crime. I think it's more than 90. The first few months of the year, it's more than 90. We say that this may be a record-breaking year for murders and crime in this country. We hope not. We hope that the government has the testicular fortitude under the Minister of National Security to deal with rampant crime. We have seen the effects. We have seen the fallout effects on our children. We have seen what is taking place. We are also seeing that with the increase in food prices, Madam Speaker, that it is not going to be an easy task for the government and by extension the citizens of this country to reconcile the fact that whilst we have high crime, whilst we have high unemployment, now we also have increasing food prices that we have to deal with. And I would also reiterate the call of the opposition, both in and out of the chamber, Madam Speaker, that VAT, the timing was all wrong on food prices. It was all wrong, and therefore the government needs to relook and take a look at that in the midterm review. Madam Speaker, before I sit, one more thing I would like to say. The Attorney General of this country has a very important task ahead of him. He is very much responsible for the legislative agenda, for putting forth a legislative agenda to the House that we are yet to see. He is also very much responsible for ensuring that through his office and his actions that we see a better standard of living and protection for our citizens. And I was very disheartened as a younger member of Parliament in recent times to see this fiasco with the Malcolm Jones case. And really, Madam Speaker, I am ending.
48-1.
Madam Speaker, I am ending.
48-1.
Members, We are all very familiar with the standing orders. 2 members cannot be standing at the same time, and when one member stands on a point of order, the member on his feet or her feet should take a seat. So I hope we will remember those rules as we continue in the debate. Member, I would ask you to withdraw the statement and please continue in the few minutes you have left.
Thank you, Madam Speaker. I withdraw that statement. In winding up, Madam Speaker, again, I would reiterate that the Attorney General of this country has a very important job to deliver to the people of this country, especially in the face of high crime, high unemployment, and otherwise. We are very much concerned for the children of this country, and therefore he has a huge task ahead of him. So far, he has failed, Madam Speaker, and therefore I make a call today in this chamber that he himself needs to pull his bootstraps up and do the job that is necessary so that our people can enjoy living in Trinidad and Tobago once more. Thank you very much, Madam Speaker.
The Minister of National Security.
Thank you very much, Madam Speaker, for the privilege to participate in this debate on a topic that strikes at the core of our very development, Madam Speaker. Madam Speaker, the family is the foundational unit of any society. It is in fact the smallest unit, but it is a unit that is there to build and weave the fabric of a very society. It is where we plan, it is where we prepare, it is where we program our children to live a life of productivity and live meaningful lives, Madam Speaker. Madam Speaker, permit me to make a quote from the Ministry of Healing by Ellen White, page 202, and she states, "Society is composed of families, and it is what the heads of families make it, the heart of the community, and the church and of the nation. Thus, the well-being of society and the success of the church, the current and future prosperity and national security of the nation depends on the home and the influences, Madam Speaker, and of course the family structure." Madam Speaker, this government has demonstrated by bringing this bill to this House in the first 7 months of its existence the importance of family, Madam Speaker. I've heard the member of Princestown and the member for Couva spoke a while ago, and they went back into some history. They went back into the antecedents as to what the then PP government did. Madam Speaker, they had 5 years with which to bring this bill to this August House. They did not do so. They did it, Madam Speaker. They allowed that bill to lapse, Madam Speaker. And therefore, we are not going back into 2015, Madam Speaker. We are dealing with 2016. The 2016 bill, Madam Speaker, that this government that cares about people, this government that cares about children, this government that cares about family, to make it so important that they feel that in the first 7 months that they must bring this bill to this House, Madam Speaker. The first 5 months, Madam Speaker.
19 was in one.
And this is an evidence, this is a demonstration of a government that cares. This is a demonstration of a government that understands family and family values, Madam Speaker. Madam Speaker, the Family and Children Division Bill 2016 seeks to make jurisdiction for all family matters and children matters to be held at the divisions of the High Court. It deals particularly with 2 different divisions, Family Court and Children Court. Madam Speaker, when one looks at the bill, one understands the issue of family matters, the issue of civil matters, it in fact has implications to national security, Madam Speaker. It in fact tells us that it's a showstopper with respect to national security. When one understands that in today's world, there are several issues pertinent to children and incidents of crime against children. The importance of bringing this bill to this House is clearly demonstrated by this government, Madam Speaker. Madam Speaker, this bill is designed to remove the intimidated, adversarial, and combative nature that has become commonplace in addressing family matters and children matters before the court. Within recent times, Madam Speaker, there has been an increase in the amount of children before the courts of Trinidad and Tobago. This has caused concern for the Ministry of National Security and for the wider society. This government understands the multidimensional nature of crime, the multidimensional nature of security. And so, any endeavor to treat with these issues must be multidimensional in scope and application. And so when we look across the spectrum, the idea of bringing this bill to this parliament is a government's demonstration. The government demonstration, Madam Speaker, that we are taking care of family and children in this society of Trinidad and Tobago, Madam Speaker. Madam Speaker, with respect to the Ministry of National Security, Ministry of National Security stands ready to render support to give effect to this bill through the institutional strengthening of a number of its agencies. The Trinidad and Tobago Police Service, Madam Speaker. The Police Service Act was amended with respect to disclosure of fingerprints and photographs with respect to children. The Trinidad and Tobago Police Service, only yesterday, Madam Speaker, this government have approved the establishment of the Children Protection Unit, the Child Protection Unit, Madam Speaker. That Child Protection Unit, Madam Speaker, is a unit that is there to treat the incidents of crime against children. It will be staffed throughout the 9 divisions throughout Trinidad and Tobago, Madam Speaker, so that in every jurisdictions, the 8 in Trinidad and Tobago and the 8 in Trinidad and 1 in Tobago, Madam Speaker, there will be dedicated police officers, a dedicated structure to treat the incidents of crime against children, Madam Speaker. That, Madam Speaker, is the trust of Ministry of National Security. Madam Speaker, when one looks at the probation services, which is now under the Ministry of National Security, the Act has been amended to treat the Children's Probation Officer, Madam Speaker. The Trinidad and Tobago Prison Service, Madam Speaker, another entity under the Ministry of National Security. The Young Offenders Detention Act has been amended now to read the Child Rehabilitation Center, Madam Speaker. So as we see, Madam Speaker, the implications and the trust of Ministry of National Security in treating with crime and criminality against children. Madam Speaker, under the Family and Children Divisions Bill 2016, reference is made to matters involving orders of children to be sent to rehabilitation centers. Madam Speaker, this is a change from what before was called the industrial institutions. And so it is a recognition of this. And as a recognition of these many issues concerning children, Madam Speaker, that the Ministry of National Security, by way of the Commissioner of Prisons, will take the necessary measures to ensure that institutions such as the Youth Training Center are so structured or so refurbished to treat with the rehabilitation centers, Madam Speaker. These rehabilitation centers are expected to take over, Madam Speaker, in ensuring that the children are placed in the type of institution that do not turn them into what we call hardened criminals, Madam Speaker. Madam Speaker, just today, I had to visit the maximum security prison for the launch of the 2016 pre-release program, Madam Speaker. These are prisoners who have been there in the last 9 months, who have volunteered to be part of that program to re-educate them, re-engineer them into society, Madam Speaker. One of them gave a testimony, and that testimony, Madam Speaker, speaks to his involvement in crime from a very tender age, Madam Speaker. From a very tender age, he went to that institution. Madam Speaker, if one looks at the issues in this bill, had that bill been enforced at that time, Madam Speaker, that gentleman would not have gone past. He would have been treated at a very tender age, Madam Speaker. Then the institution would have been in place so that he would not have become the hardened criminality was today. That was his testimony, Madam Speaker. So those are instances, Madam Speaker, that this bill is very important insofar as dealing with crime from a very tender age, Madam Speaker, because this is what we have in our system as we progress into the more advanced prison system, Madam Speaker. This is the importance of this bill. Madam Speaker, as can be evidenced in our society today and in the media, there's a growing trend in juvenile criminality and violence at schools. In fact, only recently we had a situation at Shogunas North Secondary School where 20 students, Madam Speaker, were suspended. Madam Speaker, when one look at the behavior of young people now in our society, there must be measures that are put in place to treat at a very early age. And therefore, Madam Speaker, this bill, which speaks to an issue of corrective actions, is very important in treating crime as it progresses in our society, Madam Speaker. Madam Speaker, if there was a time to adopt corrective, rehabilitative, and restorative measures to stem this type of spiraling violence, it is now, Madam Speaker. The time is now. And this measure being adopted in the bill is such measure to stem that tide, Madam Speaker, at a very early age. This, Madam Speaker, is the bill that is placed before us by this caring government. Madam Speaker, the proposed bill before this House will seek to address the problems encountered in the field of child justice as it exists within the framework of current legislation. Specifically, Madam Speaker, the Family and Children Division Bill 2016 will secure to the best interest of the child as well as protecting the rights of the children accused of committing crimes, as well as regulating the system whereby the child is dealt with and ensuring that the roles and responsibilities of all those involved in the process
4410
are clearly defined.
I'll just caution member in terms of, as I said, you can refer to your notes, but it is a debate. So please continue.
Thank you, Madam Speaker. Thank you, Madam Speaker. Madam Speaker, this bill would ensure Madam Speaker, that legislation will be there to revolutionize the criminal justice system in Trinidad and Tobago as it affects children in conflict with the laws and seeks to, in fact, to make sure the jurisdiction of the High Court is treated with, Madam Speaker. Madam Speaker, the importance of the bill also has relationship to our very Constitution. It has relationship to the United Nations, the 1989 United Nations Convention on the Rights of the Child. So that in putting this bill forward, Madam Speaker, we are also honoring our international obligations. The Declaration of the Survival, Protection and Development of the Children Act, the 1990 World Summit of Children, the Universal Declaration of Human Rights, and of course the International Convention on Civil and Political Rights 1994, Madam Speaker. So that, Madam Speaker, the issue of this bill has not only local implications, but in fact international obligations insofar as our treaty commitments are concerned. Madam Speaker, this bill provides to us a very comprehensive and cohesive system for the management of young offenders. When we understand what is happening thus in this society, Madam Speaker, I say again that the time is now. The time is now for us to treat this issue. As we look forward, as we deal with the issues of crime in our environment, as we look at the increase of incidents of crime between our young people in our society, we must understand that the family is in fact the first crime stopper, Madam Speaker. The family as a unit is our first crime stopper. And if we take measures to treat with that, and one such measure is this bill here today, Madam Speaker, then we understand that the bill, in the way it is constructed, will treat with that at a very tender age, Madam Speaker. Madam Speaker, this bill ensures that children in trouble with the law are afforded protections that are guaranteed to them in the law, as well as creating a balance within the needs of the very community within which they live, Madam Speaker, to ensure the safety and security of society as a whole. Madam Speaker, the 2016 bill takes forward a range of government commitments which are intended to improve services for key groups of vulnerable children within our society. Children in the adoption and care system, those affected by decisions of the family courts, and those with special educational needs, Madam Speaker. To a large extent, Madam Speaker, these are children who progressed into stages of delinquency, and therefore this bill seems to stem that at a very early age. Madam Speaker, the proposed bill contains provisions on a range of policies which span the responsibilities of a number of ministries. And so you will see, Madam Speaker, as the Honorable Attorney General mentioned, a number of ministries are involved in the implementation of this bill. The Ministry of National Security, the Ministry of Education, the Ministry of Social Development. And so what we are seeing here, Madam Speaker, is a policy enunciated by this government and a whole of government approach to treat the issues that confront us. You see, Madam Speaker, this government understands that in treating in this issue insofar as the family is concerned and so far as crime is concerned, no one entity can treat with it. And therefore, this whole of government approach will bring all the issues, social development, sports, culture, national security. And these are the institutions, these are the ministries, Madam Speaker, that will bring to the fore the treated issues as contained in this bill. Madam Speaker, it must be stressed that the enactment of this bill should not be seen as being soft on crime. This is not being soft on crime, Madam Speaker, but it has a very fundamental benefit in treating with the issues of crime. You see, Madam Speaker, today these efforts must be directed and coordinated in such a way that the case of the children, the rights the accused are protected, and steps taken by the state to manage the offenders in a way that will impact on and change behavior patterns to prevent the reoffending. Because what is important here, Madam Speaker, this bill would send a message. This bill will be an act of deterrence, so that in today's sitting, Madam Speaker, the whole questions of consequence to one's action comes into play. To a large extent, what is happening in our society today is an absence of consequence to one's action. And we have seen that happening. We see it being perpetuated to a large extent throughout the fabric of our society, where there are no consequence to our very action. And again, I mentioned my visit today at the prison, where the gentleman who gave his testimony said he was able to get away with a lot of things that he did, so there was no consequence for his action, and he regretted that. He said if only there was someone to correct him, if only he was punished for the events that he did as a child, he would not have been developed to the individual that he was. And so, Madam Speaker, what this bill tends to do, what this bill will be doing, is to act as a deterrent, to provide a certain kind of consequence and action at a very early age in treating with children, in treating with the family, Madam Speaker. And if we can multiply that throughout our society, if we begin to show consequence to very actions, if we begin to hold people responsible for their actions, Madam Speaker, we will have a better society in Trinidad and Tobago, Madam Speaker. And this is what this bill will tend to do, Madam Speaker. Consequence to our actions, Madam Speaker. Madam Speaker, on the content of the proposed bill, they submitted that the changes made to the bill ought to be substantive. Nevertheless, it is encouraging to note that the core essential elements of proposing this bill remains intact and unaltered, and in the best interest of the child, Madam Speaker. Madam Speaker, it is generally taught that the criminal justice system is fraught with delays. In addition, for a child passing through the system, the process can be intimidating and confusing in itself. So, Madam Speaker, this bill, however, set out specific time periods in relation to assessment, preliminary inquiry, and the finalization of proceedings. And it is submitted that these time periods are urgent and necessary, Madam Speaker. So that the time delay in the past, this bill sets out to deal with that, Madam Speaker. Madam Speaker, it must be noted that the proposed bill adheres to the principles that detention of a child must be a last resort for the shortest possible period of time. Madam Speaker, the whole question of mediation, the whole question of counseling, the whole question of treating with the child is an important aspect in going forward. Because what we want to do, Madam Speaker, is to ensure at the end of the day, we do not have people progressing from the child criminal stage to the adult criminal stage, Madam Speaker. That, Madam Speaker, to my mind, is the fundamental purpose of this bill, Madam Speaker. Madam Speaker, investigations have revealed that among the strongest predictors of serious and violent crimes, evident between the ages of 12 and 14, are strong social ties, antisocial spheres, delinquent acts, poor school attitude and performance, and psychological conditions. Madam Speaker, as a society, we have to be able to treat with our children. We have to be able to bring back the issue of value system, Madam Speaker. In other words, Madam Speaker, this bill is just one of many measures that have to be adopted in curbing the direction in which our delinquent youths are heading at this point in time, Madam Speaker. And so, what is important for us, together with that bill, is to ensure in our society we bring back the value system, Madam Speaker, to know what is right or wrong in our various decisions and what we do, Madam Speaker. And so, Madam Speaker, serious interventions are required, Madam Speaker. Serious interventions that is legislated here today, as the bill being ushered by the Attorney General, Madam Speaker, to address multiple problems, including law breaking, substance abuse and substance use, academic and family problems. Madam Speaker, this bill, in its manner in which it is being presented, with the two separate courts, one dealing with family matters, one dealing with children matters, would deal specifically with these issues, Madam Speaker, in a way that has never been done before. Madam Speaker, this bill will change the way we do business. This bill would usher a different kind of environment for our young people. It's submitted, Madam Speaker, that children need a suitable yet serious intervention. In other words, Madam Speaker, we have to be able to not spare the rod and spoil the child, Madam Speaker. Madam Speaker, the real attempt at any rehabilitation must be done in a very structured manner. Real attempt at restorative justice must be done in a very structured manner, Madam Speaker, in order for young people to be reintegrated in society, in order for them to understand the consequence of the actions. The government must be able to shape that, Madam Speaker. And so this bill today, this bill of 2016, is precisely doing that, Madam Speaker. This bill, this bill is designed to ensure that our children, our future, Madam Speaker, is taken care of. Our children, Madam Speaker, given the kind of environment and the kind of directions and the kind of learnings to ensure that they become productive in our society in Trinidad and Tobago. Madam Speaker, the Ministry of National Security supports this bill in its entirety. This is a bill with which will need all of our support, Madam Speaker, in order to be effectively implemented. The Ministry of National Security will strengthen our institutions and operation areas, our policies and our programs to give support to this bill. In particular, Madam Speaker, we'll concentrate on our youth programs. We'll ensure that our youth programs, such as the Civilian Conservation Corps, the military-led academic and training, our mentorship programs, our cadet force, our youth clubs, the police youth clubs, the fire services youth club. And within those institutions, Madam Speaker, we plan to strengthen our value system. We plan to ensure that they understand their contribution to society. We plan to ensure that they understand consequence of negative actions. We plan to make them understand the power of choice, Madam Speaker. And so, in terms of the Ministry of National Security, we, Madam Speaker, will play our part in strengthening this bill, in ensuring that we contribute significantly to ensure that this bill is implemented effectively and efficiently. Through our own institutions, through our prison system, we're going to focus on preventative measures. We're going to focus on rehabilitation measures for persons who have entered into our prison system, Madam Speaker. The Ministry of National Security is in fact strengthening the prison system at this juncture, Madam Speaker, to ensure that once individuals have returned to society, they will be rehabilitated, Madam Speaker. We have also to ensure that the infrastructure that we have designed is there to cater for the children at large, Madam Speaker. The Ministry of National Security has collaborated with the judiciary in developing an operational juvenile court, which will be toned and designed to address the youth, Madam Speaker. Madam Speaker, our very police service that interface with the youths on a daily basis within the various communities. I've already mentioned the establishment of the Child Protection Unit. But Madam Speaker, we are at the moment giving effect to the sexual offences, especially against children, in terms of establishing the sexual offences registry, Madam Speaker. That, Madam Speaker, should be in place in the shortest possible time, Madam Speaker. Excuse me. Madam Speaker, violence can take many different forms. And the Ministry of National Security will not support any type of violence. There will be institutional strengthening to ensure no power is abused. The Ministry of National Security will introduce the Police Management and Inspectorate, which will improve efficiency in the Trinidad and Tobago Police Service, to increase engagement and improve interaction with the public, thereby building confidence and trust. Madam Speaker, the Victim Support Unit will continue to provide support to the victims of crime and their families, especially with respect to children. Madam Speaker, the Ministry of National Security will continue to use its resources to address the issues in schools, assisting our colleagues in the Ministry of Education, assisting our communities, assisting our colleagues in the Ministry of Community Development. The Ministry of National Security will use all the agencies available to it to ensure that this bill, to ensure that issues pertinent to children, issues pertinent to incidents of crime against children will be dealt with in an effective and efficient manner. Madam Speaker, we also look at areas of the Immigration Department with respect to the deportation of families, Madam Speaker, and the effect it has had on children. We have seen incidents of where parents have been deported for one reason or the other, and the effect of children in our society. So with respect to that area, Madam Speaker, the Ministry of National Security is looking at ways and means to ensure that any such action does not have the effect on the children that will contribute to a life of crime, Madam Speaker. Because deportation breaks families, and in fact, they have a different effect or negative effect on our very community. Madam Speaker, as individuals face deportation, there are ripple effects that split families apart. Deportations have a large effect on families, Madam Speaker, that force them to a large extent in the foster homes, etc. So that even our Immigration Department, there are measures that we're putting in place to ensure that what actions we take do not in any way contribute to a life of delinquency and crime, as so far as our children are concerned, Madam Speaker. Madam Speaker, when one looks at the bill being introduced today, we look at some comparisons. We look at areas that have introduced bills before, Madam Speaker. When we looked at areas in the United States, we look at areas in Canada, we look at areas in the United Kingdom. Madam Speaker, between 2015 to now in the United States, 3 such states has passed sweeping juvenile legislation. Madam Speaker, allow me just to capture just the heading of those 3 states, just for the benefit of this House, Madam Speaker. South Dakota passed the Juvenile Justice Public Safety Improvement Act, Madam Speaker, making several significant changes to the state juvenile justice system. The new law increases diversions, alternatives, to expand the use of evidence-based community programs and provide more comprehensive support for youth and their families, Madam Speaker. Madam Speaker, West Virginia passed the measures informed by the Intergovernmental Task Force on Juvenile Justice. It places truancy diversion specialists in every county to provide early intervention services, Madam Speaker. Madam Speaker, Illinois eliminated the automatic transfer to adult court for children aged 15 and under. Madam Speaker, the United Kingdom, Children and Families Act 2014. On a comparative note, like Trinidad and Tobago, the United Kingdom Landmark Children and Families Act 2014 received royal assent according to the UK government, thereby allowing Children and Families Act 2014 to become law. Madam Speaker, fundamental to this law is that it imposes a 26-week deadline for care and supervision proceedings. It introduced a controversial new subsection to Section 1, adding a presumption of parental involvement. Madam Speaker, what it did is to ensure that parents, Madam Speaker, are also part and parcel of that law. Parents are held accountable, Madam Speaker. And I think there's some teaching there for us, Madam Speaker. Because when we talk about the family, when we talk about dealing with children, to a large extent, we do not hold the parents accountable, Madam Speaker. And it's important in going forward that this bill holds the parent accountable, Madam Speaker. Because at the end of the day, the parents are the head of the household. The parents are responsible for the children. As we say, Madam Speaker, there are no bad children. There are bad parents, Madam Speaker. Because we are the ones who are responsible to a large extent for the behavior of our children, Madam Speaker. Madam Speaker, Again, if you permit me, Madam Speaker, to read from the UK Children and Families Act. And it says, to give greater protection to vulnerable children, to give better support for children whose parents are separated. What it deals, Madam Speaker, is the instances where parents are separated and the effect on the children. And it ensures that even though you are separated, you are still responsible for your children, Madam Speaker. These are some things that we have to take on board, Madam Speaker. For far too long, we have seen situations where in our society, where parents are separated, and the effect it has had on our children. We can show the number of effects that have led to children getting involved in crime and criminality, Madam Speaker. So what this UK bill that we can take from that is to ensure that we hold parents accountable. Even if they are separated, Madam Speaker, they are still the parents, and they're still very much responsible for the activities of their children, Madam Speaker. Madam Speaker, permit me to quote from Edward Timpson, Children and Families Minister, who said, the Children and Families Act is all about reforming services for vulnerable children. And he said, this government's deep determination to give every child, whatever their start in life, an equal chance to make the best of them, Madam Speaker.
Now remember, your 30 minutes have expired. You're entitled to an additional 15 minutes if you wish to avail yourself of it.
I'll take part of that, Madam Speaker. Thank you very much. Madam Speaker, I draw again another example, permit me again, from the Family Justice and Civil Liberties Minister Simon Hughes, who said, we are making sure the welfare of children is at the heart of the family justice system. When cases go to court, we want them to happen the least damaging way. So we're improving processes, reducing excessive delays. We have also changed the law so that care cases must be completed in 26 weeks, Madam Speaker. Madam Speaker, I think there are learnings for us. In going forward with this bill, we want to ensure that it is dealt with as quickly as possible, especially when you're treating the children, Madam Speaker. We know of a lot of delays in our court system, Madam Speaker. We know of situations that go for years. Some months ago, I visited the remand yard, Madam Speaker, and had the opportunity to speak to some of the inmates there. People there in our judicial system, Madam Speaker, as much as 10 years, as much as 16 years, without their matters being completed, Madam Speaker. We can't allow that to happen to our children, Madam Speaker. They cannot be allowed to be able to stay in that system without their matter being tried with. So I am saying, Madam Speaker, going forward, that this bill would ensure a speedy resolution, Madam Speaker, especially with issues dealing to family and children, Madam Speaker. Hence the reason that I am supporting this bill, the Ministry of National Security is supporting this bill as it moves up to the High Court level, Madam Speaker, and more importantly, the separation of the two matters would ensure a speedy resolution of these issues, Madam Speaker. This bill, Madam Speaker, will change the way that we do things, Madam Speaker. Madam Speaker, the government of Trinidad and Tobago is determined to enable all children and all families and all young people to succeed no matter what their background, Madam Speaker. This government wants to give families freedom to manage the care of their children and balance their work life, Madam Speaker. To address the disadvantages faced by our most vulnerable children and young people, this government is reforming the children's services, providing better support for our children and for our caretakers, Madam Speaker. Madam Speaker, the aim of these reforms is to ensure that services consistently place children and young people at the center of our decision-making, enabling them to make the best possible start in life and challenging any dogma, delayed or professional interest which might hold them back, Madam Speaker. The Family Bill 2016, Madam Speaker, with a twin focus on vulnerable children and strong families, sits at the heart of these ambitions, Madam Speaker. This measure, though the measures will improve services for vulnerable children and transform the special educational needs system, Madam Speaker. This government commitment to promoting the children's rights is a thread running through this bill, Madam Speaker. Madam Speaker, this is a government that's shown its care. This is a government that brought this bill in the first 5 months, Madam Speaker. It did not wait. It realized and recognizes the importance of the family in our society. It recognizing the importance of security in this country, because there is a nexus between this bill and national security, Madam Speaker. This is a government that cares. This is a government that understands security. This is a government that thinks about people, Madam Speaker. And so, Madam Speaker, I say to you, this government will continue to do its best for the people of Trinidad and Tobago. I thank you very much, Madam Speaker.
Member for Naparima.
Thank you very much, Madam Speaker. I listened intently to my friend, a gentleman for whom I have tremendous respect, Point Fortin. I could not help but feel listening to him that his heart is in the right place, but he's in the wrong party. A party that I had the good fortune to leave 35 years ago. And perhaps you will get the enlightenment at some time. You see, this bill was introduced into the Senate. There's a 2015 version that was introduced into the Senate and then subsequently came to the lower house where it lapsed. And President Reagan made a comment that facts are stubborn things. They don't go away. So when that bill was presented in the upper house, the former Senator Elton Prescott had this to say, and I take your leave to quote a little bit because it is very, very important to the point I want to make. He said, and I quote, "Very importantly and very controversially, there has not been any improvement or enhancement, if you like, in the facilities provided in formerly called homes." And I'll just one more line. "I understand that we are still limited to St. Jude's for girls and St. Michael for boys. And I understand that girls in particular have problems at 13 years mixing with people, 18 years, fast-tracking their development in a negative way. So one of the consequences of this, if we are interested in really rehabilitating our young people, is to, and Senator Prescott made the point, we have to improve the facilities, in particular St. Jude's School for girls and St. Michael for boys. But guess what? Guess what? Facts are stubborn things. I go to the estimates of expenditure. For the St. Michael School for Boys, this was this year, right as we talk, hot off the press. St. Michael School for Boys, revised estimate for 2015, 10.1 million. 2016 estimate, guess what? 10.1 million. Not a cent increase. And you come and tell us that we have a legislation that's going to channel people into this rehabilitative center and that the budget remains the same. But it gets worse. It gets worse. St. Jude's Home for Girls, it was 10.1 million. It is now 8.5 million. You have cut the thing. And now you are saying that this is going to be part of your redemption for young people and illustrative of your concern for young people. But throughout the budget, and money talks, you could say anything you want. And if you do not budget for it, then it won't happen. We look at probation services, adoption board. What was it? 100,000 last year, 100,000 this year. Nothing. No increase. We contemplating legislation, and we're not budgeting for it. Relief for underprivileged newborn. 10 million, 10 million. The adoption board expenses, the same thing. But foster care expenses, no increase. Children Authority, 30 million, 30 million this year. So where is the seriousness? So a point that was raised in the Senate has not been addressed. Yet we talk about caring for the children and those who have fallen afoul of the system and fallen through the cracks. But my friend from San Fernando West, he had this to say. Facts are, as again I say, facts are stubborn things. He had this to say, and I quote again. So we say in Section 5 or Section 6 of the Supreme Court of Judicature Act that you may have a certain maximum number of judges. But in the same Supreme Court of Judicature Act, all right, which the bill treats, we say you can have a minimum of 2 masters, but we do not state a maximum. Why are we putting a maximum for judges in the subdivision? Does it make sense to do that? Why not put a minimum standard as we have in Section 65B of the Supreme Court of Judicature Act? The only problem is that in this bill that he has presented to us, he has specified in section 4, yes, so 4, subsection 3. The division shall comprise up to 22 puisne judges and up to 28 masters. So here you made a statement, and then in a matter of months, with no doubt with the advice and support of your colleagues and the new environment, you have changed your mind. But the more critical point in terms of that was raised was in respect of, sorry, I'll get it at this point. It was raised by the honorable member for Port of Spain North, St. Anne's West at that session. And he said, how are we going to fund this whole exercise, this whole court? Because I know how expensive it is to fund a judicial system. And we are creating a number of offices in 2 new divisions, a family division as well as a children division for the High Court. And we are having deputy court executive, administrative, and other subordinate staff. And he went on to say, I was raising these concerns, and it is directly linked to the passage of a bill which is going to require, by his guesstimate, tens of millions of dollars on an annual basis to be successfully operated. We are operating, according to him, in an environment now where every day more and more red flags are going up in respect of problems with the economy. And as usual, we hear all kinds of problems. But essentially, his concern was, where are we going to get the money to fund this expensive exercise we have of developing a family and children division of the High Court? At the time when he made that comment, the price of oil was, and I take this from OPEC monthly report, the price of oil was $50. And he was asking the question, how are we going to fund this expensive exercise when we have challenges in the economy? And at that time, the price of oil was $50 a barrel. Today, the price of oil is currently at $37.70 per barrel. $38.58. Still, even if I take your figure, admitting but not accepting, I take your figure, then it is still below the 50 figure that the OPEC monthly report said when that statement was made by the member for St. Anne's, Port of Spain North, St. Anne's West. So we have a question of prioritization. While we have no objection to this bill, Madam Speaker, and while we understand and we agree that it should be referred to the Joint Select Committee where it could be looked at in more detail, but yet I am just, one has to ask some questions in terms of where is the money. You see, when we come with bills, as we had with the Children's Authority Act, Act 64 of 2000. You look at section 5 of that and it deals with financial provisions. A completely comprehensive, well thought out legislative document. And in this document that we are presented here, we have to guess. We are hearing there are challenges in the economy. We know there are going to be costs, and there are going to be ancillary costs because we have to recruit a whole group, a whole segment of probation officers and others to support the system. I am told that in the family court, as it exists today, that it takes almost 9 months and counting. And I know of a specific case. It takes 9 months to get a probation report for the family court today. So we have problems in our existing court. They are not well resourced. And the Chief Justice, he was talking about the myriad and plethora of problems with the judiciary. And instead, in my view, of dealing with those problems, because serious people are prioritized. If I have limited resources, what do I create new institutions? at this time when the existing institutions are in problems. So he was talking about the backlog of cases, critical changes required, and this is from the Trinidad Guardian, 10th of March 2016, saying the criminal justice system was in crisis and a leap of faith is needed to rectify it. Nothing should be left off the table. So we have that problem, we have not addressed it, or we have addressed it partially, and we're now creating a new institution that are going to have outputs that are going to be presented to the schools like the St. Jude School for Girls, and we're not resourcing them. We are pitching top in mud. And this brings another fundamental question that we have with this piece of legislation. While it was good when it came when we introduced it, at that time there were different contextual circumstances. Contextual circumstances. It may, for example, the price of oil was much better. We had support systems like the Children Life Fund. We had support systems that for maternity help for pregnant women who had children and were poor. We had laptops in school. All of these things are relevant to this act because it speaks to dealing with a problem. Dealing in a problem in a particular context. Our circumstances have changed. You could laugh, you could deny it, but we all know that it is different, and therefore the question is, where do we put our limited resources? Do we put it in the front end and stop the pipeline and the flow to the court, or should we spend it in the court and have a system that is not working adequately? So our judiciary is failing, and I'm saying you deal with one, you get it out, you improve it, and then you move on to the next. This also, the little concern I have is that it has been introduced in a piecemeal manner instead of a comprehensive package. I'd like to talk a little bit about when we introduced similar legislation. For example, the Children's Authority Bill in 1999. Prior to that, it was the then Attorney General, Ramesh Lawrence Maharaj, who had made comments about a failing system. Ramesh Lawrence Maharaj, then Attorney General, noted, and he was looking at P&M years. This is 1999, and prior to that we had from 1962 to then the P&M, the way they operated did not conduce to dealing with a crime situation that was developing then. He had this to say, and I quote, "The existing pieces of legislation that he met of children's legislation are antiquated and are based on English law of the time. As a consequence of these outdated laws, which deal with our children, and the absence of other laws to deal with other social issues, we are experiencing problems which include growing number of street children, alleged abuse and neglect of children in children's homes." So we still have the problem. "And the unsuitable and unworkable adoption process for the children." So we, the UNC government, in 1999, after holding a number of consultations and whatnot, came up with the Children's Authority Bill, an act to establish a Children's Authority of Trinidad and Tobago to act as a guardian of children, and it had it dealt with the authority will be responsible for providing mechanisms for assuming parental rights and responsibility for children. That bill was introduced into Parliament on the 19th of November 1999 and left to languish under the P&M until it was partially proclaimed by Kamla Prasad Bisesa-led administration in May 2015. You cannot come here, facts are stubborn things. You cannot, we introduced a bill, you came into power, you did nothing, and we had to. Those are facts. The Children's Amendment Bill 1999 was accented to in 2000 because we were then in power. We take action in the interest of the young people of the country. The P&M allows it to lapse. But that is not all. The Adoption Children Bill 1999, an act to make provision for the regulation of procedures governing the adoption of children and to give effect to the International Convention on the Rights of the Child 1990. It was introduced on the 3rd December 1999. And you know when it was proclaimed? After 2 terms of a Patrick Manning government, it was proclaimed on the 18th of May 2015. That is a fact. We take action when we are in power for the young people. And you allow it to lapse, and you come here and boast and tell us that you care, and we're in charge, and we're powerful. And the facts do not substantiate that, sister. You can gallery as much as you want. The Miscellaneous Provisions Children Bill, 1999, introduced on the 19th November 1999, proclaimed in 2000, we did that. And the Children's Community Residence Foster Home and Nursery Bill, 1999, another piece of legislation left for 15 years. It was proclaimed in 2015. So you do not have, you could dance how much you want, these are facts on the table. If you could say that I didn't speak the truth with respect to any of those, then you could talk. If you can't, then you have to accept that the PNM does not have a good track record when it comes to dealing with these issues. And today, they come to Parliament asking us to deal with the Children's Court and have done nothing in terms of the supportive environment, in terms of the education, cutting textbooks, Madam Speaker, and this is relevant. We could say what we want. We're not giving textbooks, and there's an article in Jamaica Observer, because, Madam Speaker, if we treat with our children, if we give them an enabling environment, we do not need to have a pipeline to the courts such as we are developing today. So Jamaica is laughing at us and saying, we have ended free textbooks. A lot has been said today, about crime and how we treat with crime, and of course, this bill is a bill to assist us in respect of dealing, and I say we will support this because it is, well, we had ownership of this. It is better than doing nothing, but we are also saying that it has to be placed in a context and an environment that will help it to function better. But if we think that it is going to assist us in solving crime, it is not going to do so, because and I'm reading from The Guardian. They looked at experts from all over the world. The Guardian is a UK paper, highly respected, almost on par with The Economist. And they looked at 24 ways to reduce crime in the world's most violent cities. And here's one of the first things they said. Intervene early. This act comes at the back end. After they're monsters and hyenas and whatnot, we try to treat with them. And we send them into a probation school and we have drug testing things and DNA and all sorts of things. But they are saying intervene early. We know that a better understanding of the drivers of violence is essential, and that starting interventions early is the best way of treating with it.
For 45 years, intervene early.
They talk focus on prevention. You want to?
Could we have the date of the newspaper article, please?
This article was The Guardian. Sorry. It was The Guardian, and it can be sourced at theguardian.com, Global Development Professionals Network, June 2015. And what it was saying, focus on prevention. So it talks about intervening early, and it talks about targeting inequality. And I'm only saying this, Madam Speaker, in the context of what this bill is trying to achieve. And I'm even suggesting that if we go through with it, we have to do other things to assist in the work. Target inequality. We need to address economic inequality, which I believe is central to reducing crime and violence in the long run. And it goes on to give details about that. But essentially, if we have an economic policy that runs counter to what we are trying to do today, it means that we could jump high, jump low. We'll just create a pipeline into a system that looks at restorative justice, that tries to rehabilitate, cut recidivism, etc., instead of dealing with the problem and preventing the flow into that system. So, Madam Speaker, we support this bill. We look forward to further discussions when it goes to the Joint Select Committee. But we are concerned about the cost implications of the thing, its emphasis on the back end rather than on the front end. We are concerned about the priority with respect to our governance. So if we have a system, and we had a lady, I think her name was Amina Mohammed, whose 2 hands were cut off, and she lived near to my constituency. And we have to look, what are we doing for her children? Because and having an economic policy that leads to a couple making a suicide pact because they can't take the pressure and leaving children behind. If we do not intervene and throw resources at that level, we will just be what we call, what my grandmother used to tell me, spinning top in mud. I hate to be part of an exercise that is involved in old talk. I have few years to live again, and these have to be of value. These have to be of value. Every minute is valid, is valuable to me. So as we sit here and we contemplate legislation such as this, we need to be serious. We need to put resources. We need to create in Trinidad and Tobago an environment where every citizen, because the young people are looking on, and they're looking on as young people, and they're seeing things. They're seeing us cavorting in beaches, and they're saying, that is the life. They're asking me to tighten belt. I will do what I have to do in order to survive. Madam Speaker, I thank you.
Member for Lopinot.
Madam Speaker, it is indeed a privilege to be able to contribute to this debate on the Family and Children Division Bill 2016. Madam Speaker, before I go into my presentation, I would like to treat with a statement made by the member for Naparima. The member from Naparima stood there and he sought to convince this House that the People's National Movement government has done nothing for St. Michael's Home and St. Jude's. Nothing is further from the truth. A team of ministers led by the Honorable Prime Minister would have visited St. Michael's Home. We would have done an in-depth tour, and at the end of that, it was decided that we needed to invest even more monies that were allocated in the budget to bring that up to stand. The Cabinet has since approved those funds and have also approved funds for the St. Jude's Home. Madam Speaker, I would also like to treat with a statement made by the member for Princestown. He indicated that this government would have removed the baby grant. But Madam Speaker, I wish to inform you and this honorable House that the previous administration would have approved a baby grant program for 1 year, and that program ended on September 2015.
Only for election.
Madam Speaker, my colleagues would have spoken at length about the clauses and the provisions of the Family and Children Division Bill 2016. Madam Speaker, so I would try my best to focus on other areas. Madam Speaker, I have a special interest in this bill because of its focus on family and children. The Ministry of Social Development and Family Services is responsible for helping, empowering, and transforming the lives of the poor and vulnerable in our society. And Madam Speaker, there are none more vulnerable than our children. In addition, the family, however defined, is considered the bedrock of our society. It must therefore be strengthened and preserved, and in keeping with this, the Ministry of Social Development and Family Services has as its core mandate the provision of preventive, developmental, and remedial programs and services for healthy family functionality. Madam Speaker, the family is seen as the basic socialization for children because this is where crucial personality formation and social traits are developed.
Well put it.
Parents transmit the norms and values that are important to them, and these eventually influence their children's values and behaviors. Carol Logie and Jaipal L. Rupnarayan in child rearing practices in the Caribbean also found that children learn basic concepts about good and bad from their family. Madam Speaker, despite this, I am aware that there are other factors that influence values. These may include the media, and as we are all aware, if you look even at the way some of our young persons dress, you can tell that it would have been influenced by the American media and what they see portrayed there. We also have the celebrity culture impacting the behaviors of our young people. And what you find happening is that they imitate their style of dress. So at a particular time, the big thing is to have the biggest gold chain or to have a pants dropping all the way down here. Madam Speaker, although there are these other factors, Logie and Rupnarayan have found that the predominantly held belief in the Caribbean is still that children learn their values from parents and family members.
Great researcher.
Madam Speaker, the bill before us provides for the care and protection of children that come before the Children Court. It also seeks to preserve and maintain families through the provision of mediation and counseling and the award of guardianship and adoption in the family court. But Madam Speaker, I am sure we are all aware that families are in crisis in this nation. We have been seeing increases in the divorce rate over time, and that rate has been going up. Now, when we find divorces within the family structure, there tends to be a breakdown, and the family is negatively impacted. We are also seeing an increase in the number of children who are either victims or are brought before the court as accused. So, Madam Speaker, there is no doubt whatsoever in anybody's minds that in Trinidad and Tobago, families are in crisis and we have our young people. And so, Madam Speaker, it is for those reasons also that I strongly support this Family and Children Bill 2016. Given its focus on strengthening and preserving families and caring for, protecting, and giving this nation's children second chances when they run afoul of the law. I believe, however, Madam Speaker, that while these courts perform a critical role, we as a society have to do our part to ensure that the court's caseload do not increase, but rather reduce considerably over time. We must not make the mistake of abdicating our parental responsibilities and expecting these courts to become surrogate. Madam Speaker, we may ask, how do we achieve this reduction? I believe that this can be achieved in part by focusing on families and implementing policies and programs that treat with good parenting practices and championing a collective return to moral and spiritual values.
After that,
Madam Speaker, there are 4 basic types of family structures that affect child rearing, values, and lifestyle in the Caribbean. We have the marital union, we have the common law union, we have the visiting union, and this is where the mother still lives in the parent's home, and we have the single parent family. Messiah 1982 estimates that 30% of Caribbean families live in households where they are raised exclusively by mothers. Single parenthood, especially when the parent is a poor mother, has been singled out in a number of studies as a very important factor in the repression and abuse of children. Madam Speaker, in Trinidad and Tobago, there are too many poor single mothers having responsibility for a child or children. Madam Speaker, I can give this House of an example that I know firsthand. In my constituency, there is a child who is currently in Form 1, and 2 months ago she would have given birth to a baby. Wow. Ladies and Madam Speaker, I say to you that this young lady is neither psychologically nor economically prepared to be a parent. And this is becoming commonplace in our nation. So it is something that we must address. Madam Speaker, the stress and unhappiness that these single parents experience color the interaction between parent and child and tend to lead to emotional problems. This often forms a vicious cycle, Madam Speaker, for when these children become adults or parents, they may have trouble meeting the emotional needs of their families. Madam Speaker, in light of this, we therefore need to focus on the development of programs that would equip parents with good parenting skills. The Ministry of Social Development and Family Services Family Division will play a critical role in this area and will work collaboratively with faith-based organizations, NGOs, community-based organizations, and the National Parent-Teacher Association to ensure that as many parents as possible benefit from these programs. Madam Speaker, when we talk in terms of better parenting, there are some things that must guide parents. Parents need to understand that they are their children's parents and not their friends. But as a parent, there is a role that you perform. You are supposed to guide your children, and there are times you will be required to make decisions that may not be popular. But at the end of the day, as my colleague says, tough love. Tough love. Parents must also at all times profess and exhibit the values that are positive. They must walk the talk, because our children look at us and we cannot be saying to them, you must not consume alcohol, but they see us drinking alcohol. Or you must not smoke marijuana, but they see us doing the same thing. We have to walk the talk as parents, and when we set the example, then our children will follow. Parents should also demonstrate in words and actions that they love and care for their children, and that their children can always rely on them. Parents also have to make time for their children. It is not enough to give them the world, give them material things, but you do not give them time, because that is what they need and that is what is going to be most beneficial to them. Madam Speaker, Proverbs 22:6 states, train up a child in the way it should go, and even when he is old, he will not depart from it. Madam Speaker, as the Honourable Member from Naparima said, we need to start early. And we can start early. We can start early by training our children from the earliest age possible. Because once we train them in the right way, they will not depart from it. Parents also need to adopt and live by values that would make for a better society. And some of these values include, I am my brother's keeper. Respect for everyone, older, same age, every individual. Some of the members in this house who are around my age will remember their parents saying to them, don't hang your hat where your hand can't reach. Live within your means. Do an honest day's work for your pay. By the sweat of your brow you shall eat. Thou shalt not kill, steal, or covet. Madam Speaker, if we live by those values, Trinidad and Tobago will be a different nation. Madam Speaker, imagine the positive impact on our social education, and economic systems if a large percentage of the population of Trinidad and Tobago begins to live by these values. Trinidad and Tobago will well be on its way to becoming a model nation. Madam Speaker, I am realistic and grounded enough to recognize that these desired changes in behaviors will not occur overnight or even in a few years, but happen it will, and Trinidad and Tobago will be better for it. Madam Speaker, I am mindful that there are other areas that can negatively impact the behaviors and development of our children, and Madam Speaker, poverty is one of them. Trinidad and Tobago is generally ranked as a middle-income country. Poverty and inequality, however, remain pervasive challenges. Madam Speaker, the Ministry of Social Development and Family Services has identified poverty as a major barrier, which has adversely affected some parents' ability to give adequate time and attention to their parental duties and responsibilities. We have also found that economic deprivation can lead to stress and depression in parents and ultimately dysfunctional families. That's correct. When there is a breakdown in families, some young men tend to turn to gangs for the camaraderie and emotional support that may be absent at home. Some also join gangs or commit crimes in order to help support their family. Many a young girl has turned to men who provide financial support, and they often become pregnant and experience abuse and or domestic violence.
Thank you for giving me Member of Parliament for Lopinot. I noted your concern about the child in your constituency, but from our research and from the data from CSO, over 2,500 young girls before the age of 19 are pregnant almost on a yearly basis. And the fathers range in the 20s, 30s, 40s, and 50s. And so therefore, can I ask you if you will take it with the government?
I take it you're seeking elucidation?
Yes.
Yes? Okay, so could you please direct the question that you're seeking elucidation on, please?
I'm just wondering what would, based on what I've indicated, would your government be prepared to deal with this issue, which is pervasive now and must be dealt with, even that it impacts upon the education of the children? 2,500 approximately annually, teenage pregnancies.
Honorable Member for Caroni East, I am assured that anything that impacts the children of this nation, this government will seek to take. Madam Speaker, I am convinced that our at-risk young men and women will receive the best support possible if they do run afoul of the law after the passage of the Family and Children Division Bill 2016. But Madam Speaker, as the Minister of Social Development and Family Services, a parent and a citizen of Trinidad and Tobago, I want fewer and fewer of them to reach either the children court or the family court. Madam Speaker, while this country has pursued various approaches to poverty reduction since the Summit on Social Development in 1995 and has increased annual expenditure on the social sector from 8% in 1998 to 28% of total expenditure in 2008-2009, would have allocated over 187 billion for social sector expenditure from 2011 to 2015 and expanded the range of programs, poverty rates have increased by approximately 50% since 2005. And that is from 16.7% to 24.5%. And this information is contained in the 2014 Standard of Living Conditions data. Madam Speaker, at this juncture, I would like to treat with the comment made by the Honourable Member for Couva North in respect to food cards. During the previous administration, food cards were distributed willy-nilly. There was no established process in place to distribute food cards. So instead of these cards reaching persons who could not afford to have a nutritional meal per day, which is the purpose for which it was intended, members of parliament were given 50 food cards and they were distributed. Madam Speaker, I suggest humbly that this may be one of the reasons why, despite all those funds being expended, the poverty rate has increased by 50% over time, because the benefits that are supposed to be passed on to the vulnerable in society may not have been properly targeted, and so would not have been reaching the people for which they were. Madam Speaker, this increase in the poverty rate is a cause for concern, especially since we are at the beginning of a period of recession, and the fallout can be expected to negatively impact the poor and may also expand the at-risk population. Trinidad and Tobago, having adopted the Sustainable Development Goals, is expected to work towards eradicating poverty in all its forms everywhere. The Ministry of Social Development and Family Services, through its poverty reduction and eradication units, has therefore placed top priority on our poverty reduction plans. In this regard, Madam Speaker, the Ministry will adopt a collaborative approach to combat poverty. We are currently partnering with the UNDP on this matter. We will improve our targeting and management of poverty reduction programs, address the broader socio-economic challenges that contribute to inequality and social exclusion, focus on prevention and early recovery in social programs, focus on the needs of the elderly, children, persons with disabilities and other vulnerable groups, and introduce developmental and remedial programs to prevent an increase in the numbers of working poor and reduce vulnerability and inequality. Madam Speaker, I am personally very optimistic that this government, working together with key stakeholders, can devise sustainable solutions that will address the root cause of poverty. In so doing, we will help to preserve and strengthen families and reduce the number of children that are at risk. This can only redound to the benefit of Trinidad and Tobago. Madam Speaker, I will now treat with another aspect of the bill, the human resources that will be required to ensure the effective and efficient functioning of the family court and the children court. Madam Speaker, it is noted that the bill proposes increases in both the number of judges and masters. While there are those who may question the practicality of the provisions of the bill, particularly as it relates to the availability of the required number of persons with the requisite knowledge, skills, and competencies, I am sure that there are currently suitable persons, either in Trinidad and Tobago or within the CARICOM region, who can fill these positions. Madam Speaker, I am particularly supportive of this aspect of the bill because it presents opportunities for career progression for a number of learned attorneys. Madam Speaker, we are aware that there are a number of graduates that are either underemployed or unemployed. This bill presents opportunities for some of those persons to be employed and also for those who currently function within the judicial system to be promoted. I do not expect, Madam Speaker, that all of the new positions could be filled with the caliber of staff required from the outset. There will certainly be need for training, coaching, and mentoring. Madam Speaker, in order to ensure that the courts are staffed with suitably qualified personnel with the appropriate temperament, there will be need for a robust recruitment and selection process inclusive of the application of a number of tools and tests, for example, psychometric testing or the use of assessment centers. The utilization of these tools, Madam Speaker, can improve the recruitment and selection processes and positively impact the end result. I am certain that the relevant Human Resource Management Unit and the Chief Justice will be so guided. Madam Speaker, as I have indicated previously, I am very supportive of the Family and Children Division Bill 2016. I am convinced that the Family and Children Courts will make a positive impact on this nation's children and families. This positive impact will be enhanced by the implementation of parenting programs and poverty reduction and eradication strategies and programs by the Ministry of Social Development and Family Services. Madam Speaker, I therefore envisage a better Trinidad and Tobago where our children are cared for and protected, our families are strong and intact, and poverty is substantially reduced. Madam Speaker, I thank you.
Member for Cumuto, Manzanilla.
Thank you, Madam Speaker. Madam Speaker, I just want to start off by saying that I would like to thank the government for proceeding with these important pieces of legislation to which the Member of Parliament for Princestown gave an extensive overview. We do support this bill, Madam Speaker, but we do support it going to the JSC first. It is important, and I'll explain during my course of discussion. Madam Speaker, just to come to the Honorable Minister for Social Development and Family Services, it is important, Madam Speaker, that when we are bringing legislation such as this, which is so important, that we have the support services in place in terms of food card, in terms of a baby grant, in terms of the assistance that we offer to children who are diagnosed with cerebral palsy, because they are vulnerable, Madam Speaker. And we had a pilot project, that is the People's Partnership, which we took for 1 year. A pilot project does not really normally go beyond that. It's 1 or 2 years. And the reason why we were unsure as to how much it would cost, the impact, and therefore we were following a guideline that came out of Chile, who has a program called a child care program. And the reason being is that, yes, Honorable Minister spoke about Proverbs 22, raising up a child. And when he grows old, he shall keep to his part because of the fact that it has been inculcated in him. But we cannot speak about something afterwards when we could start it from before by helping families in the way we have started. The Honorable Minister speaks about it came to an end. But we had provision for it. So much so, Madam Speaker, that even though the program came to an end in September, there are a number of single mothers who have not received their final tranche of monies that were owed to them. And even though requests have been made, to date they have not received it. And therefore, all these pieces of legislation must have the necessary support systems in place through the ministry. And earlier in the Honorable AG's contribution, he indicated that there was going to be a number of ministries that were going to be working together, one of which would have been the Ministry of Social Development and Family Services. But we cannot continue to speak about putting these services and working together when, in fact, a number of programs that we had before are still under review or have been cut. Madam Speaker, under the PP government, we did in fact give every member of parliament. No member of parliament was excluded. You know why? We believe in equity. We believe in equality. We believe in fairness. It doesn't matter that we did not win in any other seat, in any other part. We assisted the people of Trinidad and Tobago. And so there was equitable distribution with the food cards. And that was given to the members of parliament because the members of parliament were able to assist immediately with anyone who came into their office who needed assistance. And that is, do you know what it is? Do you know what it is, Madam Speaker, to be able to assist a hungry parent and a child immediately without having to say, well, I'm sorry, I can't help you. I don't have that in my pocket. No, we wanted to be able to allow the members of parliament to be able to recognize, because it's in their constituency, they would know, they have their field officers who would be able to say, yes, this is a family from a home that is going through a very rough time or whatever it is, and give them an offer, hope. That is what we do. We speak about proverbs, we speak about faith-based organizations, but that is what we do as Christians or whoever, Muslims, Hindus. We offer hope. If we can't offer hope, then what will we offer? We speak about the word, but the word of God says, what person, what father would, if the child came to them and asked for something to eat, would he give him a stone? Would he give him a snake? And if he who knows how to give good gifts, who is, we have to follow in that path of being able to assist our constituents. We have to do that. But if it is that we cut out services, we cut out the help, and everything is under review, then what is going to happen? Then the courts will be filled. And that is what we want to prevent. We want to be able to offer hope and not have a plaster on the sore. We want to be able to deal with the root of the problem. And the root of the problem, as we have already indicated from many members on the other side, have indicated low income, unemployment. I mean, VAT. We had I think it was the member for Couva North had indicated that, and when she read a report, that a parent held their child hand on a stove and burnt it. Why? Frustration. And this is what we allowed in the baby grant. The baby grant, you had to go through a parenting program so that you would understand that, first of all, if you cannot have children, you ought not to have them, if you cannot care for them. It also taught you to manage your finances, and at the same time, we allowed you to be on a program to assist you. So we didn't just speak it, we also provided some level of support. And the only reason that you would get the support is if you enrolled in the program, because we looked at the future. We didn't look at the situation. We didn't just try to deal with the cause. We dealt with the root. Because we too, and we need the courts, we need it because we have an issue now, but we don't want to be able to just have it at the back end, where it is we wait until the problem happens. We want to be able to resolve it. We want to be able to curb it. We want to be able to reduce it. And we also want to bring a level of hope to the population. And furthermore, Honorable Minister is speaking about working with the faith-based organizations and the NGOs. But when we recognize as a government, the PP government recognized we couldn't do it alone, and we assisted the faith-based organizations with funding. We were shut down. We were shut down. I don't know if you all remember that. They told us, no, we could not. It was wrong. We're trying to buy votes. But it was not, madam. It was not that, Madam Speaker, it was because we recognize that the faith-based organizations can assist. They can work there on the ground. We are not necessarily on the ground when we're in government. And so Minister of National Security spoke of a nexus. And there's a nexus. There's a nexus between the faith-based organizations and assisting families who are in need, the children who are in their areas who need help. And so I just want to remind the members and the honorable government that it was Ban Ki-moon who commended our Prime Minister for being the first in the world to have early childhood education. And universal early child. And you know why? Because we understood we can't wait until a problem happens. Because we all know it, we speak it. Prevention is better than cure. And so we were putting things in place to help raise the children, to help raise families, so that we will not reach to this point. We have to deal with whatever it is happening in our country now, but at the same time, we were looking at raising up children, raising up families, whole families, because whole and healthy families will translate into whole and healthy societies. And so I listened to the member, the Honorable National Security, Minister of National Security, who speaks about the importance of family. He speaks about the nexus between his ministry and that of the bill. And we are saying, Madam Speaker, we are not against the bill, you know. We are very supportive of the bill. But there are things about it that we here cannot make a decision on because of that same nexus. There are a lot of, Honorable AG had indicated, he said he had consultations. Who you had consultations with? Because when we spoke with a number of persons, they said no, they had no idea. I'll deal with that after. And so the Minister of National, going back to the Minister of National Security, had indicated that we brought this in 6 months. You all were there 5 years. And the reason being is that we did not just we didn't bring a bill hurriedly to this house because it's important. We had extensive consultations, and these consultations were with key stakeholders who are in the position to guide, to instruct, to inform, and to state whether or not this could work, that cannot work. That's an impossible task. You need to implement this level of infrastructure. And so it was important to have extensive consultations with those who know best. So saying that you brought a bill within 6 months does not say anything, because you're bringing something here to us to pass when you should be speaking also with key stakeholders to determine how feasible is this, how implementable is this. For instance, you speak about peer resolution. UNDP had a pilot project in Tobago in October 2015. Did you know that? Did you consult with them as to the report and to determine what were the strengths and the weaknesses of that pilot project? Were there any gaps that should be addressed? Were they a part of the consultation? And so these are the questions that we're asking. We are not saying no, we are against it. We're just asking for a JSC to look over these pieces of legislation so that we could go forward with it. No, there are a number. You have the prisons. You spoke about a number of ministries coming together. You spoke about marrying the efficacy of the various bills. Those were your words. Marrying them and making it into one. And so that, you know, you can make one move to take care in order to harmonize. And we believe in that. We don't want to keep back anything, but it must be done in a manner that will bring about the successes that we all hope to achieve. We don't want to pass resolutions, we don't want to pass legislation, we don't want to pass anything just vai. We want to be able to see successes in our society. That is what everyone is hoping for. Every single person. In addition to that, you speak about a number of legislation that will impact upon other acts. For instance, you speak about Yoda and asking Children's Authority to work alongside prisons. Were they consulted? Have they agreed? How will they work? What will they do? So for us to come and say this will happen, that will happen, there's no consultations as how it will work, how the process will be. You know, it is almost as though it is just rhetoric, and we don't want it to be that. We want it, if we are passing legislation, that we're in fact making things, putting things in place for a successful transition, a successful life coming out of the mess that they have found themselves in. And that is what we want. We want the same thing as you. And so we are asking about the programs that have been cut. We are asking about the programs that are still under review, because as long as you need to put these things forward, there must be a social system in place to support families. Families who may have lost their jobs. I mean, Madam Speaker, would you believe we had agreed to assist families who had lost their jobs with a fire that took place last year. And to date they have not received any assistance, although it was passed in cabinet. And so we don't want to be able to say that we are passing anything and there isn't any infrastructure, any process in place to support it. We must deal with the root cause. We must deal with the root cause. We must be a part of the process. I know, Madam Speaker, we had an interministerial committee that was mandated to find out the root cause of violence in schools, because we need to find out what causes the problem. We can't deal with what happened after the problem, but we have to deal with it before it becomes a problem. And so it's important for these pieces of legislation. We do agree. But again, the JSC will be able to go through it with a fine-tooth comb and to bring it to fruition with the necessary pieces of legislation accurately done and accurately in place. Member for Tobago East says that there are things that are fraught with complexities, and it is for this very purpose that we are asking for a JSC. Because as a committee, they, who will be comprised of key stakeholders, will be able to identify the strengths and the weaknesses in the package that is before us. They will be able to identify the gaps that may be in it. And so, Madam Speaker, just another point that I wanted to raise on was the proclamation. We just want to find out from the government if they can tell us when we can expect for this act to be proclaimed, to be proclaimed once passed. Is it going to be a partial proclamation? Would steps be required to prepare for the act for proclamation? What steps does the government expect to take to expedite the implementation of this very necessary act? What are the budgetary provisions made? Is it that the U.S. aid is providing monies? What is the value? Will you be required to put other processes in place? These are the things that I would like to know. And so, I will just wrap up, Madam Speaker, because I don't want to be too long, but just to advise why it is we are requesting that this 2016 bill be sent to a joint select committee. It is really and truly, you agreed already? Very good. Well then I thank you very much for taking it to the JSC. Thank you, Madam Speaker.
Attorney General.
Thank you, Madam Speaker. I wish to thank all members sincerely for their contributions this afternoon on this very important matter before us all. Madam Speaker, the opposition today has brought some contribution, in essence asking for a further degree of consultation. And notwithstanding the fact that we have a majority in this House, and notwithstanding some of the matters that I'll go over in a short while, the position of the government is indeed to move along with the Joint Select Committee approach. And we do so, Madam Speaker, really because it is important that we have the opportunity to agree collectively to very important legislation. It is very worthy to have a second look. I would like to caution, before I address some of the matters, that this Joint Select Committee will have a lot of work in a very short space of time, because there are some external factors that are really driving against any analysis paralysis. With that said, it is incumbent that I address at least a few of the matters put onto the record, and permit me to do so in as succinct a fashion as I can. The member for Princestown spent, I would say, three-quarters of his debate acknowledging the prowess, capability, charm, charisma, and worthiness of Kamla Prasad Bisesa, the member for Siparia.
The defeated leader.
I can take no complaint that he spent a lot of time doing that. That's his own choice as to how he exercises his enterprise. Apart from that, he raised the issue of consultation, which was shared by the last speaker, the Honourable Member for Cumuto, Manzanilla, and indeed the member for Naparima had some form of reflection on that. That was, as best as I could discern, the substantive contribution from the Honourable Member for Princestown. The Honourable Member for Naparima made some rather sharp comments, spent a great deal of time talking about life as it was back in 1999, 2000, and in the period 2010 to 2015. He said, you know, I hear this crosstalk again. I hope one day to hear from Couva South eventually on the floor, but I guess today is not the day. Yet again, we live in hope. One day. So, Madam Speaker, I heard the Honourable Member ask, he did some reflection. He said that he raised up the finances, the budgetary allocations. He waved around the position that there had been no increase in budget. He said that the St. Jude's and St. Michael's allocation had not moved. In fact, the Children's Authority budget had moved down. I wish to put onto the record that at the time at which the budget papers were laid and the debate was had, the Minister of Finance was pellucidly clear in saying that there would be a mid-year return, that there would be an adjustment to the budget for a number of factors, the very least of which was how close in proximity and how imprudent it was to have an election in September when the financial year ended on September 31st and the budget had to be read as it did. September 30th, quite right. And that we had until October 31st to pass the budget. Thank you, Honourable Member for Chaguanas East. That being said, the Honourable Member did hear by way of contribution from the government that far be it from an underspending, far be it from leaving the St. Jude's and St. Michael's homes, in fact, this government, by way of cabinet decision, specifically authorized expenditure on St. Jude's and St. Michael's as a matter of urgent priority to the tune of millions of dollars, and went further, as I certify today, in authorizing halfway homes, assessment centers, transition homes, 5 locations in Trinidad, so that there could be an anticipation for delivery of the entities which the bill must articulate, the law must articulate, so we can operationalize it. So we've gone by far past the post of just St. Michael's and St. Jude's budget allocation. In fact, we have gone into much broader factors. But I want to remind yet again, as my learned colleague has just said, we were driven not only to spend all of that money in capital works and expenditure. We were driven not only to do urgent repairs at the women's prisons, to cause the disaggregation of children from adults, a situation which lay festering for 5 years, but we had to spend millions of dollars in damages for constitutional claims brought by no less a person than my predecessor, Attorney General Anand Ram Logan, who proclaimed law onto a system that was not operationalized, creating an unconstitutionality.
Deliberate.
In fact,
Deliberately.
the comment was made in the courtroom itself when the advocacy was going on. Well, weren't you the person that proclaimed the law? How come you are here in the court doing this? But that's the standard we expect from some and another standard from others. It's the same standard which compels a member like Naparima to stand in this parliament and say Jamaica is laughing that Trinidad will no longer have free textbooks. What is he talking about, the honourable member?
Foolishness.
Is it VAT? Textbooks and grant.
Foolishness.
The Parliament of Trinidad and Tobago, the 11th Parliament as we sit now, heard from the Honourable Minister of Education that the textbooks that are delivered into the school systems are being paid for fully by the government. The workbooks are being paid for fully by the government. A task force has been appointed to look at the propriety of expenditure to achieve savings. The only thing that happened was an attention by this government to any issue of waste, mismanagement or corruption. And if Jamaica is laughing about that, I would be surprised. But it's the same thing.
The wheelman.
It's the same spinning of the wheel that causes the honourable member in other places to make some rather incredulous statements.
Lost his mind.
It's the same statements we hear brandished about by an opposition. As Tabakit said most recently, a supposedly responsible opposition that says you're taxing, you're putting VAT on textbooks. I had to stand right here on Tuesday and read out the fact that there's no VAT on textbooks, educational material, workbooks, etc. Now, Naparima said something. He said, facts are stubborn things. They won't go away. Quoting Ronald Reagan. I like to quote people right here in Trinidad and Tobago. And I would like to say the honourable member put out a challenge. He went back to the contributions of Ramesh Lawrence Maharaj, then as Attorney General in 1999. He said that the PNM, in his summary, had done nothing in relation to children's homes, adoption, children's act, etc. He said that they did nothing. It took Kamla Prasad Bisesa in the period 2010 to 2015 to do this work, and she brought it to life. And he said, I challenge them, essentially, to show me one area where I'm wrong.
No, sir, then the facts are wrong. Just ignore it.
So, Madam Speaker,
ignore it.
Fortunately for us, there's technology available in this Parliament.
Ignore the wheelman.
I went on my iPad to the Parliament website. I pulled up the Children's Authority Amendment Act. I pulled up the Children's Authority Amendment Act 2003. Children's Authority Amendment Act 2008, Children Community Residences and Foster Homes and Nurseries Amendment Act 2003, 2008 for the same bill, Children's Community Residences, Adoption of Children Amendment Act 2003, Family Court Act 2008. I have no idea how a member could stand up like that, throw down the gauntlet and challenge, and then say, prove me wrong. Because the honourable member has essentially said to us, show me.
What point of order?
No.
If it's on a point of order, you have to refer to the point of order. The only other way.
I just want to ask you, if the adoption of Children Bill 1999 was left languishing and it was proclaimed on 18th May 2015?
The answer to that is no. And I'll tell you why you're wrong. Because it was amended twice in between. And therefore, the validity of the 1999 Act, you see, Madam Speaker, I appreciate that honourable members might sometimes not understand, but you see, there's a large tail in between. Yes. Because the honourable member conveniently stepped past the position where there was no constitutional majority in the PNM and required the cooperation of the honourable members, now opposite. But not only was he wrong about the facts he put onto the record a while ago, but he left past the circumstances. You know, it's very much like the circumstances raised a short while ago in relation to the food card position. We heard from a most charming member opposite, a lady whose delivery is very delicate and compelling in her manner and approach. But she said, there's nothing wrong with members of parliament. We gave them all these food cards to give out. They would know who to give it out to. You see, perhaps we ascribe to different standards, honourable members. The position in the People's National Movement is that it is improper for ministers and members of parliament to be hand-delivering food cards to people, where we create the impression that we are those upon high with manna from heaven coming to save people's lives, when the gratitude is to be paid to the system. We don't want anybody grateful to the member of parliament. We want the people to deal with the propriety of the system, because the member for San Fernando West doesn't pay for a food card. The government of people on Trinidad and Tobago pay for that. And that is why, Madam Speaker, we took in our distribution of food cards the opportunity to mobilize the requisite ministry, have it mobilized to give out the food cards so that people would be grateful to the public service for acting the way it should. That takes you away from allegations of food card via trunk delivery service. So, Madam Speaker, it's important that we remember that there's propriety. I heard Princess Town, I don't know what possessed him to bring baby Miracle into this debate. I've been very careful as Attorney General, even though I have evidence in my hands. I have information like 5 lawyers getting $45 million, 1 lawyer $90 million. I haven't called a name once in this parliament. But yet, I hear the tragedy unfold today of calling a baby's name and saying San Fernando West did nothing about it. And the fact is, Madam Speaker, the Minister of Health today spoke to the application going into the Children's Life Fund. I met with the parents. I recommended the application forward. It went in. 6 institutions were approached. 5 of them declined to do the surgery. The 6th one agreed to do it, scheduled the date, and the poor blessed child passed away. What can a member of parliament do beyond that? But that's again the contextual reality divorced from the reality of life as it prevails when truth is spoken, Madam Speaker. Macbeth and theatrics and drama and hands waving. I don't know what that has to do with this. We heard the honourable members opposite talk about carbon copy of a bill. Oh, you did nothing. Absolutely nothing. This is a carbon copy of the bill. It's our bill. We are here. We have paternity over the bill. But hold on. We don't agree with the contents. We need a joint select committee. We need time to study it.
But it's their bill.
It's their bill. They're claiming paternity. You did nothing for 6 months. But I need time to consider it now. We heard them talk about, oh, the AG says he's coming with a legislative agenda. You know, they forget that when I made a promise and an undertaking which will be kept to bring a legislative agenda, it being the first time in 6 years that a legislative agenda will be published, they have the audacity, the temerity to be suggesting that keeping your word to do something which they would not do is something by way of victory on their part. God forbid that there's logic to be discerned in that. Madam Speaker, for the record, the bill that was brought by the last government in May 2015 numbered 38 pages. The consequential amendments were across exactly 2 pages in double point, double space typing. They amended the Supreme Court of Judicature Act to change from 36 judges to 49. They changed the word judge. They removed judge in chambers. They amended the Probation Act. They put in 1 clause. They amended the Children's Act. In the definition section, they removed the word juvenile. They dealt with the child in need of supervision. They removed the word the. They substituted the word a. They deleted section 61. They made 3 lines amendment. That's it. The carbon copy version that they say we brought today is 95 pages long. And the schedule of amendments crosses not 3 pieces of law, but 18 pieces of law, and deals with over 40-something pages of amendments. Now I could understand if you had said, well, look, significant amendments were made, we need time to consider that. But to approbate and reprobate at the same time is the nonsense, most respectfully, that I'm speaking about. It's nonsensical to say it's the same thing, you did no work, and I need time to study it, if you won't recognize the truth in the equation. Madam Speaker, it was for that reason that more than 2 weeks ago, we sent out the information. I personally went to Siparia and gave her a printed off hard copy version of the track change amendments and the bill. I explained to her what they were. I said I will send it to all of your members. I've instructed the Parliament to put all the track change versions to show you the 18 pieces of law that were amended. I'm willing to answer any question you have. Princestown stands up today. Naparima stands up today and says they had no consultation. In my 5 years in the Senate, I didn't have one occasion like I just expressed to you. Not one. True. And in passing the Children's Bill 2012, I participated with great vigor and supported the government right through in circumstances when, Naparima, let me correct you here through you, Madam Speaker, when the Children's Act needed to be supported. When the UNC was piloting it, the PNM made sure we supported it. And every single independent senator said no. But they didn't do that when it was their turn. No, but I'm correcting your positions about what was done in the period prior to 2010. That's what I'm addressing. And Madam Speaker, most respectfully, the Honourable Member has asked Naparima and the Honourable Member for Cumuto, Manzanilla, they say, where is the money coming from? They said, you, as Senator Al-Rawi, had certain things to say. You, as Senator Young, had certain things to say. I'm paraphrasing. They said, why would you deal with maximum and minimums? Where are you getting the millions of dollars from? Well, I'll tell you. It's coming from the US aid fund. It's coming from the government of Trinidad and Tobago having publicly stated that we will give the judiciary financial autonomy for the first time ever, as we have said. It has come by way of budgetary support way over the preliminary figures put in the budget as it was debated when we passed the appropriation bill this year. And so, Madam Speaker, that's an important point to note. Very importantly, Cumuto Manzanilla asked, what consultation was there? She said, quite interestingly, she wanted to know, the honourable member wanted to know, whether there was consultation with the prisons. She wanted to know if we knew about the pilot project and were there consultations on the pilot project. I'd like to tell the honourable member, this is the consultation report on the pilot project. And there was consultation on it. I'd like to tell the honourable members when they both spoke about the task force. The task force met in a period which was a very short period of time. I'd like to put it onto the record. The Child Protection Task Force met 15 times in the period December 6, 2013 to July 3, 2014. They issued a third report and ended their tenure on the 31st of July 2014. Last time I checked, the election was in 2015. You must have known, honourable members opposite, as you raised the point, that the task force ended in your term a year prior to the election and more. But sincere people opposite stand up today and don't seem to even know what happened under their watch. You know, when we come to approach matters like this, it's one thing to say, well, look, I have a problem with X in the clause or the enabling environment around it, etc. But to come and make irresponsible statements where you demonstrate most respectfully a fundamental lack of knowledge of what you did as a government yourself is really a dereliction of duty. That's the fact. Naparima says, talk, boy. Well, I don't want to spin no wheel. I can tell you that. Hey, honourable members, Madam Speaker, talking about give people hope. That's why you need to get them food cards. I distinctly remember the member for Oropuch East telling people 100 homes a week, thousands to be built. I remember going up to a site where he said there were 1,000 homes. Not a blade of grass disturbed.
Not a stone unturned.
Not a stone unturned. Bush everywhere. People lining up for the hope outside HTC for the same 1,000 homes that he was talking about. UNC style hope is not the kind of hope that we hope to offer to the people of Trinidad and Tobago. Most respectfully. Madam Speaker, Las Alturas Hope, again, coming from where? Couva South. 6 years in the Parliament nearly. Not a word as Minister in the Ministry of Finance. Nothing. I mean, I find it incredulous to listen to the kind of old talk. And listen, it's not polite old talk, it's loud old talk, Loud to do as if it's nearly a contribution on the floor. The honourable member has the right to speak in this Parliament under Section 55 of the Constitution, and I pray that one day he will actually do it. Madam Speaker, Madam Speaker, we heard the position about consultation. I just want to put onto the record that there was consultation, and a very widespread consultation, coming through the Honourable Chief Justice, judges, magistrates, registrars, family court staff, social worker representatives, Ministry of the Attorney General, Ministry of National Security, Law Association, police, prison, probation, the criminal bar, DPP, Solicitor General, legal aid advice and authority, children's authority, private bar, children's authority, judicial officers, representatives, PTA, Ministry of Education, Ministry of the Attorney General, youth development specialists, religious leaders. And I just heard somebody say that again, but she didn't say the same thing when Cumuto Manzanilla was asking who you consult. One member hears it, Couva North. The other member doesn't seem to hear it, so I have to repeat it. Put it onto the record. Madam Speaker, the task force committees that sat on this, I can tell you, worked assiduously for 6 months. We took the opportunity. I heard Naparima say, and then I saw Princestown nearly fall off his chair, you didn't bring a comprehensive bill. When 18 consequential laws are being amended at the same time. That was what I found amazing, to watch the body language between Princestown and Naparima when Naparima says you didn't. When Naparima says you didn't bring a comprehensive piece of law, Madam Speaker. Madam Speaker, my learned colleagues on my bench are right. My learned colleagues on my bench are right. I need to focus on the fact that we mustn't assume that there's consultation across the benches or with the bench-to-bench relationship. But Madam Speaker, all that I wish to say is that the good team headed by Master Christian Morris Allen, members of the Children's Authority, the DPP's office, the hard-working drafts people, all of the ancillary services, they worked up to 16 hours a day. On weekends, on birthdays, day and night, doing the work of the people. Long story short now, Madam Speaker, what are we to do? The long story short is that we will agree, as we now say again in winding up, to the Joint Select Committee approach, a committee of this House of Representatives and one from the Senate. I would honestly appreciate if the honourable members could consider that the report must be returned by April 29th so that we can purchase the reward of the international funding that the judiciary has put in place for us. I look forward to contributions in that committee. I know that the process is that I would beg to move and then seek your permission, Madam Speaker, to actually refer this to a joint select committee. So permit me, Madam Speaker, firstly to thank you and honourable members for a very interesting and lively debate. Secondly, Madam Speaker, I wish to end this debate by begging to move that this particular bill be referred, and permit me if I get this wrong, I will simply beg to move at this point and then rejoin you at the point of asking for the standing orders to be applied. I beg to move, Madam Speaker.
Honourable members, the question is that a bill entitled An Act to Make Jurisdiction for All Family Matters and Children Matters exercisable in a division of the High Court to be called the Family and Children Division and to make provision for matters connected therewith be now read a second time. All in favour say aye. Aye. Any against? The ayes have it. The Attorney General.
Entitled An Act to Make Jurisdiction for All Family Matters and Children Matters exercisable in a division of the High Court to be called the Family and Children Division and to make provision for matters connected therewith.
The Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, in accordance with Standing Order 15.5, I beg to move that the House continue to sit until the conclusion of the matters before it this evening.
Honourable members, the question is that the House continue to sit until the conclusion of the matters before it. Those in favour say aye. Aye. Any against? I think the ayes have it. The Attorney General.
Thank you, Madam Speaker. Madam Speaker, as provided by Standing Order 68.1, I beg to move that a bill entitled an act to make jurisdiction for all family matters and children matters exercisable in a division of the High Court to be called the Family and Children Division, and to make provision for matters connected therewith, be committed to a joint select committee established for its consideration and reported by April 29th, 2016.
Honourable members, the question is that a bill entitled An Act to Make Jurisdiction for All Family Matters and Children Matters exercisable in a division of the High Court to be called the Family and Children Division, and to make provision for matters connected therewith, be committed to a joint select committee established for its consideration and report by April 29th, 2016. All in favor say aye. Aye. Any against? I guess the ayes have it.
Madam Speaker, Madam Speaker, I beg to move that the Joint Select Committee comprise the following representatives from the House of Representatives, to be matched by an equal number from the Senate. Madam Speaker, the names for the government's bench would be Faris Al-Rawi, Member of Parliament for San Fernando West, Mr. Randall Mitchell, Member of Parliament for San Fernando East, Ms. Ayanna Webster-Roy, Honourable Member for Tobago East, the Honourable Member Ramona Ramdial, MP for Couva North, the Honourable Mr. Barry Padarath, Honourable Member for Princestown Proper. I beg to move, Madam Speaker.
Honourable members, the question is that the Joint Select Committee comprising equal members of the House and of the Senate be comprised of the following members of the House of Representatives. Honourable Member Faris Al-Rawi, Member for San Fernando West. Honourable Member Randall Mitchell, Member of Parliament for San Fernando East. Honourable Ayanna Webster-Roy, Member of Parliament for Tobago East. Honourable Member Ramona Ramdial, Member of Parliament for Couva North. And Honourable Member Barry Padarath, Member of Parliament for Princestown. And an equal number from the Senate. All in favour say aye. Aye. Any against? I guess the ayes have it.
Madam Speaker, I beg to move that this House do now adjourn to Friday, the 18th of March 2016 at 1:30 p.m.
What will we be dealing with then?
We'll be dealing with we'll be dealing with the Strategic Services Agency Amendment Bill 2016, and we will also deal with the Draft Elections and Boundaries Commission, Local Government and Tobago House of Assembly Order 2016.
And everything else in Europe.
Honourable members, there is one matter that qualifies to be raised on the motion for the adjournment of the House filed by the member for Tabaquit. I will now call upon the member for Tabaquit. Member for Tabaquit.
Thank you. Thank you, Madam Speaker, and thank you for allowing this motion. Madam Speaker, this matter relates to the Flanagan Town RC School. Madam Speaker, dilapidated schools do not provide a proper teaching and learning environment, one that is conducive to the proper education of a child, and as well for teachers being able to give of their best. And while throughout the country we have been witnessing protests by children and parents about the condition of their schools, in my constituency of Tabaquit, the parents and the community as a whole, teachers and members of also the religious group, they're very concerned about the state of construction of the Flanagan RC School. My honourable colleague from the other side, the Minister of Education, Member of Parliament from Manzanilla, will agree that governments are responsible for ensuring that the physical environment of a school is enhanced for teaching and learning. Madam Speaker, after 3 years of representation between 2010 and 2013, that is on behalf of the Flanagan community, Flanagan Town community. A new school was approved, and a contract for the construction of that school was awarded. And in fact, in 2014, work began on that school in Flanagan, for which I owe a debt of gratitude to the former Minister of Education. Since that time, there has been what I like to call start and stop of the project. And this has created a great level of anxiety for the community, because the project is now about 1 year behind schedule. 1 year behind schedule. Madam Speaker, there are about 70 to 75 children who are involved in this school. And it will pain you to know that they have never had a school for the children there. In fact, since the 1930s, the children have been housed in the church. So that if you go down to Flanagan Town and you see the dilapidated condition of the church, you'll understand the environment in which the children go to school. So I'm talking about 85 years that the children of that community have been going to school there. You know, and there's one gentleman there by the name of Mr. Vasant. He's an old man now, in his late 70s. He was given all his life to the children in that area and to the PTA and to the community. And, you know, I put his name on the record because his greatest desire... Yes, Vasanganis, yes. Before he you know, it's his desire before he leaves this world to really see that school come to fruition. That has been that man's desire, believe it or not. He's living to see that. And I want to put on record our appreciation for the manner in which he has served that community and the children. The school was shut down, as I said. Yes, he's quite a community person, yes. And his wife and family also. Madam Speaker, I'm not going to ask for your protection.
Member, I am sure with your experience, if you direct your attention here, you won't be distracted. I mean, it is your time, and therefore I think, having regard to the passion you feel for this motion, I would ask you not to be distracted and direct your attention here, please. Thanks.
You know, there's an old saying, empty vessels make the most noise. So that is what we're saying there. Madam Speaker, the school is virtually stopped now, although 90% of the foundation is complete. But I got a letter only 2 weeks ago from the chairman of the Couva Tabaki Talpa Regional Corporation, Councillor Henry Awang, who is also the councillor for the particular area. And he too has visited this project, and we both came up with some of the things that exist in that church environment that, you know, is so disheartening. The blackboards that the children are using now are filled with holes, and they have to keep filling these holes with stuff so they could use the blackboards. There are some of the blackboards that are being propped up. There are some of the blackboards which have fallen on persons, according to what we have been told. And the benches on which the children are sitting are termite infested. Termite infested. And they are very unstable. They are creaky, they can fall anytime. And the most important for me is that the standard 5 class is cramped. Very little space. So 85 years they have suffered. And they have, you know, they have learned and they have sacrificed. But I think, Madam Speaker, it is time that we do something about this. And today in this Parliament, I rise on behalf of the people of Flanagan Town, the parents, and particularly the children. The only other school that exists close to that is in Brazo Venado. And you have to go through a place called Los Atajo. And way up into Brazo Venado, that's where the weather station is. But they can only 45 students. Well, they have to travel down there to Caparo on the other side to go to Tabakit. But the member for La Hoquita Talparo is trying to say that maybe they don't need the school in Flanagan Town. Yeah, don't need the school. Deal with your constituency and I'll deal with mine. That's why I'm there. I'm there to deal with it, Madam Speaker. And I'm dealing with it. And if every week I have to bring a motion here and motions on the adjournment to deal with matters in the constituency, I will deal with it. Madam Speaker, thank you very much.
The Minister of Education.
Thank you very much, Madam Speaker. And thank you for giving me the opportunity to respond to the member for Tabakit in his motion regarding the Flanagan Town RC School, as it affords me now the opportunity to lay bare the truth where this matter is concerned.
Yeah, man. Yeah, man.
Madam Speaker, just let me respond very quickly to a statement made by the honourable member for Tabakit, in which he lamented the fact that the school was in a parlous condition, the blackboards had deteriorated, and the benches were termite infected. Madam Speaker, the simple answer to this question is, what occurred over the last 5 years when the member of Tabakit was in office? I am sure, Madam Speaker, that this deterioration of this school did not occur over the last 6 months. Those on the other side had every opportunity to correct the faults that have been identified by the member for Tabakit. And they failed. Yes, they failed. Madam Chairman. Madam Chairman.
The Tiffin. Digo Martin notice.
Honorable members. Honorable members. Honorable members, I would like everyone to observe the proper decorum, to refrain from unparliamentary language. I therefore call on the Minister of Education, to continue his contribution.
Thank you very much, Madam Speaker. The Flanagan Town RC Primary School is a school that is owned by the Catholic Education Board of Management. It was established in 1933, and as the member for Tabakit stated, it is now 83 years old. The school currently has an enrollment of 52 students and an academic staff that comprises the principal and the 6 teachers. Construction of the school building began sometime after the signing of an agreement on May the 4th, 2014, between the Education Facilities Company Limited, representing the Ministry of Education, and the contractor for the project, D. Mahadio and Sons Limited. Madam Speaker, it is our clear understanding that following the initial site clearance and the site preparation, work at the construction site came to a halt, since the designs produced by EFCL were inconsistent with the policy of the Catholic Education Board of Management. Such designs must be signed off by a registered engineer before the Catholic Board can give consent. And this is what started the delay. The designs produced by EFCL were not acceptable to the Catholic Board of Management. A major problem, Madam Speaker, was the fact that the EFCL design completely blocked access to the church. And it was only when changes to the designs were made, the board agreed to the continuation of the project. However, the contractor suspended work on the project in December 2015 due to outstanding payments. I wish to point out, Madam Speaker, that at the time of suspension of work, the project was approximately 21% completed. The items up to that time included the following: clearance and the preparation of the project site, fencing of the project site, architectural designs, which were 90% complete, foundation works, 30% complete, and washroom block that was 100% complete. Madam Speaker, it is no secret that the Ministry of Education, like many other ministries, has been experiencing difficulties in effecting payments to contractors, and this has been due to declining government revenues associated with the ongoing fall in oil and gas prices globally. However, Madam Speaker, I wish to assure the member for Tabaquit, residents of Flanagan Town, and by extension, the national community, that notwithstanding the cash flow difficulties being experienced by this government and by the Ministry of Education, the ministry remains committed to completing construction of the Flanagan Town RC School. We remain committed to the completion of this school. As such, I want to assure that every effort will be made to collaborate with the Ministry of Finance to identify the required funding that will enable a resumption of construction and eventual completion of this school. As was stated before, it is the policy of this government to replace all outdated and old and dilapidated schools with new modern buildings and facilities, and construct new schools in areas where they are most needed. I thank you.
Honorable members, the question is that this House do now adjourn to Friday, 18 March 2016 at 1:30 p.m. All in favor say aye. Aye. Any against? The ayes have it. This House now stands adjourned to Friday, 18 March 2015 at 1:30 p.m.